Hey guys, good morning. We have day 10 here of the George Pino trial. The evidence is closed. All parties have rested. State was done with their rebuttal. And over the weekend, the parties were working on jury instructions. Not sure how that panned out. There were some changes to Florida's pattern jury instructions by statute on June 12th. Kind of threw a wrench in the middle of things. So if you're interested in reading those filings, I did link them in the description, and I'm sure Defense Diaries mods will drop them for you guys watching with Defense Diaries. And it looks like there was a little bit of discussion this morning before the court went on to a break. So we're going to get caught up with that break and have some skip time. And as you guys know, we are collaborating. It's myself here at Katt Williams and Defense Diaries. So do not be fooled by Ali's name tag. It says Bob today. But this is Ali, of course. And yeah, I mean, what was your takeaway watching that jury charge conference, Ali? How do you feel going into today?
I don't know. I don't have a lot of faith in the judge. I think the jury is going to be confused. But maybe she came back and did think about some other things. So I don't know.
And the chat is happy for closing arguments. Remember, guys, it'll be the state first, then the defense, and then a rebuttal, which I'm sure the state is going to utilize. I'm sure they'll want to get the last word. So that will probably be the structure that we see. And even though this judge does not do time limits, I believe both parties said they didn't think that it would be too long, and that they wanted to do states and defense, like their first opening, lunch, and then the state's rebuttal when they come back from lunch. But maybe since they're starting late, maybe they'll change that scheduling. So yeah, Bob's hair got really long. As you guys know, the chat, it's been kind of balls with this trial because the court administrative order requires that no live chat feature is live while we're sharing the court feed. So in a few minutes here, we're going to be shutting off the chat, but we bring it back when we go on breaks. Also, Brooklyn, thank you you've been a member before, but YouTube's not saying your months. I think you've been a member for like 20 months. So big thank you for so much support. Also, Sheriff Chuck gifting 5 over here at Katt Williams. So if you just got green, make sure you say thank you to Sheriff Chuck. Also, I'm seeing...
Bob's.
Is that Bob's chair?
Yeah.
Oh, my goodness. Big thank you to Sheriff Chuck. I'm also hearing that our audio might be low. Ali, can you say something?
It could be me. I can't even tell if his mic is on. Oh, it is on.
It's weird because usually when it's Bob, he comes in loud on that mic. So turn both of us up a little.
Let me see what his is set to. Yeah, he's still at like 67.
Oops, I had an old banner. Sorry, guys. I forgot that you have to do it twice for it to refresh sometimes on StreamYard. Also, all right, everyone says we sound good. All right, that is awesome. Or I'm low compared to Ali. I did just put myself up, though. So with that being said, guys, Ali, anything before we get into it? We're going to talk about some of the requests that came in on the docket, but we're going to wait and see if that's discussed this morning before we talk about it. And
yeah, no, I'm good then. Oh, wait, I've got to press the buttons.
All right. And you've also got Nurse Mandy over on Defense Diaries, a member for 3 months, says, I love this duo. Well, that's awesome. I'm glad. Awesome being a member for 3 months over on Defense Diaries.
Yes.
So, guys,
thank you for your continued support. All right, wait.
This is that time. We've got to.
All right, I'm ready.
We've got to shut you off. All right. Goodbye, guys.
Bye,
See you soon. All right. Mine is saved.
Mine too. Can't even find now. Oh, there you are.
All right. So this is queued up to where they came in this morning. We skipped the dead air. And let's see what happens. Sounds lovely.
All right, good morning, everyone. State of Florida versus George Pino. Parties and answers, please. Good morning, Honor. We're at this time. Good
morning, Honor. On behalf of George Pino, who's present, Howard Srebnick, Edward Molina, Mark Shapiro, who's General Gomez will be here in a moment.
All right, very well. Come on.
Good morning, Honor. I do. Thank you.
All right, very well. The jury should be here shortly. Just want to take up and I'm going to address the kind of instructions that were, although we had our charge conference last week, there were additional meetings and discussions via email that the parties have had with the court. A few additional pleadings filed that I would like to address. And again, I believe we addressed them during the course of the charge conference, but for purposes of the record, I'd like to go over some of these, especially during instruction requests. So, defense filed yesterday objections to the June 12, 2026 amendments to the standard jury instructions on manslaughter, and my understanding of this is for the culpable negligence instruction as the misdemeanor under the standard jury instruction 8.9. There was some modification of the language of 8.9, and this modification in the amendment actually now mirrors the language of the felony culpable negligence jury instruction, of which
That's confusing.
you had last week in the charge conference, requested this court to include additional language in the standard of the felony. You requested that the language of the misdemeanor culpable negligence instruction be included.
Correct.
Okay. So, I would ask the state if they had any comments on it. I mean, I've read the pleadings, I understand the issue and the argument and the basis of the argument that you're making. And again, it was something we addressed, but, excuse me. It was something that we did address. So, let me just ask Ms. Adams, and Mr. Boris, was there anything that you wanted to comment on with regard to, it was the defense request for the, I guess, pre-amendment language of the misdemeanor jury instruction under 8.9 to incorporate that into the standard manslaughter instruction 7.7. All right, sorry, Ms. Adams.
I understand the defense request. I think that we litigated this on Thursday. I think the court has already ruled. I think that the instruction in manslaughter regarding what culpable negligence is appropriate. I think, Your Honor, I haven't had much time to look at the instructions, the final ones that we got from Your Honor.
They didn't
But in
litigate until
reviewing
the end about the changes, though.
the instruction that the court gives on page 8 of the packet, like when the court defines culpable negligence, I think that it is an accurate statement of the law, and I see no reason to import a misdemeanor into a felony homicide charge.
And I think that was, if we kind of break it down and try to simplify it, if we can simplify it, I think that that was the intention of the defense, and I want to speak, to have the definition of the culpable negligence for the misdemeanor added, that language added to. Am I right about that?
Correct, as well as other
There were other
propositions of law that we had proposed in the case law, but yes, you're correct.
Okay, so, having reviewed this again, and I did a little additional research, and I am comfortable that the instructions as it exists currently under 7.7, as the current standard instructions for manslaughter 782.7, they are appropriate without the inclusion, because there's a separate, again, jury instruction. 8.9 is the separate jury instruction for misdemeanor culpable negligence in misdemeanor sense. So, which would be a charge under 784.05, which would be the culpable negligence, but as a misdemeanor charge, not a felony charge. So for those reasons, I am not going to, and I understand also, we'll get to this when we talk about the reasonable doubt, because everyone I think is agreed on that, but I am going to decline to include additional language to extend the instruction, the former definition of culpable negligence as a misdemeanor. So, for the record though, your objections and your amendment and the requested special instruction is part of the record. So that is, we decline to do that. And then there was the, and I think this goes again to discussions we had last Thursday during the charge conference on the two different theories under manslaughter for where the jury could come back under either the intentionally committing an act or acts that led to, that caused the death of Lucy Fernandez, or and the death of Lucy Fernandez was caused by the culpable negligence of Ms. P. Okay? So, and I heard all the argument, and I understand the defense position is you submit that the intentional act under that theory is actually the striking of the marker. And I don't know, I think the state has responded on that. I didn't do that. I don't agree, after I've read additional case law, I don't believe that that is the intentional act. So I was declining to give any additional instruction in that regard. And then you also had requested, though, I see here, to, so that was there anything else on the, under 2A?
Yes.
Okay.
So the anomaly that this creates is that intentional is an act that assumes that the operator is intending to essentially crash. That's what it has to be that, otherwise there's no causation to the between the act and the death. And the alternative theory of culpable negligence is assuming just a course of conduct so irresponsible it leads to a collision that was not intended. The state has, from the beginning of this case, said in their traverse, they take the position that they have no reason to believe Mr. Pino intended to crash. So what we're left with is two theories that the state is going to the jury with. One that just start with culpable negligence, let's just call it irresponsible, indifferent, conscious, all sorts of negligence.
Culpable negligence.
Without intent. It's not an intent crime. On the other hand, with 2A, what is the act? I would just ask the court, the jury needs to know what's the act they're looking for.
And if you read the case law, my interpretation of the case law, it's the act, and it's defined here. It's not necessary that the state prove that the defendant intended to cause death, but to commit an act that was not merely negligent, justifiable, or excusable, which caused death. For example, let me give you an example of the case that I read. The vehicular vehicle case, where there was a death. And the theory was under an intentional act. Driver and passenger. Driver and passenger get into a dispute while driver is driving. And passenger reaches for and jerks the wheel of the vehicle. And
so you notice how she's relying on case law here, but doesn't understand why the defense has to rely on case law to clarify?
Which then ultimately results in the car veering off and hitting a tree and killing the driver of the vehicle. Okay? But my point is the act under those circumstances, and again, this is my interpretation of reading the cases as to why there are two theories under the manslaughter. The act was the grabbing of the wheel.
But that was an intentional act to get the passenger.
So that's the way I'm interpreting. And I didn't ask for the state to, we had responses on Thursday, and the state made the responses, but I went back and I did a little more work on that. over the weekend. So while I absolutely understand your position on 2A, intentional act, that it creates an odd situation. And it could never be.
It's confusing.
But that's why there are the higher crimes when a death occurs of second-degree murder and first degree murder. So that's my understanding. And your argument?
And it sounds like by analogy they were suggesting that the intentional act clause 2A is.
I'm not suggesting anything. I'm just giving you my interpretation of why there are two theories as charged by the state here, and two theories under which whether or not the state can sustain their verdict under either theory of manslaughter is a whole different thing.
So for example, in our case, the intentional act, if you do it broadly, operating the motor vessel, just broadly. So Pino intended to drive or operate the motor vessel. That's so broad that the argument is that he intended to drive the motor vessel, and that eventually led to a.
I'm not sure I agree with that.
How is it any different?
I'm not sure I agree with the example you're giving. I don't want to, what I am not going to do is, I'm not the jury.
To clarify,
And yourself,
so
in the closing arguments, to explain to the jury what you believe the evidence was, and how the jury could apply the law,
that's your job.
or not apply the law, or even applying the law, the evidence either reaches the element of proof necessary beyond reasonable doubt, or it does not. And
That would be the
they
burden.
argue how it does, and you're going to argue, sure, how it doesn't. So I'm going to leave it at that.
I think it creates a notice problem for us in terms of what was the act we were defending against.
Yes.
We always assume the act is the elision. Under that part, that the state was, if it's in the charging document, there's two theories. Either he intended to crash, meaning you can see the example where people bump up against the pylon intentionally, too fast, someone gets hurt, and if it's done intentionally, not merely negligently, then there may be liability. On the other hand, driving not intended to intersect or alight at the marker, but happens to do so because of an erratic driving pattern, that would be another theory, which is the theory we've been defending against since the beginning of this case, because the state had made it clear, particularly in its reverse, they're not claiming he intended to alight with the marker. So that's what's giving us the concern. We submit that 2A, manslaughter, should be stricken.
Excise that.
And I think we preserve that issue, and I'll reinforce it. And then I'll be listening carefully to what the state argues in closing, and be mindful of what Your Honor has said to us about the case law, about the passenger grabbing the wheel, turning it, and that causes the.
Again, when I read the cases on the different means by which, in a criminal case, elements of either the intentional act from 2A or 2C, the type of evidence, every case is different, right, factually. So that was my interpretation. Okay. Let's get to, I think, the final.
Just before we leave that, to make sure you receive our pleading proposing the instruction.
Yes, I'm going to talk about that.
And we filed it, so
Right.
where we propose the instruction on manslaughter 2A.
I see that, and in that proposal as well, you also, then there was an additional pleading where you asked for, under the vessel homicide instruction, you asked that the court provide the jury with an additional special instruction as a vessel homicide, which were case examples with citations to the case with the factual summaries of the cases.
Yes, sir. It was both for vessel homicide and for the manslaughter.
Yeah, vessel homicide, you had about 12 examples, I think.
You made it 13.
13, there you go. And for the manslaughter, you had, which were the cases that were presented, and we addressed earlier on as well.
In the motion dismissed.
Yes. So I am not going to instruct the jury with case law or summaries of case law.
I've never seen that
Factual
before
summaries of
anyway.
different cases. But again, this is part of pleadings and part of the record. The other matter, and I think we've all agreed on, the navigational rule instruction. If you look at, I gave you all what I call the final instructions. If you look, I did, and thank you for pointing it out, during the charge conference, I agreed that the additional language of individually or cumulatively would be included. And if you look, and I think it's included in the correct place where I had agreed that I was.
Yes, sir. I see it at page 10 of the paper copies that were delivered to us.
You better revisit that lesser instruction, lesser
Okay, so that's good.
offense.
On defendant's statement or statements, because there were various statements, and when the jury is given the opportunity, and as they should, to determine whether or not statements are voluntary, I just included the word statements, and then I put in parentheses S when I said the word statement in the rest of the instruction. Look at it, I just
Do you want to page over that?
let's see. Page 18. Thank you. Starting on 18. Yeah, it's just one of the pages. So the first sentence, if you read, I said statement or statements. And then from thereafter, I just put the parentheses S. So, because again, there are separate statements, and the jury should be instructed, each statement has to be considered, each statement has to be considered individuals.
You see it was fine.
Okay. The only other matter was the reasonable doubt instruction. And we talked about, and I had initially indicated that I was going to instruct with the amended instruction, June 12th, which was then amended again. And
Why it's doing that?
what I am going to do actually is instruct the jury on reasonable doubt as the instruction existed in the standard prior to June 12th.
Okay, so
At
this is
start
the
of
old
case
one.
when the jury
Thank
was
God.
sworn, which was June 5th, I think.
It was
No, I
sort of
didn't start the jury
like-
until the 8th, but everyone was in agreement with that. I think I didn't hear any objections to that.
So, that's right, we asked for the original
Right.
instruction supplemented by the U.S. Court of Appeals for the 11th Circuit's language. that-
And in that regard, I am not including the additional language of the 11th Circuit Federal Standards instruction, but it's going to be the reasonable doubt Florida Standard Jury Instructions pre-June 12th.
I think that covers it.
I think we covered everything on the instructions. If you see anything in the packet,
Well, that was when?
sometimes you look at things over
Yeah,
and
and
over
we'll
and
go
over
over
again,
that.
and you miss something. So fresh eyes, if you see something that is incorrect, would you please just make a note of it, and I'll make those corrections during the course of the morning. So, Renee, how are we doing with jury? Okay, can you go up and check them out, please? Because I think we're just about there, right?
Okay.
I just left my water bottle with my shoes in
I
my
can actually, please don't stand up. May I see the written order with the attorneys at the sidebar for a moment? Thank you.
Okay, we'll skip that. Yeah, so one small thing, one big thing granted for the defense there, that she will use the prior version of the pattern instruction for reasonable doubt, which Florida just updated on June 12th. To me, the new language is vague and confusing. When we have a longer break, unless you want to go over that now, Ali, we'll look at the difference quick, or we can do it on
I mean, we
lunch.
could save it on lunch.
Yeah. Should come back like right here.
Thank you. We're working sidebar. We need to communicate with the lawyers there. Thank you, everybody, for your patience. And I'm also stalling because I'm waiting to hear from Renee whether the jurors have all arrived and are ready to be brought in. And they have not. So I'm waiting for the jurors. And while we are waiting, I'm going to ask if anyone is in the courtroom who is an intern, not either a close friend or family member, I'm going to ask you please to vacate this courtroom. We have an overflow courtroom in 4-6. So please go over to 4-6 so that we can make space here because I can't have anyone standing in the courtroom. So if you are not a close family friend or member of the family, you're going to need to please vacate your seats. Thank you so much. And then everyone else can please fill in. fill in the openings.
And they're all waiting for the jury. We did receive a copy, paper copy of the proposed verdict form. And she
That's
plans to
like
get a
all media.
special verdict for the different kinds of manslaughter.
That was the other request last week that we spoke about, that the defense had requested that the jury find, if they find either intentional act or culpable negligence, that they would have to find one or the other beyond reasonable doubt unanimously, and do that in the form of a special verdict. And I declined to give a special verdict form, but that was also preserved by the defense. Thank you. Okay, now I have the jurors. So they are coming down. Very good.
Judge, we'll take a break after the state
Yes,
sanction
we will.
by an organization.
Okay.
You ready?
So they're switching. They're going to do the state before lunch and then come back and do defense and then rebuttal.
So just remind me to talk about that, because I sounded like she said she was not giving a special verdict form as far as 2A and 2C. And
That's
she
going to be a
mentioned,
problem, I think.
well, I don't know, because I thought she mentioned that she's going to tell them they have to be unanimous, meaning some of you can't pick A and some of you pick C under manslaughter. If not, that's an issue if they don't know that.
Because she declined that on Friday, so if she's changing her mind today, she probably went and looked up some case law on that, which I think it was one of the laundry list items she said she was going to look over the
But
weekend.
I thought she still said I decline it, or did she say I had declined it, but I'm going to give it?
I think she's declining the form, but you said she's going to instruct them verbally.
I thought that she said she was, so
I think that's going to be a problem, because if you're not, how do you know? If you're requiring to be unanimous on a finding and they're instructed as such, but then you don't give them a way to, you can't get into their minds and know if they did or not.
right.
So I think that makes it worse than just not, if we left it as Friday and weren't going to verbally instruct at all.
I mean, they have to know that it can't be, but there has to be the same theory they all agree on. But
All right.
Lower this while the jury walks in.
Good morning, ladies and gentlemen. Good morning. How are you all doing? Now, a couple of days off, and I have important questions of you. Have any of you engaged in any independent investigation or research to try to gather information to be used in this matter? Have you spoken to anyone about this case? Have you been speaking with each other about this case? Has anyone attempted to speak with you or in your presence about this case? Have you seen anything in the newspaper, any articles, anything on television, social media, that you think has to do with this case?
No.
All right,
Someone say-
very well.
I swear someone said yes.
We're ready to proceed. Members of the jury, both the state and the defense have rescued this case. The attorneys will now present their final arguments. Please remember, what the lawyers say is not evidence. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the opponent has spoken. The state.
they usually say because the state has the burden here.
Yeah, they usually do say that. They didn't. Isn't that funny?
Ladies and gentlemen, good morning. 3 weeks ago, you all came into this courtroom not knowing what kind of case you might be selected to serve on a jury.
Keep your voice up.
Yes, sir. About 3 weeks ago, you all came to this courtroom and you sat through the jury selection process without any idea what kind of a case you were going to maybe be selected to sit and listen to. No doubt this has not been an easy case for anyone in this courtroom, but everyone in this courtroom owes each of you a true debt of gratitude for your service, for your attention, and for your thoughtfulness throughout this process. I want to talk with you all a little bit about what I said to you at the very beginning of this trial. I told you that this is a case about responsibility and accountability. Now that you've heard all the evidence in this case, you can see that this defendant is a man who abdicated all responsibility as the captain of a ship owes to each one of his passengers. Now, done safely, of course, boating can be a lot of fun, and you know that. Look at the pictures that we have. There's so much evidence in this case. You have you all saw the photograph that Ali Fernandez took from his boat, looking across to the defendant's boat, where the teenagers are on the boat, they're in the water. What a great time. What a special day. That photograph was taken because Ali Fernandez was taken with how special it was that his teenage daughter said, "Mom, Dad, come on out to the sandbar." He really didn't want to. Thank God he did. Thank God he did. When voting is done safely, what a wonderful thing to do. But when people like this defendant do not take seriously their responsibility to their own passengers and to other boaters and passengers that might be in the area, disaster and catastrophe can happen. And though it may seem obvious, I wanted to highlight for you in this trial that boat crashes are a lot different than car crashes. When you're on a boat, you're basically like someone in the back of a pickup truck. On boats, you don't have the benefit of brakes, not even anti-lock brakes. You don't have seat belts. You don't have a steel cage surrounding you to protect you from impacting other objects. There's no airbags. And if, God forbid, something should happen and you fall out of that boat, you jump out of that boat, you're ejected from that boat, you run the risk of drowning, even if the injuries that you sustained weren't that serious. And we know that to be true because that's exactly what happened to Lucy Fernandez. Now, in this case, you have evidence beyond any reasonable doubt that this defendant disregarded basic navigational rules and concepts of safety, and he did so in a manner that made it a near certainty that tragedy would result. This tragedy, the death of Lucy Fernandez, was completely preventable. But after this abdication of duty that this defendant owed to his own daughter, to his wife, and to those 11 other teenage girls, these 13 other souls that were on his boat, what did he do? He lied over and over and over again about what happened. Why? To shift the blame away from himself and in an avoidance of accountability. That's why I told you at the beginning of this case, this is a case about responsibility or the lack thereof, and accountability and the complete lack thereof. So let's talk about what was happening on that Sunday. It's Labor Day, it's Biscayne Bay. There's a little more boat traffic out there than usual because it's a holiday weekend. The defendant and his wife decide they're hosting a birthday celebration that weekend for their daughter who was going to be turning 18. That morning, some of the girls watching Mass on TV. We're talking still back in 2022. We're just kind of starting to come out of the pandemic. After that, pickleball tournament sponsored by the defendant. The girls defend tennis, pickleball. What a fun day. Knowing that the next thing they're going to do is go out to Billy's Point, go out to that sandbar. So everybody boards George Pino's boat to go party at the sandbar. And boy, what a party that was going to be, huh? They brought food, sure. The defendant's wife said, "Oh yeah, and my husband packed the drinks." What drinks? Beer, alcoholic seltzers, Prosecco, Chambord. Not just for the Pinos, for everybody. The kids, other people that they're going to meet up with. What a great time for these kids, huh? How irresponsible. But you get out to the sandbar, and what happens? Well, the defendant going out to that sandbar, you heard from Paul Albert, navigational expert, GPS expert, that when he went out to the sandbar, He goes relatively at a mild pace, not really at breakneck speed, and he kind of meanders in and out of the canal, out of the channel, which Mr. Albert told you is consistent with, navigating around other boats, things of that nature, until they get to where they're going to drop anchor. But they don't stay there because one of the other boats, as Mr. Fernandez told you, was too big to drop anchor there. So they go a little bit further north, and that's where they all stop. And they're there for almost 3 hours. And what are they doing? People are drinking, they're socializing, they're swimming, they're listening to music, they're dancing. A lot of these 17-year-old girls were drinking alcohol that the defendant provided. You heard from Candy, the first passenger who testified in this trial. She had consumed 10 alcoholic beverages. 10! I submit to you that as the fun and the drinks were flowing, the defendant kind of lost track of time. And he suddenly realizes, oh my goodness, it's getting to be close to 6:30. I gotta get all these people back to Ocean Reef. And everybody's gotta get fixed up, glammed up for the party. Now, we heard testimony that the house that they were stationed at was like a 3-bedroom, 3-bathroom house. Conservatively speaking, that means 4 girls per bathroom getting ready for the party that he had spent almost $2,000. So it makes sense that the GPS data that Mr. Albert showed us on the way back, he's making a beeline. He's not making all those track points. He's not deviating from course. He's in the mindset of like, set it and forget it. Get back to Ocean Reef as quickly as you can. So, literally, with a boat full of buzzed teenagers, if not drunk teenagers, this man decides to set a course heading to that channel, a channel that he has gone through time and time again, a channel he knows where those markers are. In a boat that there's a stipulation between the state and the defense, an agreement. The boat is in fine working condition. There's nothing wrong with that boat. And he knows the specifications of that boat. He's had it since 2020. So, with that boat,
every day there's a phoning for
with
it.
those 10 girls at the bow of that boat, with an extra 1,000 pounds on that boat, at the front of that boat, he makes a beeline. And you heard from Mr. Albert. In order to reach the speeds that we see from the GPS, with that amount of weight on the boat, he was going full throttle. Full throttle, with all these teenagers on board that had been consuming alcohol as fast as he can, through a narrow channel. Because if other boats want to go through that channel, if he's in the wrong way, then they've got nowhere to go, because if they go outside the channel, they'll run aground. So with all of that going on, he decides to travel down the wrong side of the channel as fast as he can. We know that right before impact, he's going 47 miles per hour. Now, it's kind of a silly thing, but I think most people have seen folks, driving the cars and put their hand out the windshield or out the window and kind of feel the air over your arms. We take for granted in driving that it's not that fast because we have windshields, but if you didn't have that windshield, if you were on a nice paved road, if you were on a bumpy road, 47 miles an hour is lightning fast. And the reason why we saw those reenactments is because we wanted you, in as safe a way, but as realistic a way as possible, to understand the manner in which that man decided to operate his boat. Now, I talked about the teens that were buzzed. The defendant, for sure, consumed alcohol. The defense would have you believe that it was only the 2 beers that the defendant told Lieutenant Thompson. I'm going to submit to you that maybe the evidence suggests that just as he wasn't exactly truthful about how the crash happened, maybe he also wasn't so truthful about how much alcohol he had consumed. This defendant knew the channel. He knew that vessel. He knew the people on the vessel. He knew what they've been doing on that vessel. Yet he chose, before this impact happened, to put his vessel on a heading 5 degrees to port, 5 degrees to the east. And that put him on a collision course with channel marker 15. And sure enough, by the time he realizes, oh no, it's too late. How did this crash happen? I'll tell you. Because he was reckless. He was criminally negligent. No one but this defendant captained that boat. No one but this defendant decided the speed that it should travel, and no one but this defendant decided the direction of travel. No one and nothing is responsible for the death of Lucy Fernandez, except for that man sitting right there. He is the reason why he is dead. Let's talk about that during a little bit more. In these photos, dates 3 and 10, which are in evidence, we see in number 10, a bunch of young girls having a great time. In number 3, we see that photograph that Andy Fernandez took. What a fun, happy day. Is it horse?
Make Forrest go do the tech wizardry.
This person right here, in the white bathing suit with the little flowers, that's Lucy. Birthday girl. Yeti tumbler. Lucy's necklace. We know from exhibits 11 and 106, which are in evidence, that Lucy was seated here in the diagram number 9, right in front of where the defendant was at the helm. And we know that this is the seat that Lucy sat in, where it has her name. You all saw it for yourselves. You all had the opportunity to go on that vessel, the vessel that turned out to be almost a gravesite for a 17-year-old little girl. Because she was still a kid. That's where she sat. And that's where, when this recreation was done with FWC, with the assistance of Mr. Albert, someone sat in that very seat and filmed the route that that man took. Coming up on 13 and then 13A. That's traveling at about the same speed that we know this defendant was traveling through that channel. Let's look at something again. You may remember that when I played these videos for you during the trial, I would stop the video just about at the point where it looks like the vessel is going to impact that channel marker. And then I asked Mr. Albert, who's sitting here, Okay, so if that impact is, let's say we have, 4 seconds left, what's 4 plus 9? Oh, no, that would be great. Why was I asking that? Because what we know from the GPS reconstruction of this crash, that 9 seconds prior to impact, the defendant chose to change the heading of his vessel slightly to the left, or in nautical terms, to the right. And when he made that choice, that's when he put himself and all of those teenagers on a path toward near certain tragedy.
This is their
He was the one that
2A
made that
intent
choice.
argument, intent
And
to act.
for 9 seconds, they were on that path. And, you say, oh, 9 seconds, how long do you have to crawl? We can use technology to tell us just how long 9 seconds is. I have my iPhone here set for 9 seconds. Ready, set, go. That's a long time to not look at what you wait in front of you.
It is not a long time.
Took her longer to shut off the phone.
Yeah. Took 4 seconds for her to shut off the phone.
So let's look at this again. That's 13A. There's the buoy. The one that Mr. Albert explained, that he put that buoy in place using his GPS device to replicate the location where the second to last track mark is. That tells us that this is the location where the defendant decides to change heading slightly to the left, to the outside part of the channel where it is not supposed to be, and then continue straight dead on until right before impact. Channel marker 15. This is a little bit of a ways away from you. All of the evidence that was introduced in this trial, you will have available during your deliberations to watch if you wish. You'll have a laptop that you can watch any of this video on. But look, right now we still have 41 seconds left in this video. Let's see how long it takes to get to that channel marker. Excuse me. So, do you not see how long he had the ability to see that channel marker and adjust course? But because he didn't, because he was operating with such complete disregard for the kids that were on his boat, Lucy winds up like this in the hospital. Because of the way he operated that boat, this is what the police had to deal with.
Very long shot here. Very hopeful.
That part of the clip was included in part so that you all would get a sense of when the police are responding to a life and death emergency, it makes sense for them to go as fast as they can. Not for dinner parties, for life and death emergencies. And you can see that these officers, even on Marine Patrol officers that are trained on a police boat, it's still bumpy. Even though we know that it was a clear day with calm seas, calm winds, you can see the officers, one of the flaps on his uniform, it's like waving in the breeze, because that's what it is to be on a boat. Air rescue got involving a paramedic trying to get to Lucy, to try to save her life. But this is where you remember that Officer Bruto, well, he's not an officer anymore, he's retired, but he was the first police officer that testified in this case. And he told you about the difficulties that air rescue was having getting the paramedic onto the boat because the prop wash from the propellers was making the small boat start to spin. So Officer Bruto and another officer basically pinned that vessel between theirs so it can be stationary enough to safely drop the paramedic to try to save Lucy's life.
Wow.
Officer taking out life-saving equipment.
That sun glare is something.
The girl in the white bathing suit with little flowers, who just a little while earlier had been singing and dancing with her best friends. From there, we know the testimony is that the police boat raced as fast as they could to the Elliott Key Harbor, where a helicopter was waiting for her to try to get her to the hospital to save her life, the life that he endangered. Talked with you before about that final track mark. Now it's the time to talk about it again. On the way up, we see him going northbound. Here he is coming south. Track point. Track point. From 6:37:19 to 6:37:28. 9 seconds. Straight. Had he not made the decision at 6:37:19 to make that turn, to go to port side of the channel. Number one, he wouldn't have been on the wrong side of the channel. Number two, he wouldn't have been on a collision course with channel marker 15, which you know, because you've seen it with your own eyes, is fully visible from where that track point is. This last track point is the one that really tells on the defendant. Because it is only here when the channel marker, which is 3 feet by 3 feet, painted day-glow green at the top of a steel pole, that's the first time that he comes out of his stupor or whatever he's zoned out or checked out doing. That's when he realizes, oh my God. And that's when he tries to turn course. But he can't. He's going too fast. He has too many people on the boat. He can't turn because boats don't turn on a dime. He can't turn to avoid the collision because boats are steered from behind. So when he makes that turn, what happens? He slams the starboard side of his boat right into that channel marker. This tells you he's guilty. No responsible operator of a vessel would ever do this. And what's the result of the, I don't know, arrogance? The complete disregard? Nobody's saying he meant to hurt anyone, but just because you didn't mean to cause something terrible, if what you're doing is likely to cause something terrible to happen, the law says you're responsible.
Yeah.
There are consequences for your actions. Sadly, beyond sadly, the consequences of those actions are in State's Exhibits 15 and 7. A healthy, happy, vivacious young woman with her whole life ahead of her goes from this
Oh man.
to this with her own father. Tearfully, but with controlled emotion, telling you this. This was my Lucy. The defense would have you believe that the defendant was terribly broken up, and I have no doubt. Nobody would be happy about this. But imagine if Fernandez's first Christmas without their children, and this is what's posted on Instagram, this bereft man. This is what they see in December 2022. Their daughter is barely cold in her grave, and this is what's posted. Responsibility, accountability.
Oh, you're muted, Ali.
For his social media post? Wow.
Mr. Andy Fernandez told me
All sorts of wrong.
when I asked
All
him
sorts of wrong.
what he saw of his daughter, hooked up with all those tubes, and his answer was, a parent's worst nightmare. I don't want to unplug this thing, but I hate being so far from the jurors. Aaron, may I have permission to use this again?
I kind of want to hear if the jury responds good morning when the defense says it.
So, I want to say, first and foremost, this is not a complicated case. The facts are not really difficult. And in fact, many of the facts in this case are not in dispute.
Complicated.
But what is in dispute, for sure, is what level of accountability does this defendant have? In jury selection, the judge told you, bias, prejudice, and sympathy have no place in your deliberations in that jury room.
As
We
we
got
just
a
moved
motion.
around.
The evidence, photos, what the witnesses say, and the law, that belongs. Common sense tells you that this defendant is guilty. Now, the defense through this trial has tried to downplay the enormity of this defendant's recklessness and criminal negligence by saying, it's just an accident. No, it's not. This defendant was in a rush because he had paid money for the party for his girls. The way he operated that boat with so many people that had been drinking when he'd been drinking at a high rate of speed in a body of water that literally was called the I-95 of Biscayne Bay. Well, it establishes recklessness and culpable negligence. Why? For a party? Because he wanted to be the cool dad, the dad that brings alcohol out to the sandbar, the dad that plans the pickleball party, camp counselor George. He wasn't thinking about the navigational rules. He wasn't thinking about the well-being of the passengers. He wasn't thinking about the well-being even of his own wife and daughter when he was on that beeline to get back to the Ocean Reef Club. He was too wrapped up in trying to be the cool
Bring it
dad
down a level,
on that
George.
boat. He didn't mean to is not a defense, it's an excuse. Now, the judge is going to give you an instruction, and it's called excusable homicide.
She is? Oh my gosh.
I thought that was out.
Oh my gosh.
Common sense tells you that just because one person causes the death of another person, that in and of itself doesn't necessarily make it a criminal act. For example, the judge is going to read you an instruction. It's called Introduction to Homicide. And that instruction says that you have to consider whether or not the killing was lawful, whether it was justifiable or excusable. Now, of course, this is not a case of self-defense, but the law tells us that if there's a justified use of deadly force to defend a person, then that person will not be held criminally liable for that death. Common sense. Common sense also tells you that there can be accidents that happen, but there should be no criminal responsibility. Let me tell you what that instruction is.
This
Excusable
sneaky,
homicide.
shady
If the
bitch.
killing is committed by accident and misfortune, which this nobody's saying
She
he intended this to
underlined
happen,
ordinary
and
caution?
obviously this is
Tell me
most
she
unfortunate.
underlined
looks like
ordinary
it.
caution.
Yeah,
Doing
she
any
did.
lawful act. Was he operating his vessel lawfully when he was on the wrong side of the channel, going so
Ordinary
fast,
caution.
not keeping a proper
Oh
lookout?
my
Was he operating
gosh.
it
In a different
lawfully
color.
when he's not avoiding the risk of
Underlined.
collision, when he doesn't even avoid the collision? No.
Usual.
And by
Ordinary
lawful
caution.
means,
Does
is this
anyone
the
on the
way
defense see
that we
this?
expect people to operate their vessels?
Are you
on
paying
the waters of
attention,
the
Judge?
state? Of course not. With usual, ordinary caution. Was there 1 ounce of usual, ordinary caution as he's speeding from this track point straight into that channel marker? Of course not.
There's an objection in the motion.
There you
really?
go.
Without any
You
lawful
waited
intent.
that long?
Now, I'm not saying he had an intent to cause
Wait a
any
minute, go
harm,
back.
but his intent
Sorry, I
also.
talked right
Yeah,
over
let's
it.
run
What
this
the
back.
fuck? She didn't. First of all, I was wondering when are they objecting? They know she's saying it. They know it's coming. She's literally holding it up in front of their eyes. Usual, ordinary caution. The judge contemplated in her instructions saying this doesn't actually apply. And now she also said stuff like they're not going to highlight that. They're not going to focus on that. Like, could you focus
They're
and
doing the
highlight
exact
it?
thing.
This is like this instruction should have never been there.
That's the problem.
They did
That's the
that in
problem.
session, okay? And now she is trying to confuse the jury with the words. So the judge sure as fuck better do something about making it abundantly clear that this
That's not the standard for culpable
right, and
negligence.
that is not the only way that is not the only way that it is not criminal homicide, because that's what she just told the jury, that it is
And more important,
homicide.
don't forget the framing. Before she walked over here, she started arguing, now you need to consider this was not an accident. They tried to downplay it. This is about recklessness and culpable negligence. And then she picks us up with the red underlined words. So her framing for introducing this is directly underneath the definition of recklessness and culpable negligence.
All right, let's hear what the judge said when he objected. The guy's going to be convicted.
We said it on Friday. He's getting convicted for that alone. Like the jury's never going to be able to delineate between that and what the elements of the crimes. They're just not going to be able to do it. They're just not going to be able to do it. Juries don't even understand beyond a reasonable doubt.
The judge is going to have to instruct them that what she held up there is literally just an introduction to homicide. It is actually not in play
She's
here.
not doing any of that shit. Like, she's not going to give any kind of limiting instruction or any kind of explanation as to what that means. It's going to fall all on the defense. They have to.
And they better make sure they spell this out in appeal. Like,
right, we're already going to worst case scenario. No, but they should have rethought, and it's too late now to rethink that wanting the lesser includeds, because the closings aren't fashioned around it. But I was already thinking they need to do this with the ones that matter. And I see defense attorneys gloss over the instructions way too often. So let's she's playing
Wait,
it back.
we got a couple quick Venmo questions real quick. Misty had asked, well, first she sent a buck and said this judge is horrible, but then she had asked, can the defense not object to all of the non-factual conclusions this prosecutor is making? She is so bold. That was a $5 Venmo. I think she was specific. She sent that right when Laura Adams jumped to the conclusion about how much George may have been drinking.
I was there. I'm like getting the dog shit ready, and I'm like, oh no, she didn't.
Oh,
Oh
yes,
no,
she
she
did.
didn't.
Oh, yes,
Like,
she
are
did.
you fucking kidding me? She
That's
is telling them you can assume that he lied about that as well. And let's just stack that on. And, look, defense attorneys, like, we are trained. You don't object during openings and closings, especially in a closing. You just don't do it. You let the people speak their piece. But the law says otherwise. You do have to object sometimes, so if it's this he had to object. Thank God he did object, but it's like it goes against our grain to like object during closings, and now we'll see why. But
I,
the other thing that she did was it was God, I wanted to send you guys a comment so I didn't forget, like a text. She talked about what the police had to encounter when they got there. But there was something else that she did that she shouldn't have done, that she was trying to get to the emotion, and, it was
the
something else
before and
she did.
after photos, the social media.
Yeah, I mean, there were all those things, but it was even earlier, but, to your point, Misty or Missy? Misty, right?
Misty.
You can object, especially if there's facts not in evidence, but that wasn't really the time or place. Like, they've lost some objections in that regard, and I think that they'll just hopefully get up there and say you can just rip up, the evidence they actually put forward from every single witness is there was no sign of intoxication. No one saw him drinking. No one saw him in any way appear, seem remotely inebriated. And the parents were there at the same time all of this was going on, seeing all the same drinking, making all the same decisions, blah, 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 blah. But if they don't
See, that's
stand
why
up,
I don't think they sorry to interrupt you. I don't think that they make the objection there. I mean, theoretically, it's argument. She's definitely introducing facts not in evidence. There's no evidence whatsoever throughout the course of the entire trial. But I think if you object there, if you're the defense, and I understand what you're saying in terms of maybe he should have, I think that sends a weird message to the jury potentially, like, oh, because juries always think of objections not like, oh, we're preserving an issue for appeal. They look at them like, oh, well, what are they trying to hide? Like, why are they not trying to allow them to say that kind of thing? Which obviously isn't what it is, but we're talking about juries here. So
right?
you've got to kind of like weigh it in terms of, all right, I'm going to handle this on my closing during
And
my
that's
closing,
actually what I
the
was
way you were
saying for the
saying, right?
for the drinking, right? I didn't think he should object, but and then I did this little thing because my eyes went right to that underlining red thing again, so I just was still
That's egregious.
like it
This is
is.
this is agree like this concerned me on Friday more than anything else.
Yep.
And if you haven't watched our coverage on Friday, like this particular language coming in under a definition of homicide, which to me, frankly, was completely irrelevant to this case. I mean, like, I don't know. It's this is going to convict them. That language, the first thing they're going to do back there. This is going to be one of the first instructions they look at. They're going to have that thing there, unless Howard does a spectacular job explaining to them. Look, the thing that she had to like, he should go and pick that card back up,
And
like
say,
her
"This
her
just take
demonstrative.
a line through it and
Right, this
take a"
ain't it. This isn't.
uh-uh.
This is not the element that has to be met.
It
This is
literally
not
says in the
right.
words, it has to be more than, not
And
just
and it has to be beyond a reasonable doubt.
Right. Whatever that means.
alright, so
Whatever that
They're
remember,
means.
going,
but
if you
we
missed it, Bob, they're going with the prior language for reasonable doubt, not the
Oh,
new
prior
one.
to the June 12th?
yeah, and we're gonna
Yeah, the
talk about it
one the
on
one
the
win for the
break.
defense.
Yeah.
So
Alright.
people remember what we paused it here to hear is the defense is going to object. I was screaming my face off, but I didn't even hear the judge say a word. She must have said overruled or something, because the prosecutor just kept talking. And I really thought that this should make the judge. I thought she's picking up her phone there. See what did she have her phone in her hand? I
I
thought
don't
she's
know.
Got
making a little note
something.
to herself, like, this is not right. I got to rectify that. Like, that's what I was thinking she was going on there. Like, she sees what's happening. But then we hear this objection. I think you don't have to go back that far, but it's
Oh, it was like
it's
10 seconds.
okay.
Also, for anyone, Peter, shout out to Peter over on the tip jar. I know Green Hearts would be going crazy in the chat if it was live. Said, hey, what's new? Love your hard work. What happened to the live chat? Remember, guys, we will bring the chat back for lunch. It's based on the court order. We have to, any feed showing the court stream has to disable the live chat function. Otherwise, there's a risk of the still camera that's giving us this footage being kicked out. So
But
thank
we
you,
miss you
Peter,
guys,
and we
and
will be
Kat, put
back.
back up your little banner so they
Oh,
know.
yeah. Sorry.
Yeah.
I didn't know it was down.
Oh,
Oh, I got to add the thing about court in this one. I see what you mean. All right, let's hit play.
we'll keep
Safe?
playing them.
Of course not. With usual, ordinary caution. Was there 1 ounce of usual, ordinary caution as he's speeding from this track point straight into that channel marker? Of course not.
There's an objection in the motion.
And without any
Reserved.
lawful intent. Now, I'm not saying he had an intent to cause any harm, but his intent also was not to safeguard his own passengers. So when you hear this instruction, listen to it, pay close attention to it, but then ask yourself, does the evidence support a claim that this is an excusable homicide? I submit to you the answer is a resounding no.
Oh, God.
Best analogy that I could give for people that don't really go on the water too much would be this. Imagine if a person decides to drive a pickup truck with 12 balls in the back. They're not restrained in any way. And that person is going down a rather bumpy road. Because even on the water on clear days, you're still bumping along that water. And that person who's driving that pickup truck with all those people in the back on a bumpy road decides to drive on the wrong side of the road. And let's suppose that at the end of that road, it dead ends and there's a telephone pole at that dead end. And although that person who's driving the pickup truck can clearly see that telephone pole, at least if they're paying attention, for 9 seconds, that person driving that pickup truck slams into that telephone pole and one or more of the girls hurt badly, maybe even dies. Didn't mean to kill anybody. But are we really going to say that that is acceptable conduct? Are we really not going to hold somebody criminally liable when they have precious cargo on board and pay no
Holy
attention to what's
fuck.
in front of their face?
Say
Of
eggs.
course not. Your common sense tells you that's not the world that we live in. Those are not the laws.
She is literally trying to do jury nullification in the reverse. This is so outrageous to me, and it probably won't be as nearly as outrageous to an appellate court. Who knows? But this is just, and I'm sorry because I know you guys want to hear the openings. And then I remembered the other thing she did. She said when the dad got on, he had controlled emotion. She was getting at.
Closing.
Oh, yeah.
Right.
Yeah. Look, man, that is not at all the same. Pickup trucks, boats are made, a 29-foot boat is made to have passengers. Like, you're not supposed to be driving with people in the bed of a pickup truck. It's not at all comparable. It's a completely, her analogy was nothing like what we're talking about here.
But
You should
Bob,
have
what do you
objected there.
think would have happened? Yes. What do you think would have happened if the defense in like some cases is arguing, like, I can't think of a good argument, but it would be because this is like she was saying during nullification, this isn't the world we live in. Are we going to say that's okay when there is precious cargo? First of all, it has to be unlawful, even if it's empty, no matter what the cargo is. An entire truck full of serial unaliving rapists and child assaulters.
Well, I mean, in her example, in her analogy, driving on the opposite side of the road is illegal. So, I mean, there was nothing that he was doing that was illegal. And you know, whether or not he was in violation of navigational
Well,
rules,
that would be the same, I think,
no,
illegal.
I don't think so. You get a ticket if you're on the right driving on the wrong side of the
And you
road.
get a ticket if you violate the
I
navigation
don't think
rules.
he does. I don't think leaving the channel a little early is violating a navigational rule.
I don't think so either.
Because
I
that's
actually thought
all
that
he
was
did.
going to be bad when I first read about this case and was waiting for it to start, and we didn't see what the channel looked like for like 5 days. I was like, oh, that's kind of really bad. Why would you? And then they show us the channel, and it's really tiny. It doesn't even seem significant.
Right. It's just, you know, I mean, the entire point of the channel is that they dredged it so that boats that have deeper holes, you know, aren't hitting the bottom of because it's very shallow around there. Like, I mean, it's shallow water. You could see it when the boat flipped, that the top of the boat, when it's upended, is like resting on the bottom of the water. You know, I mean, this isn't 30, 40 feet deep. It's like 7, 8, 9 feet deep, maybe. I don't know.
And I just wanted to make clear because, of course, I lost connectivity as soon as you started it up, and I listened in my ear. She just said overruled
Did you
with that
see
objection,
did you
right?
see the glare?
She said it was preserved. So
Oh, which glare?
The glare when they were showing the videos. Like the glare was
she showed
insane.
Bruto's response, and like how like in that video, to me, half the video is taken up by the sun glare when they face a certain direction.
Like the whole video was
Well, hopefully the
unwashed.
defense has,
Emphasizes that.
keen eyes, keen observers like Katt, and puts it back up and says, what do you see? I literally had a prosecutor one time. We were trying to decide whether my client handed a firearm to a child who then shot another child. And they used the sun reflecting off of her belt during this period on this cell phone where they were really close together and said, there, you just saw it. And I had to go back, find the exact spot and show them this is the sun. Like, this is the sun. Like those.
And they were saying it was muzzle flash?
No, they were saying it was the silver, like the reflection of the silver of the gun passing. And it was she had like a belt buckle on that caught the sun. So
Well,
it would be a perfect opportunity for him to put up her video and say, tell me what you guys see. I don't need to tell you what you see. You tell you what you see.
Or what you can't see because
Right.
of the glare. Yeah. All right, let's roll. Let's roll.
Sleazy, good for nothing.
This was not an excusable homicide because the defendant was more worried about being the fun dad, the party dad, the cool dad, than he was worried about being responsible dad, safe dad. He created an environment by supplying that alcohol, by not managing how much those girls are drinking, and drinking himself out there on the water, having played pickleball earlier, been in the sun and the salt water. He created the scenario where this happened. And that's why Lucy is dead. I know that the defense will have an opportunity to address you when I'm finished, and I have no doubt that they will say that they are very sorry that Lucy is dead. Nobody wanted that to happen. And I am sure that that is 100% heartfelt. But when you hear any kind of statement like that, I want you to keep your ears out for the inevitable, but so sorry she's gone, but what a tragedy she's gone, but. And you know what the rest of that sentence is. It was only an accident. Accidents happen. Well, you know this wasn't just an accident. An accident is if you accidentally blow through a stop sign and somebody gets into a fender bender. This isn't blowing through a stop sign. This is blowing into the stop sign on the wrong side of the road when you've been drinking. It's not an accident. I want to take you back to when this defendant's wife took the witness stand. I asked her, showed her Lucy's photograph. right at this witness stand. She's sitting here, and she's looking at this picture of a young person that she had known for Lucy's whole life. And in the same breath that she identifies this picture of Lucy, she tells you it was an accident. I made note of the exact back and forth exchange. This was me asking her, do you know how it is that your husband wound up smashing into channel marker 15? Answer, the accident? How it occurred? How did he wind up crashing into it? I do not know. Me, why not? Her, I was looking at my phone and trying to send a text to the moms, a video of the video of the girls dancing. I was trying to send it to the moms, and I remember looking at the blue line and being upset that it wasn't going through the text, and I was looking at my phone. Me, I'm showing you a photo. Who is it? Her. Lucy. Me. And she died because your husband crashed into that channel marker, right? Her. With the same breath that she had just identified this young woman, she has this to say. She died because there was an accident. What? How do you know it was an accident? You were too busy watching your cell phone. You were too busy drinking your Prosecco's and your Chambord out of Yeti tumblers to know what happened that day. But you want to take this witness stand under oath and say that this was an accident? The expressions of sorrow for Lucy and her family mean nothing in this court of law because this is not a case to be decided on based on sympathy. Not for Lucy. Not for her family,
Okay,
not
lady.
for the other girls who went through this horrible traumatic experience. Not for the defendant's wife.
She might as well
Not
be
for
holding the
everybody.
picture of Lucy up as
It's
she's
not a
saying
case
that.
about who cried
This is not
the
about
loudest,
sympathy.
who held back the tears. It's a case about what is the facts, what is the law. That's why every day when we see you, Judge Lucy Fernandez asks you the same series of questions. Have you paid attention to this case outside of this courtroom? Have you heard anything about it? Because truly, we need you to make this decision, not based on sympathy, not based on what's out there in the interweb of it all. We need you to base your decision on what happened in this courtroom. The defense seems to want you to believe that what the defendant did is see the channel marker, that he's not responsible. If you didn't see it, it's because you weren't looking. What were you doing? Were you watching your wife as she's trying to get these text messages out to the other parents? Were you looking at your own phone?
You don't know, it's your
Drinking
burden.
something? What were you doing? You sure as heck weren't watching out for that neon green channel marker that you knew was there. And because of that inattention, his boat wound up upside down under the water. The defense also seems to be suggesting that, well, if he didn't mean for it to happen, he's not responsible. If he meant to kill Lucy, he'd be charged with murder. If he deliberately smashed into that channel marker, same thing, he'd be charged with murder. Why is the defense defending against a charge I never filed?
What?
All right, let's circle back to that one.
The defense kept asking the girls that were on the boat who came and testified, and the defendant's wife, did he look like he was impaired by alcohol? Well, I did not charge him with DUI, voting under the influence manslaughter. You know what?
I think we need to pause here because if you are not aware of pretrial motions in limine, the state filed to exclude references of previous prosecutorial decisions. And to me, this is creeping over the line. This is totally creeping into the line of charging decisions. You're muted, Ali.
It is. I mean, I have it paused right here to play you guys when we go to a break. The discussion that they had about whether or not she was going to even mention the usual and ordinary caution. So just remember that red underlined thing, and you guys remind me to cue it up and play. I've got it paused to play for you guys. But she is
I don't
Absolutely.
even think she's towing the line. I think she's stepped over the line. Like this is absolutely going to charging decisions. I mean, she may have been referring to the two misdemeanors initially that he ended up getting upgraded on, but like this is a charge that clearly wasn't charged. And beyond that, she's arguing as if he should have been based on her comments earlier about, well, he lied about, another boat being there. So we can just assume that he was drunk. I mean, it's like she's doing what Howard has said that she's been doing the entire trial, which is arguing out of both sides of her mouth.
Yep.
She's trying to have her cake and eat it too. And like I don't know what you guys think of her demeanor. I hate
I think Bohr should
demeanor.
have done the closings.
Well,
She
that's why,
she
babe, I said what I'd like to hear is when she said good morning, they all said good morning. So I'm dying to see if the defense says good morning, if they respond good morning, because they may just see her as the, the
Angel
state's
for
angel
victims.
that's
Yeah, the white
protecting.
hat. The white
Right.
hat,
And
coming to
and
the rescue of poor Lucy,
And what else she did right there? She tried to say when the defense tries to say words, all those words are defending causes of action I haven't brought. Oh, yeah, so they must have been talking about murder. Remember, she'll get back up and be like, I didn't charge him with that. Yes, the fuck you did. You charged him with an intentional act. Okay. So it's like Bob is saying, she's arguing out of two sides of her mouth. The judge can't grasp the law. The judge specifically said that she would not be, that the prosecution would be improper to do what she just did, yet she preserves the argument on uh when the defense makes an objection. This is so outrageous, and I know it's way more outrageous to Bob and I. Maybe your everyday prosecutor would be like, oh, it's just like, oh, maybe that was a little wrong, but it's the kind of thing that just infuriates the fuck out of me, because this is supposed to be about what's fair, what's right, what's wrong. Not, well, are we going to let a guy skate who did this with precious cargo in his car and those girls' eyes? Is that the society we are? Y'all are going to let this guy skate? He had precious cargo in the car. You remember that, right?
He's rich.
Yeah. Why don't we play that Uptown Girl a little bit more? Look at these Uptown girls. Mm.
Man.
And I
What
know
his
there's a
blood
lot of
alcohol level
people
was.
that think he was criminally culpable. So, and you guys are, welcome to hold that view and maybe still see, some of the issues with the way she's arguing it. Yes, Bob, and I don't think that this evidence proves he was culpably negligent. Under the law, as it is actually defined. Um, But yeah, just stay tuned for that little refresh that we're gonna play at the break of the very same argument that we just heard.
Yeah, and I also think she's leaning much more than I expected into the 2A theory, the intentional act theory, where he intentionally changed his course of direction towards the marker. I didn't expect her to lean so strongly into that, but she is.
It's just so bizarre that she's relying on an intentional act. It's like it's the fact that the judge can't wrap her mind around the fact he made the point. So, based on the logic you guys have here, if he intended to operate a boat and then this happened, everything between, that is 2A. And under 2A, you cannot charge it is not a lesser included offense. Vehicle homicide is not a lesser included offense under 2A. So you cannot tell me that the very same thing constitutes the same theory either way. If legislature, the courts, they have gone out of their way to say, but under C, vessel or vehicular homicide is a lesser included. Under A, okay, there's an intentional act. No, you don't get the lesser included. So it has to be different. It cannot be the same freaking thing. Sorry.
Cam got home.
Oh, okay.
Yeah. All right.
The time you smashed into that channel marker, I can't prove beyond and to the exclusion of every reasonable doubt that he was impaired by alcohol at the time he smashed in that channel marker. So you know what? I didn't charge him with that offense. And why is the defense defending against something he's not even charged with? Now,
Because you're arguing it
You
anyway.
keep saying he's wrong.
he said he had 2 beers. Well, frankly, it seems like 2 beers might be a little bit under-reported what he actually consumed, but I can't prove how much more than that he might have had. So we didn't charge him with DUI manslaughter. Think about how many times you may hear the defense say, he didn't look impaired, but who was it that was making this judgment, at least from the voting perspective? The teenagers and the defendant's own wife, all of whom had been drinking alcohol. You think
And the
maybe
first
people that have been
responders.
drinking alcohol are not in the best
Those
position
guys.
to say who did or didn't look like they were a little bit buzzed or more? And then that brings up another question for you all to consider. Why even drink beer at all? When you're the captain, when you're responsible for all these lives. Gatorade, non-alcoholic seltzers, water, iced tea. Why did people drink beer? They drink it to get buzzed. And Lieutenant Thompson told the defendant, and his courtroom, it's not per se against the law to have a beer and operate a boat, but if you do drink and drive, or if you do drink and operate a boat, better be really mindful. Because I think it's common knowledge that before somebody looks like they're stumbling down drunk, alcohol's already playing games with the brain. We all know that alcohol can make people make maybe not such good decisions. It can maybe influence your ability to pay attention and to concentrate. But again, he's not charged with DUI. He's charged with being reckless. He's charged with being criminally negligent. And the defense also brought up through the officers that see the defendant, well, you didn't see any signs that he was impaired? Of course not. The police are seeing him some decent amount of time after the crash, time after he'd been holding onto his boat, right? Time that he had to kind of clear his thoughts, be in the water, assess his surroundings.
Oh yeah, clearing thoughts.
Tammy, the first passenger who testified,
Assessing
she had
surroundings.
10 drinks. A 17-year-old with 10 drinks in her system snapped to it enough that she was able to help try to rescue Kathy, Mia. She said, I was buzzed when I got on that boat to go back to Ocean Reef. But being in that water and seeing the emergency situation sobered her up at least enough that she was able to do things like try to save her friends' lives, the friends that he endangered. So, you know, to say that by the time the police see the defendant, he doesn't look like any signs that they can see impairment, that's just the function of time, adrenaline, and being in an emergency situation.
What evidence do you have of that, woman? Like she's Ipsy Dixieing it, like just saying shit
sure.
without any evidence of that.
That's been their whole
In the
case
moment after this crash,
for these charges.
this was not good seamanship. This goes beyond not just following navigational rules. This goes beyond anything like that.
Ray
This
sips
is
a lot
criminal
water.
conduct. And that's why he couldn't wait. When he's brought to Elliott Key Harbor, and Lieutenant Thompson just wants to ask him about, hey, where do you keep your boat? Do you have a trailer for your boat? Because he's thinking, have to get this boat out of the water. And what does the defendant do? He's so anxious to blame somebody else, that lack of accountability, that he starts answering, and you can listen to the tape yourselves, because you'll have the jump drive with all of this defendant's statements to Lieutenant Thompson. And what you'll hear and see is that in those moments, when the lieutenant is just coming up to him and asking him, hey, do you have a trailer for your boat? Where do you house your boat? He's talking about, oh, there was this other boat coming in the opposite direction. Thompson is not even listening to that. He's like, whatever, and he keeps going back and asking, where do you keep your boat? Then he finally gets the information that the lieutenant wants. But he's still yammering on about some other boat. Then, when he sits down with the lieutenant at that picnic table, he builds on that line. And he starts giving more details about this phantom boat that came along. He's given his Miranda rights. He's told anything you say can be used against you in court. You don't care. He still wants to get that lie out. And under oath, he signed a written statement. It was the other vote's fault. But he didn't stop that night. He was untruthful to his attorney. You heard from his attorney twice in this case. I called him the first time just to explain what interrogatories were, and that in fact, both the defendant and his wife signed these interrogatories answering questions under oath about what happened. But then he was called back a second time by the defense. Boy, he couldn't say enough great things about George Pino and how he wanted to settle things with the Puigs as fast as he could. But then I brought out the fact that, oh, really interesting, because within 6 months you had filed a motion to limit his liability. And you had also filed a motion to dismiss claims of their lawsuit. Okay, this is not a civil case. And the only reason why any of that is relevant is because it shows the persistence of the lie. That he not only lied to the police, he lied to his own lawyer, who then took those lies and incorporated them into legal pleadings.
Oh my
And
God.
he wasn't just lying to his lawyer. He was lying to the court system. He was lying to the family of Katy Puig in answering those questions in the way that he did. Because he was so desperate to avoid accountability. Why? Because he knew this was not just an accident. People don't lie about accidents. You fess up, you say, my bad, I didn't see the stop sign. I should have stopped. I'm so sorry. But this was so much more. That's why he lied to the court system, lied to his lawyer, lied to the Puig's lawyer, and the Puigs themselves, a family that his family had known for years. Now, with that being said, I want to make it clear, he's not charged with perjury. The only relevance of those lies is to show that he knew. He had a consciousness of guilt. Because anyone that has as much experience as he has on the water knows there's no excuse on earth to justify the way he operated that boat. And, you know, it's kind of stunning behavior from the man whose wife described him as, oh, he was like the one for Camp George, right? He was the father who wanted his children to get the best education. That's from his wife. He was the father that wanted to instill in his children an understanding of right from wrong. That sometimes actions have consequences, and that it's important to take responsibility for your actions. That's what she said he taught his daughters. To try to explain away all these lies, the defense called Dr. Diana Barrett, a concierge neurologist who saw the defendant twice, watched a video of him, heard some things that he said, and did work to do one thing and one thing only: answer questions posed by the defense. Did he have a traumatic brain injury, a TBI? Could it have caused amnesia and or false memories without the intent to deceive? And how long would those false memories last? And she got about $30,000 to do that.
All right, what picture are we getting?
This is the witness that the defense relied on. A woman who is in private practice and won't accept insurance from patients who may need her care. It's a pretty far cry from the woman that used to do work for Milla's house. A woman who just took her marching orders from the defense to answer 3 self-serving questions. She said the MRI that she'd been given didn't matter. The Montreal cognitive test that she gave didn't matter. During my cross-examination of her, she had to admit there was no test that she could give to the defendant, no test, to prove that he had amnesia or created false memories without the intent to deceive. She had to admit when I asked her about the defendant's Glasgow coma scale. Doesn't mean you're in a coma, but that is a tool that EMS, firefighters, paramedics use to assess a person's level of consciousness. I said to her, after I introduced the fire rescue report for this defendant, what was he assessed that night, September 4th of 2022? What was his Glasgow coma scale? 15. What's the highest possible Glasgow coma scale? 15. Every single one of our jurors every single attorney in this courtroom, 15. She admitted that the defendant simply got 7 staples in his head to close the wound, and he was released from the hospital the very next day. She admitted she hadn't even laid eyes on the defendant until this past February, about 3.5 years after the crash. And she admitted that the defendant told her the only treatment he received was some therapy and psychiatric medications. And I'm not putting that stuff down. But that is not indicative of a person that had a traumatic brain injury such that he's confabulated like a person with dementia would. Boy, I'll tell you what she did not want to admit. I asked her, last thing, when she was on the witness stand, Dr. Barrett, let me make sure I understand. You were hired to evaluate the defendant's memory surrounding the crash, but you never asked him what he remembered of the crash. It's a simple yes or no question. Yes, I did. No, I didn't. But you know that the answer is no, she didn't ask him. And she kept wiggling around. Well, I didn't think that that would be important. No. Let me ask again. And note this, when the judge reads you the instructions, one of the instructions is going to ask you, was the witness honest and straightforward in answering the attorney's questions? I said to her again, no, Dr. Barrett, I want to ask you again. You were there to assess his memory of the crash, but you never asked him what he remembered of the crash. Ultimately, she kind of says no, but you know the answer is no, because if she had, she would have said yes. Here's what he told me. She didn't want to admit what a tremendous lack of expertise went into that $30,000 that she made burned. I don't blame her. That's her choice. But you should consider her credibility when you think about the fact that she didn't ask something that basic. She told you she based her decision that he had amnesia and, how did she say it? False memories without the intent to deceive, based on just these 4 things. Who sat behind him? He couldn't remember which 2 girls were behind him. What the horsepower of his engines were, he said 225, they were 300. They could remember exactly what happened right after impact. And that he said that it was Nati that he recovered under the boat, not Lucy initially. But there's an explanation for that, that she wouldn't have known, but you know. When the defense called Hamlet Rodriguez, he was one of the good Samaritans that gets to the scene. We know that Hillary Candela, who was friendly with the defendant and knew the police and knew the Fernandez family, when Hillary Candela gets there, I have him yell from the witness stand, which I know seems weird to yell in court, but he yells to show you, George, if you don't go down under there, I'm going to do it. That's got to be about the time when Hamlet Rodriguez is getting there, because Hamlet says when he's yelling at him to go under the boat, the defendant does go under the boat. But what does Hamlet Rodriguez tell us that Hillary doesn't see? The defendant grabs a girl from under the boat, and does he take her to another Good Samaritan vessel? Nope. He passes her off to Hamlet Rodriguez. And he's the one, he told you, who takes Lucy to the boat where you just saw the video, where people are doing CPR, where the Marine Patrol puts her on the backboard, gets her onto the Go Fast police boat to get her to the harbor. So it makes sense that the defendant, in just those brief moments that he has of passing Lucy's body, maybe he didn't really take a good look at her. So all 4 of those things, he couldn't remember who was behind him. Even Dr. Barrett said, and I kind of can understand that. Why are you looking behind you if you're going forward? The 225 versus 300 horsepower, okay, whatever, you got a detail on. Not remembering exactly what happened right after the fact, totally understandable. This was a terrifying thing for everyone, I'm sure, including the defendant. And then the fact that initially he said that he thought it was Nati, but then he realized, oh, no, it was Lucy. That's what she based the amnesia and the false memories without intent to deceive. What I want to propose to you is that you don't need an expert witness to maybe look at the totality of circumstances and say, no, this wasn't a false memory without an intent to deceive. This was a false statement made exactly with an intent to deceive. When he said other boat caused the crash. It was a false statement, and it was intended to deceive. And I submit to you, if he was willing to give a false statement with an intent to deceive about how the crash happened, maybe he was also willing to give a false statement with an intent to deceive about how much beer he had at that sandbar. We can't prove it, so I didn't charge it, so why are we defending against it? During this trial, you've heard the defense try to blame a number of different things in this case. Blame the sun, right? Maybe the sun kept him from being able to see the channel marker. But Mr. Albert told you that at the defense request, overnight, after he had testified and I had rested the case, he did some calculations, and he saw, based on the NOAA, National Oceanic Atmospheric Administration, based on their data, he knew that at the time that that second to last track point was, the sun would have been to the defendant's right-hand side. The sun isn't blinding him from seeing the channel marker, so forget that. The defense attorney says to Detective Dow, the drone operator, oh, well, this photograph, the water looks green, the channel marker is green, maybe the channel marker wasn't so visible. First off, Detective Dow was like, no, actually, that's just a function of the not so great printing of this photograph. Plus, when you're higher up, the water looks more green, but when you're closer, which you guys can see from the videos, the water's blue. You really think the Coast Guard didn't take into account, let's make the channel markers as hard to see as possible. So that doesn't work. Oh, remember they also asked, hey, could channel marker 13A, the one before channel marker 15, have blocked the defendant's view of channel marker 15? Mr. Albert, who, in contradiction to Dr. Barrett, Mr. Albert said, I did that extra work, I'm not charging anybody for it. That's integrity. And what Mr. Albert said in answer to the defense attorney's question is that the only way that channel marker 13 blocks channel marker 15, if you're so far back, you wouldn't be able to see channel marker 15 anyway. So that excuse doesn't work. The defense talks about, well, but if you zoom in on the chart plotter, it looks like maybe the channel marker is a little bit further off. And that's when, it was kind of hokey, but it illustrated the point. I grabbed my iPhone and I showed you all a picture of the Mona Lisa. And if you zoom in on the picture, it doesn't look like it's the Mona Lisa anymore, even though it is. And that's exactly what they did with the GPS screen. Then they come in and try to say, oh, it's the girl's arms. They're singing and dancing. But I asked Claudia Portocarrero, who was the first girl that the defense called as a witness, okay, you guys were singing and dancing, you've seen the video, but at the time you're going almost 50 miles an hour, facing backwards on bumpy water. Like, in those moments before the crash, were you guys standing up? Were you guys waving your arms around? No, of course not, because who's going to be doing that unrestrained in the front of a boat? It doesn't make any sense. So that excuse doesn't work. And then, this might be my favorite, the tides. It was high tide, so maybe the sign wasn't visible. As if the Coast Guard isn't aware of the fact that tides rise, tides lower. And they're going to take that into account when they're placing channel markers that are there to keep boaters and passengers, everybody on the water safe. So none of these excuses hold up. When this trial began, with jury selection, you all were instructed by the judge that this defendant is presumed innocent. And each and every one of you said you can abide by that presumption. Had you not, you would not be here. We live in a country, we are blessed to live in a country where people do not have to presume their innocence. That's not how it is everywhere in the world. Here, the government accuses you of something. The government better have the evidence to back up those allegations. Now, there's an instruction that the judge is going to give to you. That while the defendant is presumed innocent at the beginning of the trial, that presumption of innocence can be overcome if the prosecution does two things. To overcome the defendant's presumption of innocence, the state must prove, one, that the crime or crimes that he's charged with were committed, and two, that the defendant committed those crimes. So I'm going to take a little bit of time now to go over those crimes, the evidence, and what the law is, to try to give you a roadmap for when you go back into the jury room that you can follow to come to the correct and legal and wise verdict. So first, the defendant committed the crimes. That's basically a way of saying, is the right person charged in this case? There's no testimony that anyone other than that defendant operated that boat. Cammie said it, Hero said it, Claudia said it, Nati said it, his own wife said it. He said it himself in the statements to Lieutenant Thompson. He said it in interrogatories. So there was nobody else operating that boat. So we're already basically halfway there. Same thing. We're already halfway there to a guilty verdict because we've established, without any question, he's the person at the helm of that vessel. He was the captain of that ship. So now we just got to look at, did I prove the crimes of manslaughter and vessel homicide? And although the judge is going to instruct you first about manslaughter and then vessel homicide, I just want to go over with you the crime of vessel homicide first. The elements for vessel homicide are simple. First, that Luciana Cristina Fernandez is dead. We know she is. Second, that the death was caused by the operation of a vessel by George I. Pino. Nobody but this defendant operated that vessel. And third, that he operated the vessel in a reckless manner likely to cause the death of or great bodily harm to another person. The instruction tells you the defendant to be guilty of that crime does not have to have intended to harm anyone. So why would the defense say, well, he didn't mean it? Of course not. If he meant it, he wouldn't be charged with these offenses, he'd be charged with something else. The judge will tell you that recklessness is more than just failure to use regular care. She will tell you that recklessness can take place in two different forms. I'm going to suggest to you both are present in this case. First, that the acts are done in a willful way. Willful doesn't mean you will Lucy Fernandez to die, but willful means you deliberately set the course, set the speed. You deliberately operated that vessel. This vessel was not on autopilot. He was the one making the decisions.
Wait a minute. Wait a minute. So remember, like, 40 minutes ago when George was like, hey, Your Honor, that sounds like, if I intentionally operated the vehicle, that's the intentional act. And oh no, I don't agree with that. Well,
That's exactly what it is.
what'd she just say? What are the words this woman just spoke? They need to object again, and I think that they're like zoned out.
Deliberately set the course, set the speed. You deliberately operated that vessel. This vessel was not on autopilot.
It wasn't an autopilot.
He was the one making the decisions. Were they wise decisions? No. Did he intend the consequences of the decisions? No. But he is the one that steered the boat. He's the one that decides how fast it goes. That makes this conduct willful. Also, she will tell you that recklessness can result from what's known as wanton behavior. What is wanton? It is a conscious and intentional indifference to the consequences, right? Not that you want those consequences, but you're not paying attention to what the consequences might be. And that damage is likely to be done to persons or property. When you set your vessel on a course and then are basically flying blind for as long as 10 seconds into a channel marker that you know is there,
Do you want me to pause?
that's a wanton disregard for the safety.
Can you
So,
send me the instructions?
did he intend the outcome? No. Did he intend the death? No. Did he intend it in the channel marker? No. But did he intend to change course? Did he intend to be operating at full throttle? The answer to that is yes. And that's what endangered everyone on his vessel, including himself. What witness tells you that? What witness tells you how fast he was going and what direction he was traveling? You know the one. I told you at the beginning of this trial. The witness that didn't have a voice. The witness that had the perfect memory. The witness that isn't influenced by bias, prejudice, sympathy, money, or power. The witness is GPS. The GPS, that track point that I showed you, tells you everything you need to know about this defendant's recklessness. And the person who testified about that GPS data, Mr. Albert, he says to you at great length, at my prompting, about his training and his experience, that his day job is a lieutenant in the Internal Affairs Division, the town of Palm Beach Police Department. He tells you about his years and years of experience in police work, both with that agency as well as with Florida Fish Wildlife Conservation Commission. He tells you about the years and years that he's been a boater since he was a kid. And he tells you about the years and years of experience and training he has in GPS, which ironically just stemmed from his love of fishing. You recall he told me I had to start learning how to use GPS so I could find my favorite fishing holes. And I know that testimony might have seemed a little bit dry. But it was really important for you all to understand the quality of the witness that he is. With all that law enforcement and personal experience in boating, with all the training and experience he's had in interpreting and analyzing GPS data to the point where now he's a senior trainer at the NASDAQ, I don't know what it stands for, but that's how good he is at what he does. And it was important for you to understand that we're not giving you ship science. And so when he went through with you step by step, and you have all those track marks, you can look at them in the jury room, of how the defendant meandered his way up to the sandbar, but then was like zooming back. When he's telling you this is how fast that vessel was traveling and this is the direction it took, and he had to be the one to make the choice to go that fast and to head in that direction, that's all the proof you need to know that this was reckless. And so when you go back in the jury room and you have the verdict form in front of you, as to the crime of whether or not the defendant committed vessel homicide for operating his boat recklessly, the verdict is guilty. So as to the offense of vessel homicide, I submit to you that that charge is proven beyond a reasonable doubt. If there was no one else on the defendant's boat but his wife, and if he had followed that path that he took, and if she had wound up dead, forget about the other kids, forget about the alcohol, forget about all of that. Just the manner in which he operated that boat, head on into a channel marker that was easily visible, that he knew was there, and disregarding anything around him to just fly into it, he's guilty of vessel homicide. But the thing is, you can't ignore all of these other factors that were in play that afternoon. You can't ignore the fact that he had brought the alcohol, that those kids had unlimited access to it, that he wasn't moderating anybody's drinking. He's drinking. He has a boat full of vulnerable teenagers who are not going to probably be at their very best if, God forbid, something should happen. He made the choice to be consuming alcohol. He made the choice to be operating his boat through I-95 of Biscayne Bay as fast as it could go. And so when the judge reads you the instruction for manslaughter, she's going to read you the definition of what culpable negligence is. Manslaughter can be proven in this case in one of two different ways. And just like I said, we've proven both aspects of being reckless. I'm going to submit to you we've proven both aspects of manslaughter. And this is why. First, you can be guilty of manslaughter if you commit an intentional act, even if you don't need to cause death, but your intentional act causes a death, that's manslaughter. And the importance of Mr. Albert's testimony is because those track points are dropped when direction is changed. And we know the speed of the vessel based on the distance it takes, or the time it takes to travel a given distance. And we know that because he was traveling, accelerating for over 9 seconds, that's not one of those speed spikes that I told you all that can happen if you're talking about very short distances. But this is a long distance over a relatively long period of time. So we know that he is intentionally committing acts, not with the intention of death, not with the intention of hitting the channel marker, but the intentional acts that he is engaged in do cause a death. That's manslaughter. But the other way that you can be guilty of manslaughter is if your actions, in their totality, result in a death, if your actions meet the definition of culpable negligence. It's the judge's job to instruct you on the law, so I will wait for Judge Fernandez to read to you the definition of culpable negligence. It's going to sound a lot, honestly, like the definition of recklessness, but it's a little bit more. And so he's charged not just with the vessel homicide, because it wasn't just one person on board. It wasn't somebody who hadn't been consuming alcohol. It wasn't someone that didn't have a scenario where it's just him and his wife. This is a scenario where teenagers are on the board. The level of danger that he exposed everyone to cries out for something more than just vessel homicide.
What?
And that's why he's also charged with manslaughter. And you may say to yourself, well, how can one person be charged with 2 different homicide charges if there's only one death? And the answer is because, yes, of course this is recklessness. So you can find him guilty of vessel homicide. But it's also, he committed an intentional act and he acted with culpable negligence. And so to be as descriptive of what his conduct was.
Wow, she just said it was for everybody.
He's charged with both
That
crimes.
he exposed danger.
That the evidence in this case proves both those crimes beyond a reasonable doubt. So then we go back to this.
And they didn't object at all.
Is the defendant's presumption of innocence overcome? I've proven these crimes were committed and that this defendant is the one who committed them. You will have access to all the videos, photographs. You will have access to the documents that are in evidence. There's an interrogatory, the fire arrest report, all of that will be for you to review, to think about what the witnesses said, how they acted, who was believable and who was not. And I'm confident that when you do that in this case, you will find that the defendant is guilty both of manslaughter and assault. Thank you so much for your attention. I hope you'll give your same kindness and attention to my opposing counsel.
Thank you, counsel. Just give me a moment. Listen to what is over. Thank you. Thank you.
Well, we could jump past this. Think they're just doing scheduling, or think we'll come back and get an
I think we
instruction?
want to hear. Oh, I thought no. There's going to be
I mean,
some
what do you think
talking.
the approach is about?
Everything,
All of it.
but it could just be how much time, because we also want to argue some shit, Judge. You know.
Yeah.
So
It
here's the
looks like it
thing.
was like 6 or 7 minutes. This little break.
Here's the thing. Under A, right? So she's charging under A, and under A, like the 2A of manslaughter, the intentional act, her little underlying thing, that is the law. He did an intentional act. That intentional act caused the death, and it wasn't excusable or justified. So it makes like no sense with culpable negligence under this way of doing things, because
What was the intentional act?
his decision to speed, this is what she's saying, his choice to travel at that speed, his choice to travel in that direction, his choice to set a course.
The direction change 9
The
seconds
direction
before
change. Right.
the tracking based on the GPS. And she's still kind of arguing slightly the 2C argument, but I think it's so far overshadowed by her emphasis on the intentional
Well,
driving.
because for 2A, all you need, it just has to be, or you have to, the only way it's excused is through ordinary caution. Usual ordinary caution is 2A, because it requires this intentional act. It is actually easier to prove here than culpable negligence, even though we're talking about, like, I'm trying to find one case where a negligent act is the intentional intentional act. Like,
That's what I'm getting at. Like, that's like saying me walking and putting a step forward, with one foot is an intentional act. Everything that he was doing, there was nothing negligent about it until somebody lost their life. I mean, flat out. Flat out. I mean, him having the girls on the boat, having music playing, him going full throttle down the channel, like, that's just commonplace. Like, there's nothing in and of itself. It's like the only way that it clouds the picture is because Lucy lost her life. But for that happening, no one would think that what he was doing was not reasonable. That's what everybody out on the water does. I mean, to me, that's not an intentional act. Like, to me, an intentional act is they would have had to have proven that he purposefully, with intent, decided to drive right towards the channel marker. Like, he didn't see it. It's clear that he didn't see it for whatever reason. I don't know. Like, that's never going to go away from me. I don't know if it was a glare. I don't know if he looked down at his phone. Like, those would be like, if he looked down at his phone, that's an intentional act wherein you could make the argument that it's foreseeable that you're going to hit something. I mean, like, just him steering the boat, chained all the changing course bullshit. I don't even like what? Like, that ain't it. I'm telling you, they're criminalizing straight up negligence here. It's not like he's
To the highest that manslaughter by culpable negligence allows. Too.
Yeah. I
Like,
mean, he's gonna get convicted. Watch. And it's going to be a combination of that homicide instruction, and that language is going to confuse them. They're not going to be able to separate the two in their minds. And, they'll send out a note, and the judge will say, well, what judges always say.
All
We
right, let's get
provided
through
you
this,
with
because
the-
they look like they go to lunch. So there's a
Okay.
little bit, it looks like maybe they kick the jury out, and then Howard argues.
I hate that. Wait, they're sending the jury to lunch before he follows up, so they get to sit there for an hour and stew on our
Yeah, but
bullshit?
then the other alternative would be they come back from lunch and only have rebuttal.
I'd rather have that maybe. I mean, like stewing on her closing for an hour, I think is more damaging than having her just do the rebuttal on, like after lunch. Because I mean, like the last word is the last word either way. Like to me, the gap in time after her closing without him standing up right away while the shit's fresh in their mind so he can rebut it. I don't know. I don't know. I don't know. What do you think, Bay?
I think
No, what
that
do you think about the timing?
They get to prepare during
I
lunch
yeah, I
too.
like that he I think I like that he gets time to think. I think that that's
What?
what I don't know. I mean, I understand your point. Obviously, you don't want them sitting with it for too long, but I feel like I would want that time to like breathe and us like powwow and be like, plus I think they have a lot of arguments that they need to make before they go to their
He knew what
closing
she
of
was
a
gonna
verdict.
say. There was nothing that was surprising about what she said or did in that closing.
Yeah,
Like,
but I'd want to use a specific quote as my opening if I were the defense counsel. And maybe they wouldn't do this if they are reading the jury a certain way, but if the jury isn't really showing much at all, I would want to get up there and flip back that why are we defending against something that wasn't charged? Like, I'd want to use that specific language that the state used, not just the concept or the expectation that she was going to trickle into those arguments, but her explicit language. Why is the defense defending against something that we didn't charge? And I'd say, well, because the state is relying on something that they didn't have evidence to bring charges for, because they also don't have enough evidence to prove these charges beyond a reasonable doubt without making you think about the possible impairment and wanting you to make the large inference, the leap to impairment, when they didn't put on evidence of impairment in this case. And that's what I'd want to go out starting on. Turn the state's words right back on their head.
So let's see if they start talking and get this chat back as soon as we can because
the
I'm
Yeah, let's
sure
do
problem
that.
with all that, and I agree with you, is that if there's an hour or 45 minutes and they've stewed on that, they've already made up their mind. That's just the way the human mind works. That's how juries work. Like I'm basing that on experience. Like to me, like I hear what you're saying, both of you guys. That 40, like if you think 45 minutes is allowing you any time to really, like Ali, think about us having a little like a half an hour to try to like you're not productive because your mind's racing. To me, you just got to get like, and I don't know that the judge gave him an option. I don't know that she was like, well, do you want to go right now or do you want to take the lunch break? And Howard's like, well, I'll
I
take
think
the
they
extra
decided
45.
before. I think they decided earlier. She mentioned something about it earlier, and I think that's because they had to deal with some jury instruction issues, and the jury didn't really get in until 10:30 instead of 9:30
Man, I
Eastern.
think their best hope is a hung jury here. And with six, it's rough. It's rough. This is a like a strictly like this entire case is an emotional narrative case. They're not winning on the law. They're going to win on the emotion. They're going to win on the fact that she keeps, you know, putting the picture of Lucy in front of the jury and the jury feels something because of that. And, there's going to be enough for them to say, all right, well, the guy, he was supplying him. He had all the booze on the boat, like shit that's not relevant at all. Like they weren't able to make any kind of causal connection between the fact that the girls had access to alcohol on the boat and what happened with the accident. The accident is the accident. Like that is all that they need to be focusing on. And Howard needs to steer them back to that. All the other noise that the state is trying to put forth to you as if it matters doesn't. Now, whether you agree or disagree as to whether or not 17, 18-year-old girls should be plied with alcohol and have access to it, that's your prerogative. But in terms of what we're trying to figure out here, what your duty is to figure out if they've met the elements for either of these two charges, and the things that they're talking about
And be upset
before
with the prosecutor for not charging it.
right and post. Well, I mean, he's gonna have to lean into that, but I don't know how much you lean into it because, like, I don't
Well,
want
I
to.
wouldn't argue it, but I mean, you sound like you were speaking to if people are upset and they think he's responsible and Lucy should still be here, and that the issue is that alcohol was being served to minors. I mean, then that outwardly speaking to the public, then that should have been the framework through which there were charges brought. And
Right.
I
Well, I
don't see
mean,
why you can argue that there wasn't evidence that alcohol was served to minors. I can understand why they didn't feel they had evidence to bring an impairment charge or BUI, but why couldn't they, if they wanted to, charge George Pino with supplying alcohol to minors? It seems like a bastardized application of prosecutorial discretion because they didn't want to charge other adults that were present that day and had the knowledge that minors either were partaking in or getting alcohol off their boat or were condoning it in any way, shape, or form. By that,
yeah,
I mean the
no, like
Fernandez family being there in person, as well as the
100%. But
other
my
voters.
point is that the issue is not what happened prior to or after. It's that simple. I mean, the state's trying to argue that it matters, that it's a totality of the circumstances, that everything that he had done that day, starting with buying them the alcohol and speeding and all the other shit. I mean, the speeding maybe you could make, and I don't know that it's speeding. The way that they keep trying to frame it, like he
Yeah,
was
and they said
acting
we
like some
know
kind of
we know it was
lunatic out
47, and
there.
they don't.
Yeah, it's a frustrating case, and it's terrifying if you're the defense attorney in there because Howard's obviously very experienced. He knows how juries operate. He knows that they're prone to convict, and you're sitting there trying to defeat an emotional case, and like this just isn't a case that's not built on emotion. It's completely built on emotion. It's no accident that she repeatedly keeps pulling that picture up of Lucy over and over and over. Oh, you see the girl in the flowered bikini? That's Lucy. Oh, you see the girl who's getting her chest pumped by the EMT? That's Lucy. It's like it's just I say it all the time because it's true and it seems cold, but emotion has no place in the law. It has no place in a courtroom ever, ever. And it's such a tool that prosecutors use in order to secure convictions. And I mean, you're pretty much hamstrung in terms of the defense in stopping it. They're always going to be able to wring the pathos out of these situations. I mean, a beautiful young girl lost her life. It was a tragic accident. And, I'm sure if George could change it, he would, obviously. Would he go slower? I don't know. Probably not. I mean, this is like what I do every time. Like this is exactly what I do every time that I've voted. Like I'm full throttle down the channel. Like there was nothing unusual about it other than whatever caused this disturbance to where he's not aware that he's coming up on the marker. Like that's like, and I don't know what the answer is. And unfortunately, neither does the jury. I don't know that he knows the answer as he's sitting here right now. I mean, it's distinctly possible that the man doesn't know. Like whatever distracted him for that, I would argue, very brief 9 seconds. It passes like 9 seconds is, you know, I mean, like when she demonstrated on her alarm, with her stopwatch or whatever she was using. It's like,
And she couldn't stop it. She couldn't
yeah,
stop the alarm quickly.
it's like this is just if we start criminalizing cases that are just straight up negligence, it's going to change everything. It's just going to change everything. If this was charged, if he would have been charged and they had the evidence for the BUI, then this case is a no-brainer. It's a no-brainer. But they haven't produced any evidence whatsoever, including the guy who came out of the woodwork later on, the fireman, saying, "Oh yeah, like saying the exact same thing that you see in a sworn statement by any law enforcement or first responder in terms of, bloodshot eyes, strong smell of alcohol, slurred speech. Every cop known to man, and I know that wasn't a cop, but they all write the exact same thing. That's like boilerplate language. And, you know, I mean, they didn't even put that guy on. So at this point, we have no evidence whatsoever from the state that he was in all impaired. You know, and they're pushing that so hard without having charged it. It's gross. Just is. And it's gonna work. It's gonna work. It's just gonna be, I mean, I don't know. I'm not gonna be at all surprised if he's convicted.
I wouldn't be surprised with any outcome with this verdict.
Yeah.
I could see an acquittal on because there are no lessers, but I think there's a risk of splitting the baby between the two charges. I don't know.
Yeah, I think they made a terrible mistake not including the lesser included that he allowed George to make the decision on. You got to say, man, look, this isn't the principle of the thing. We're trying to keep your ass out of prison, bro. You know, and that's a charge that we can handle with a 60-day jail max. Like that gives the jury the ability to be able to convict you of something. If they're not quite to where the state wants them to get on the felonies, this gives them something to hang their hat on. They can walk out and say, all right, well, we did something. You know what I mean? It's like that was a huge, huge blunder, you know, and if I'm wrong, I'm wrong. If they come back and acquit on everything, then so be it, you know. But like, man, I really would have been trying to talk George into saying, look, man, we need to do this. You know, it's like, because what is the argument against it? It's the principle of the thing. I'm not willing to allow them to convict me on anything with regard to this. It was a straight up accident. I don't know.
I don't know. I think there might be sense to it, but let's see because it looks like Howard's going to argue a little here before they get to lunch. So let's see if he does more than just the one issue where he outwardly objected.
All right, ladies and gentlemen, I think it would be most prudent for us to take, even though it's a little bit of an early lunch break, because I do not want to interrupt. The defense will make their close, and I don't want to interrupt that close for us to take a lunch break. So we're going to take a lunch break at this time until, I'm going to ask you to please be back upstairs by 5 minutes after 1. We'll take a 1 hour lunch break at this time. It's very, very important, ladies and gentlemen, wear your juror badges at all times, even if you're outside of the courthouse. Be very visible with your badges. They're well displayed. Very important, ladies and gentlemen, please avoid any kind of contact, eye contact, conversation with anyone wearing a juror badge. We've all worked very hard these last few weeks to maintain the integrity of these proceedings. The jury can have no contact or conversation with anyone. Even a friendly hello can be misinterpreted. So please avoid any contact with anyone. Do not do any research. Do not look up anything on your phones to try to gather any information. None of that is evidence. You can only rely on evidence and the law to reach your decision. Okay? When you finish your lunch, please go to the jury room, again on the 7th floor, where they will meet you there and bring you into court. If you would, please put your notepads inside the envelopes. I'd like your name to hold them and keep them in a private place during your lunch break. Okay? All right, so I'm going to ask everyone also, please just give us 2 minutes. Let the jury leave, get taken away from the courtroom, and then at that point we'll excuse everyone.
Bloop, bloop.
And I'm just going to ask everyone just to wait a moment or two, then I'm going to excuse everyone.
Convict. The trial court's attention is over on this issue that we raised sideline. So the prosecutor has suggested to the jury that their intention is enough to convict. That was essentially a contradiction to the jury instruction we proposed that Your Honor declined to give. It is now important for us to know how the court is going to instruct the jury, because the case law in Esposito is the case that we cited as to special homicide. I believe it's Miller, the case that we cited as to manslaughter. Mere intention is not enough to convict, yet the prosecutor has now total jury back. And so I'd like to ask the court to guide us on what that instruction will be, because I certainly was planning to explain to the jury that principle of law, but we're not in sort of no man's land, no person's land, because I need to know if the court's going to grant my request to instruct the jury that inattention is not sufficient to be there.
Which was a supplement and specially requested instructions. Yes, they are. The court is going to give the instruction as previously indicated, that his argument, and you may make the argument you think is appropriate, in the context of how there is no objection contemporaneous to these statements actually throughout the entire state closing.
What?
Even as it may, any statements by the state are, I did not interpret that there was a specific focus or statement to the jury that alone would constitute a crime, of the crime charge. So, I understand your point. I'm not going to change what would be the standard instructions. I'm not going to include.
She said there was no contemporaneous objection.
For example, again, I believe this is part of argument.
On the mere intention is not enough to convict language specifically.
Yeah, he didn't object enough.
Welcome to make those arguments. All right? Very good. Ladies and gentlemen, we're going to be in recess for lunch until we're going to get 10 after 1. 10 after 1. Thank you.
Get the chats back up. All right, chat should be live over on my end. Also, we've got some Venmos. Thank you guys for sending these Venmos. Definitely appreciate it.
Yes.
Angel said that this prosecutor is killing me. I need the chat. So chat is back. Come get it all off your chest. Now is the time during this lunch break. Thank you so much for the Venmo from Angel. We also have from GA Cat Mom says, I never truly understood the importance of jury instructions until I started following you guys. Thank you for educating us, in parentheses, me. So shout out to Defense Diaries with the great breakdowns, looking up Westlaw live on the fly to help us understand.
Westlaw Live with Defense Diaries.
All right.
We got
so,
Misty here. Oh,
no, go ahead. Go ahead. Sorry.
yeah. Misty said, is all this crap she's saying reversible error? She has no evidence for any of it. How is this judge letting this go on? Well, no objection.
There you go. Yeah,
And-
judges aren't going to independently just stop a prosecutor unless it's something insane. Like typically one of the sides has to object before the judge is going to sound off. Like the judges aren't going to, say anything. They'll just sit there and you have to object. It's like what Ali was just pointing out. Judge said you didn't contemporaneously object when it was going on. What do you want me to do about it? You waived it.
I mean, I honestly think that Florida is either going to have to change their law or because they used to have like intent to kill as part of the intentional act definition of manslaughter, and they like removed that. So, I mean, manslaughter by culpable negligence, right, requires proof that the conduct of a gross and flagrant character, demonstrating a reckless disregard for human life, amounting to the conscious indifference of, and there was something like it's that it's likely going to cause death or serious bodily injury. Like there's some language in there like that. Like you have to like know or have reason to know that it's going to cause death or serious bodily injury. So the culpable negligence one is definitely one that is more than ordinary negligence, more than mere error of judgment, all of those things. But when it's like evidence of the intentional act part, they don't need any of that. The intentional act requires that the defendant deliberately engaged in conduct causing death. So, and I've looked at the law, babe. There doesn't need to be that causal like connection, although it's typically something like you punch someone in the face and then they died. You know what I mean? So you intentionally punched them in the face, but it wasn't, you didn't have any intent or think it was.
But that in and of itself is an illegal act.
Correct. But so for that though, it just requires proof that they engaged in conduct causing death and showing something I think like, I mean, it's like, and wasn't acting in ordinary care. It's like kind of crazy. So, like for driving in an unsafe manner, if the if I can't find one case where I literally put in drive exclamation point, so that catches driving, drove, well, not drove, but driving, drive, um, operate, catching all of that in the same sentence as speed, unsafe, in the same sentence as manner and condition. So that should capture everything from driving an unsafe speed, driving unsafe or speed, due to the conditions, unsafe under the conditions, like kind of capture all of that. And I went as far out as end, like intent, which would capture intent, intentional, intend, and act to catch act and action in the same paragraph as manslaughter, not one Florida case, period. Like it has never been discussed where they have tried to do the manner of operation as the intentional act instead of culpable negligence. So it's when she held up that thing and underlined it, if the judge is letting her have it where, okay, we're calling the intentional act the man that you chose to drive like that.
That ain't it, man. That ain't it. I'm just telling you that ain't it.
But it
Like,
is
that is not
bizarre.
culpable negligence. It's just not.
It is bizarre given this. Let me play it, babe. Now I can
Yeah,
play
let me know when you pull
yesterday's
it up.
without taking the chat off, right? Like a
Sure.
quick blurb from 2 days ago. We're going with it.
We can do this.
Whoop, whoop, whoop. Okay, let me go back.
Oh, wait, I gotta remove this one.
Parts to that.
Well, then, that's why I'm saying they conflict with each other.
I'm not sure I agree. But I
Let's just hope the state doesn't argue in closing using that instruction and say, here it is right here. It's only excused if it's ordinary caution,
I would think that would be an improper argument.
which is why I don't want the instruction submitted to the jury.
Okay, I mean, that's the only part we need to hear, right?
Yeah.
I mean, am I crazy?
No, you're not crazy. We were saying that when it was happening. Like, I mean, we were making the same look, man, boats are recreational vehicles. Like this concept, people buy boats so that they can entertain on them. Like you buy a boat. If I'm
Yes,
buying a
Aaron.
fishing boat, it's because I'm going to go fishing on it. It's a recreational activity that I do. If you're buying a boat like this and you're getting it for the express purpose of entertaining people on it, like this concept that 47 miles full throttle is crazy or in and of itself is negligent is total bullshit. It's not. Like the one boater on there, if that person is being intellectually honest, to be like, I'm full throttle all the time on my boat. This isn't a cigar boat. I'm not doing 100 miles an hour flying like I'm like hovering above the water because I'm going so fast. This is like 47 miles an hour. And in her comparison to a pickup truck where no one should be sitting in the bed of a pickup truck ever. It's like we've had our kids ask when we're like out in the country, like, oh, can we ride in the back of the pickup? Like even in those circumstances where it's rural, I'm like, no, it's not safe. That is not comparable or not comparable. It's you just can't. And she's putting him on the other side of the road, driving on the wrong side of the road, and then plowing into a telephone pole. Like it's like none of that is even remotely close to what happened here. This is a guy who was just trying to get back. And if they could have proven that he saw the marker and consciously made the choice to try to cut in from it, then it's a different case. Then I think there's a stronger argument for culpable negligence because that was an intentional act. I saw the marker. I thought that I can make it. My judgment was off. I didn't make it. Somebody died from it. That's the intentional act to me. Is he has to have seen the marker. He knew it was there because he was there on many occasions prior. No, I'm sorry. It's like I've driven our roads a million times, and like I'm not going to know where I'm at if something has my attention other than my eyes on the road, which clearly, whether it was the glare, if I'm Howard, I am leaning into, like Ali said, I'm putting that video of hers up and I'm saying, all right, like I'm going to let the picture speak for itself. What do you see in this picture? People will be like, wow, it's pretty heavy glare. Because I mean, the sun couldn't have changed position that much, right? I mean, I don't know how long did it take the Coast Guard to get out there once the boat was down?
I think it was like a
Seem-
40-minute difference, like 30-minute difference. But we had, did they show Bruto's in closing? Was that Bruto's video? That was Bruto, right?
I think so. You mean the
Because he would have
one?
been the first body cam video then. So he got there quicker than whatever the guy's name was who showed up and was like talking trash about Bruto.
Oh yeah, that guy. How is Bruto never been, like how is he still going? I'm like, it's exhausting standing out there. It's like my back hurts, my leg hurts, all that shit. Like, I don't know how he does it. He's slacking out there. He's not doing the real work. That's what he was implying.
Yeah, so with Bruto, it would have been way closer in time because the other guys, they started getting there like 30 and 40 minutes later, but Bruto got there before they did. So,
Yeah,
and again, I think
like,
the sun takes a long time to go down. It's not like just because sunset is demarked as starting at 1 minute doesn't mean it takes a minute for the glare to go away. Like, I don't know if you guys have ever driven when the sun is coming up or down and you're driving into it. It is not a fun time.
it is blinding. You can't see shit. And
So-
like we live out west, so like every time we're driving home, even on the expressway, and the sun's coming down, it is blinding if it's a sunny day. It's just you can't, like I have my sunglasses on, I have my visor down, and it's still like you've got to find like a like a spot to where you can kind of see the road in front of you because it's blinding. I mean, have we looked up
That's
when
kind of what I
sunset
think.
was?
There could have been a boat, like a slight angle away from where you'd be looking at the glare. I think that could explain the change of course. It's not an intent to start going towards this channel marker that he also didn't see.
Right. Well, I mean, that's I mean, we don't know if he saw any of the preceding channel markers either. Like, what time did the sun go down? Like, what time was sunset? Do we know that day?
It
Because if
wasn't evidence. I don't remember. They
Yeah, I probably have it
definitely
in
put it
notes.
in there.
Do you guys want to do Sarah's Venmo? I'll look at my notes.
Yeah, Sarah sent a $5 Venmo and said, can't prove it, didn't charge it, but I'm going to include it in my closing anyway. I cannot stand this woman. So hard to watch without being able to scream about it in chat. Thanks. Thank you, Sarah. Yeah, trust me, we are all three of us missing the chat desperately. So it takes a lot of the joy out of live streaming a trial, not being able to really hang with you guys and fire back. Because I know Kat's very active in chat like I am during our stuff, and I'm typing and reading, and I enjoy the back and forth. It's part of the enjoyment. It's part of why we do this. It's a major part of why we do this. So yeah, this has been like kind of an eye opener as to what YouTube would be like if we didn't have live chat. It would suck. It's like it would be just like doing videos all the time. People leaving replay crew messages. It's a whole different vibe. So yeah, we feel you. Thanks, Sarah.
Yeah, so I've got 7:43 was the sunset on that day. And then also I see a note right in my notes that they were asking this witness with, I think it was Paul Albert, they were showing some, well, no, what witness was this? On day 3, They ask, oh, I think it was Cecilia Pino. They show her a photo and ask some questions about a clip or a photo for still frame from a video. And then I noted to myself that there's very visible sun glare, and the stamp in the video was 7/18. It would have been 7/18. So that's a different video than Bruto's. That was later than Bruto and still had the sun glare. So
What
we'll
was
just have
the
to see
date
if
of
the
the
defense brings
occurrence?
those in. September 4th, 2022.
Okay.
And then I think this was from you guys, right? For Defense Diaries. Angel sent a 25 saying thank you to you both.
Yes, our Venmo angel Kim,
Thank you, Kim.
who always gives us the love daily. She's amazing. Thank you so much. We adore you so
Okay,
much.
so name is Angel. You add the angel. I mean, name is
No,
Kim.
she's
You add
our
the angel as a title.
yeah, she's our daily Venmo
Hey,
angel,
there we go. Love
Kim.
it.
Yeah.
Sarah has a fun one here to you guys.
Read it, babe, because I'm looking at this. I'm looking at something.
So Sarah sent a $5 Venmo. Objection, F face.
Exactly.
That's Ali internally, probably.
Yes, no, that is.
Yeah.
Externally as well.
And then Carol 593 sent $10 and said, "Good morning. Please play the judge's response and bring back the chat so we can participate in the discussion. Thanks."
Yeah, this was us earlier with not hitting the play button.
Yes. Yes. And thank you so much, Carol. We appreciate you so much. And then that's you, right?
No, that's you.
Oh, so Nikki Lewis, member for 3 months. Thank you very much for that. IAC, IAC claim coming. I mean, not on direct appeal. And look, Howard's still going to give his closing. So, it's like he can undo some of the damage, but he's got to be very compelling. But he is a compelling attorney. Like he is very skilled in orating, and he has a deep understanding of the law. And I think that he has the ability to be able to kind of break it down for lay people so that they understand the concepts that he's trying to put forth. So, I mean, we'll see. Like right now, I feel like the jury is going to convict on something. And I'll see how I feel after Howard gets in there and takes his shots and see what he can mitigate and clarify for the jury. It's like if he doesn't spend a fair amount of time on the homicide definition for excusable homicide and clarify that is not the standard that we're talking about here. It has nothing to do with what we're talking about in this case. And so don't impute it. Like, don't have it hanging around in your brain. Like it's not what has to be met. I'm assuming that'll be the first thing he's going to address. I would like to see him pick up her demonstrative and say this thing she underlined and wrote in red that she wasn't going to harp on, but what she did harp on, it's of no value here for what you have to decide.
And it's a precursor to what really matters. The charges here are manslaughter by culpable negligence and the vessel homicide, and there's standards beyond that general language that must be proven. The state must prove beyond a reasonable doubt that all elements have been met and then go into it. And I think that is going to be a big issue. I think what's going to be an issue is I expect that the state will object when the defense is trying to do their argument, right? And the judge has said it on Friday, said it today, that, well, I'm not going to change the instructions I'm reading to the jury, but that sounds like argument. You can argue these things that are pulled from the case law. I just have this feeling that the prosecutor is going to object when he gets into those arguments. And I think it'll come down to whether or not the judge sustains or overrules those objections. If she sustains the objections, it's going to look like a rubber stamp to the prosecution's case.
Yeah, I agree.
Like basically stamping the prosecution's argument of the case as the instructions if this ends up being sustained, if it's objected to. So I don't know.
Tehef said, not me just joining this trial today. Laughing, crying face. I've been so busy, but I passed my teacher's cert exam. Congrats, Tay.
Aw,
It's amazing.
congrats. That's awesome.
That is awesome.
I hate to just pop in
You can
here
do
off,
whatever you want, baby.
but why have we heard nothing about the upgrade here? Nothing about the use of a weapon. Not did I miss it in jury instructions? Because it's a pretty big fucking deal. And I don't recall the special jury instruction about it. Maybe it just was like something that they were like, oh yeah, there's this, there's that, and it never came up again.
I think they started to mention it and then never actually opined on it. Because I
The
remember making a note on Friday.
the prosecution hasn't brought it up. I mean, maybe the law in Florida changed and I'm missing something and it's no longer, something a jury has to decide. But I thought that the law that we looked at was pretty recent on that. I don't get it.
So when I timestamped it, it was like 4 hours and 15 minutes into our stream. So it was towards the end of the day, and it just says arguments about weapon special verdict. And then the next thing they started talking about was a discussion of the initial misdemeanor charges. So to me, it seems like they veered off topic and didn't actually give us a conclusion, because I didn't take any notes and I don't have a memory of them saying one way or the other if they're going to do a special verdict for him on that.
So would he have been heading southeast when he's veering toward
the sun would have been off his right shoulder, and so if he veered left towards the channel marker, the sun would have been over here. He would have been quote unquote veering away, if we're going to call that veering, where he does that final last track mark, that his change of direction would have been like away from the sun.
But so he's heading southbound in a southward direction. But what I'm saying is when he goes towards the flat, he's heading southeast, right? Because he's heading south. I think so.
Yeah, so the boat was traveling southwest, so his turn, I believe, would have put him slightly more, but not necessarily east.
Okay.
If that makes sense, because the testimony I have highlighted, and the boat was traveling southwest. Yes. So the sun was off the operator's right shoulder. Yes.
Okay. All right. I'm asking the robot. I'm seeing what the robot has to say about all this. Let's see what it says. Did you read that one?
Soap here says, I hate that woman. I truly hate that woman. I'm assuming this could apply no matter who was doing the arguments. Thank you for the super. I kind of wish it was just, I knew it wouldn't be. Of course, Laura's going to do the closing arguments. But I think a borscht closing argument could have just been like plain, to the point, to the law, to the facts that are actually evidence in the case.
That's the problem for them, Kat. Like
they don't want to do it that way.
They can't do it that way. I'm telling you, this is an emotional narrative case. There's some cases where if it's close on the law and the law is a little bit murky, they're going to lean into the emotion of it. And that's exactly what she's doing. 100%.
I agree. I agree.
I mean,
we have Flowaskis saying, maybe it's Flowaskis or Flowaskis, says the quote unquote, got to do the air quotes, the reenactment is missing the loud music, people in every seat dancing with their arms in the chair, and equivalent time of day and tide. How did that make it as evidence? Thanks for covering this. I agree. I have issues with the reenactment for several reasons. I don't think it's a compelling argument that the state made that, and even overnight, Paul Albert went and looked at the sun information, and he came back and he told you about the sun. The state was arguing that was supposed to help their case, show that their expert was doing due diligence. To me, the time to do that due diligence is not in between when you get called back to the stand during the defense's case in chief. That's something that you should have done when you're planning to do this recreation.
Yeah.
But the way the state argued that, she made it seem like it was just such an endearing thing for the witness she originally called to do this last minute. Oh, I forgot. I probably should have cared about the sunlight because they're talking about the glare now. So, and also the reenactment, I think it's a different boat. The boat looks like it's made of heavier materials. I don't think it would steer the same way. But I don't really know. I don't know the exact difference between the two boats. So, I agree. I think it was very different, and I'm sure we'll hear a
Well, I
list
mean,
in closings from the defense.
Laura Adams like can tell us that she's never been on a boat with kids without telling us she's never been on a boat with like the music
just
was
cargo.
cranked. The music was cranked. I guarantee it. Like the music was full max volume. The girls were all either looking on their phones. They were like, I guarantee, like her sitting there acting like all the kids would be like this. She's just full of shit. It's like the woman's never been on a boat. Like them going cruising along, music's cranked. The girls are a little bit buzzed, which sounds like some of them were. They're partying. Yes, they're sitting, but they're still they're they're engaged in activity. They're not all sitting there like mortified, like we're statues. Oh my God, he's going so fast. Oh, yeah. You know what I mean? That's just not reality. That is not reality of the situation at all. Like it's just all right. So this is what the robot said. It said, here's the geometry using the sun's position from a moment ago. And it says the sun would be off the operator's starboard bow, front and to the right, boat heading southwest, 225 degrees true. Relative bearing 47 degrees off the starboard bow. So the operator looking straight ahead has the sun about 47 degrees to the right. The sun height is 12.6 degrees above the horizon, low, near eye level. So what that
So it would
means
be under that cabin protection of the boat.
right. So it says what that means for glare in practice. The sun sits in the forward right portion of the operator's field of view, low enough to be roughly at eye level rather than, and I put in the time of the accident. Low enough to be roughly at eye level rather than overhead. To look directly at it, the operator turns the eye's head about 47 degrees right and tilts up only 13 degrees. That's squarely within the zone a helmsman scans while watching the water ahead and to starboard. So it says two glare sources stack here. Direct glare at 12.6. The sun is low enough to slip under most visors, bimini tops, and windshield headers, hitting the eyes directly, as you were saying, and then reflected glare off the water. The sun's reflection, the bright glitter path, runs from the sun back towards the boat, also off the starboard bow. On open water near sunset, this creates a washed out, shimmering band that can hide objects, swimmers, debris, or low profile craft on that side. So, net effect on an operator on a southwest heading at that time, had the sun working against them precisely where they'd be looking for hazards forward and to starboard and low angle near sunset glare is mostly visually impairing condition. If this is for a case, I could build I mean, it seems like maybe they should have had somebody dealing with the glare issue, an expert.
I think they're going to rely on the video footage plus the testimony that it was on the right shoulder. I do think Howard asked good enough questions across the witnesses to get this information in a way that he can argue.
Yeah.
So, and I think it's the most important thing because to me that could explain why somebody, especially if the channel marker you're about to approach is 5 feet shorter than all of the others, you might not be able to see that combined with the idea that, the sun is just hitting in this weird way in this moment that I like, whether I consciously tilt the boat a little bit, because it kind of looks like it could just be a nudge. You ever sometimes you see a glare, your instinct is to kind of go like when you look in a direction and see the glare, you kind of just like jerk
Yeah.
your body one way. Like maybe his hand nudged as his body moved as a reflex to seeing the sun when he turned to look the other way.
Or maybe he doesn't see the marker at all.
Yeah, I don't think he saw the marker. I think he was just his focus on the reason for the turn could have been because of turning sun and eyes. Let me just go this way a little bit.
Yeah.
And marker's not visible when you're also making that turn for you to go, oh, wait, I got to turn more or turn more the other way because there's going to be a marker if I just do this.
Yeah.
So,
Yep.
so I don't
Yeah.
know. And I'm sure we're going to hear that this channel marker was 5 feet shorter. That's not a negligible amount of difference in height.
So music to my soul. Thank you very much for your super. Why do courts require contemporaneous objections? What does it matter if they're objecting now when the prosecutor is still going to get a rebuttal? Well, I mean, the way that you always have to think about the record is that is all the appellate court is allowed to look at all. So say, for instance, you are objecting five statements later, the appellate court's going to have no idea what you're objecting to, and it's not a clean record if you're going to say, okay, well, I know that the prosecutor said 5 or 6 things after what I'm objecting to. I'm objecting to when she said that. You just have to make the objection when it happens because of the fact that that's all the appellate court has to go on is the court record. So you need to make a clean record. That's why you have to object contemporaneously. I mean, maybe he could have at the end of it said, I object to her entire closing. Everything that she said and did, I object to all of it. It was all objectionable and I hated it. And then, the appellate court said, no, that's not going to do it, buddy. So you just have to do it contemporaneous. Like there's that old lawyers always tell you if you fall asleep at the table, the first thing that you do when you wake up is you object. So, but Ali's right. There's kind of an unwritten rule, and it's not just for defense attorneys, it's both sides.
Yeah, but they never do it. That's why I say for defense attorneys. But Bob is right. It's supposed to be for both sides. But I
Right.
hear prosecutors doing it all the time, like a bunch of babies.
Yeah, but it is an unwritten rule that we try to avoid objecting during closings because it is argument. Closings are not openings, right? Opening statements are just that. They're statements wherein you're trying to lay out what the case is, what the jury's going to see in terms of evidence coming in, giving a narrative, putting your story out there for the first time, saying, hey, this is what we think happened, and this is the evidence we're going to provide you with to prove it. And, in closings, that's where you're arguing. It's where you're making all your arguments. So they're very different beasts. And, could Laura Adams make the argument that her whole thing about the fact that he lied about, what he claims caused this in terms of there being another boat and a big wake, and that you can now use the fact that he's a liar with the fact that he lied about how much he drank. I mean,
P.S. Supreme Court of Florida in 2019 says, in the absence of a contemporaneous objection at trial, which I guess would also mean at closing, a jury instruction error is only subject to relief in the event of fundamental error. So maybe actually that might be, ignore me, strike it from the record, continue.
Hey, I appreciate you looking it up though.
Flowaskis says, maybe it's Flowaskis, I gotta figure out the phonetic, says, if this isn't an accident, what on earth is? Intent? It's crazy. Everything is criminal now. Also, she's V-I-L-E vile, the prosecutor. I think I would not be so. I get a lot of comments, and it's not unusual. I pick cases where I'm confused about how a case is charged, and you guys might see why I have that confusion about this case. This case wouldn't have interested me if either we had a field test done, a warrant was obtained, and we had a field test done at the same time, and or we don't have this 0 blood alcohol level reading a few hours after 11 p.m. at the hospital, where if somebody was inebriated, I'd still expect a reading, not
Yeah.
0.
Yeah.
But additionally, even without that, where we could support a BUI or mention all of this alcohol usage and not do these air quotes about 2 beers, if this had been charged differently, I don't think this case would have interested me either. Like, initially, the charges were misdemeanor charges. I think they could have proven their case if they took this as a misdemeanor case without me sitting here going, why are they doing it this way? Right?
Yeah. Well,
So,
plus he probably would have pled out to one of them and, been a fine, maybe some community service. I mean, if the misdemeanor charges had stood, this isn't going to trial. They're not streaming it. You know what I mean? It's like the same reason that Law and Crime and Court TV decided, okay, this is a good one to stream, was because of these charges. You know what I mean? It's like the charges are crazy. And it's like, from my perspective, it's the important part of this case, especially in Florida, is it's going to set a precedent. If he's convicted and it withstands appeal, I mean, they really have criminalized negligence. Well, I mean, to me, this is a civil case. Like, all her bullshit about the things that George was doing. He said he wanted to settle, but then he's doing motions to this. I'm like, man, like that was the whole point of me kind of belaboring the point that these are insurance defense lawyers. It's their job. Like, they're trying to mitigate damages for their employer, for the insurance company that are representing, because they're trying to keep, whatever money is going to get paid out to a minimum. Like, I mean, it's literally their job. Somebody sent a comment on like our chat. They were like, "Oh, I work for," she's like, I was disappointed on your take on insurance defense firms and insurance defense lawyers. I mean, it kind of is what it is. Like, it's not a judgment on them as human beings. It's probably my least favorite area of the law in terms of litigation. Just
But,
because
we do have to recognize there are litigious people, and sometimes they
100%,
make false claims, so insurance.
totally,
Right.
totally. But for every one of those, there's people that are legitimately injured.
That they're just fighting tooth and nail not to pay.
They're fighting to the death on it, like liability. And soft tissue is very hard to prove. That's like that's your typical whiplash case.
I mean, try to even get the value of your car if your car is totaled. They are supposed to give you the value of your car is supposed to be enough to buy the same car right now, and that never happens.
No.
You got to fight tooth and nail for every penny, even just to get the value of a totaled car, or like when someone's house burns down and it's not enough to build the equivalent house.
Yeah.
And then they have to spend
mean,
like hundreds of thousands of dollars getting their own lawyer and their own insurance adjuster to force the insurance company just to pay the right money so they can rebuild their house.
Yep.
also, big salute here to Sheriff Chuck with another 5 gifted. Let's get some W's in the chat for
Woo,
the Sheriff
Sheriff
Chuck.
with Mosey's on in. Oh, how you doing? Ma'am, let me kick you with some memberships over here.
Oh yeah, we
Okay.
learned about the bouncy chair earlier.
Oh, yeah. Yeah, the yoga ball chair. They're pretty good. Ali abandoned hers completely.
What? Abandoned by what?
So
We've got
yeah.
Oh my
this
God.
is a different Angel, actual name Angel. Says, I mean, how tall is George? It was too short to fit in these pop-up things, so I got to read it on the side. Says, I mean, how tall is George? I'm extra short, 4'10". Shout out to the shorties. Aw. Sun glare hits me all the time. If I'm on the jury as a short person, I'm going to notice that glare in the picture and take it into account because glare is one of my many arch nemesis. Oh no.
Babe, do you live in the world of glares?
Yes.
Visors don't work for Ali either.
I mean, I just don't really wear visors, I guess, enough to know. Tell you
No,
the
she's
truth.
talking about
Well, like the car
visors.
ones.
Wow.
Oh no, those don't work. No. I gotta like. My mom sits on a pillow.
Yeah. And I have a stack of phone books for Ali to put on.
Jack.
Hilarious. Well, thank you,
Uh,
Angel, for that. And I think I don't remember hearing a height about George, but
Yeah, we
wasn't the
did.
state? I didn't catch the
I think it was
exact
like
height.
5'8", 5'9". I don't remember.
And then the state, I was gonna say, I remember it being shorter, like something like shorter than me, or like my height. And then the state wanted to use Paul Albert, who's very, very tall. He's like 6'7", to discuss like, oh, well, if someone's taller, they could be like the visor of the center console, the hood of where you'd be standing as a captain. You wouldn't really be able to see the sunlight. But the problem with that is Paul Albert hadn't done any research on the sunset and any of that. So what was he even speculating about or opining about?
Yeah.
Because he had to go home and do the research. He came back the next day, and next time he was on the stand, then he did that research.
It
Which
was
just seems
crazy.
stupid.
Yeah.
Oh, wait, Paul Albert's 6'8"?
Yeah, he
Jeez.
was tall. That guy was
So
tall.
it's like a foot difference between him and Pino.
Yeah.
They
And I
stood
remember
next
they
to each
asked
other.
another witness too, like, would you say he's like, I wouldn't say he's small. Something like that. We also have BMAC, Nana Banana saying, you all are awesome. You too. Thank you. We have for Dread saying, Bob, I told you the glare with the sun was my main concern of what could have caused this from my experience operating boats in the same area for years.
For Dread knows. For Dread
I was
knows.
gonna say boots on the ground, but I guess it's boats on the water.
Yeah, thanks, for. I mean, you have been saying it. And I don't know if you were on. Kat threw up. We didn't play the video because you had music, which would have probably got us a ding. But when she showed the still frame, what we're assuming is your boat or the boat that you operated. So we,
Pretty nice boat.
yeah. So thank you for that. Thank you for
Yeah,
that.
giving us the perspective of like the GPS and the vantage point. Also, for Dread with the second follow-up said, also another critical thing that sometimes when driving the boat, the wind blows hard in your eyes, even through glasses, making it hard to see. So
Yeah, 100%.
and maybe even worse if you're like someone's trying to show you something and you turn your eyes to where they're facing you, the back of the head would be to where the air is coming in, but you turn to look at something they're showing you and it's like
Yeah, for me at the end of the day, like the concept that the intent is that he was going fast. The only thing that they need to prove in my world is that he intentionally put himself on the course of that channel marker. Like he knowingly did it, intentionally did it with the thought, I'm gonna bust out and I miscalculated. It's like they just didn't prove that. You know what I mean? If we're under the premise that he didn't see it, there's so much reasonable doubt as to other things that may have caused it. And would it have mattered maybe if he was going a little bit slower? Would the boat have done the same thing? I don't know. Maybe not. Maybe. I don't know. If he still didn't see the thing and he struck it, it's like, to me, I don't know. We'd need a real accident reconstructionist to say, okay, well, if he was going 37 knots, this would have been the likely result. Like the boat wouldn't have capsized, or something like that. I mean, maybe then you can make the argument, but still, if his intent was not to try to cut in front of it and he just miscalculated, meaning he did change his course, seeing it, knowing it was there, and just miscalculates and hits it, then I think you've got a case. Because that's foreseeable. That at that speed with the weight of the girls up front, you trying to do some kind of close call maneuver to cut right in front of that thing, and then you misjudge it. I mean, is that foreseeable? If you don't see it, I just don't see the intent side of it, like, at all. Like the other things that she's trying to cram in the intent bag, I'm not buying. But I don't matter. It's only the jury matters, and the jury in the totality of the circumstances, because she's been able to argue, oh, he's doing 47 and he's got 1,000
All right, we have
pounds,
we have
and
action in the court.
oh yeah, let's go.
Also want to give a thank you to Soap, who says Laura Adams is telling us she's never invited to parties without saying she's never invited to parties. I don't understand her distinguishing between precious cargo. Like, would it be different if it was strangers on board? I don't think that's a strong argument to make. So I feel you. Thank you for the super. We
Yes,
have
thank you, Soap.
next witness saying, sorry if I missed it, but are there any lesser included charges, or is it all or nothing?
It's all or nothing. There should have
Yep.
been. You were a little late for that convo on Friday during the instruction conference. It was put out there that there was a lesser included that I thought would have been super tasty. I think it was a max 6 months if he was convicted
I thought
on
he
it.
said 90 days or something insane.
Or 60 days. I think it was 60 days.
60 days.
And they got George on a Zoom, but I think that they spoke to George prior to, and George, they're claiming.
No, I thought they said that the lawyers had changed their mind and they were recommending he does not.
I think they worded it like that. I think that it was his decision, but they worded it like that because they changed what the advice of counsel was.
I want to go back.
They did it for his own
I've got it. I got
precaution.
it booted up. I'm going to listen right now.
Yeah, because Juror, they specifically said George, our client, does not want to do that because there were two things. There was that, remember? And I was like, okay,
and the concession.
Yeah, when are they going to get to the concession? When are they going to get like that? That's not an express concession, which I still don't think they ever did.
All right, so here's what they said. I got it. Okay.
I love that you guys are finding Katt.
This is old footage, by the way.
I hit her up.
Okay, so it says,
let's do this together. She's like, let's do it. I knew you guys would love Katt.
Okay, so it says, we have informed her that you have told us that you would abide by the advice that we have given you on the requested instruction, that you've referred to us because you don't have any legal background, and that you were relying on our experience and advice in how best to present those instructions for the court's consideration. As well, we've informed you that there was a discussion about a lesser included offense. It would have been a misdemeanor offense, the misdemeanor offense that you were originally charged with, which brings a maximum sentence of 60 days in jail. It is not a felony. We discussed with you that option, and that you had advised us that you would not be seeking this lesser included at this time, which means it won't be presented to the jury as an option for them to deliberate about. Did you understand everything I just said? And continue to prefer to follow the advice that we gave you, including declining the lesser included offense. He says that it was their advice.
Dang. That's bad advice.
I know.
I think he's saying it's at his advice that way in case he wants to challenge it, that there was no strategic decision or something. But I think it was George Pino's decision, honestly.
I mean,
yeah, the way that I heard it, is that the whole thing?
That's the whole thing when they come back, which surprised us because before the break, it seemed the defense wanted the lesser. He asked for the lesser.
Yeah.
Then they asked to talk. Then they called the defendant. Then all of a sudden they got back and they said that you're following our advice not to go with the lesser. So maybe Katt could be right. There's no way for us to know, but they were pretty confident that this guy was going to follow their instruction and would do whatever they said. And maybe that is why they went through this whole long spiel to allow him to claim it was their fault later. But I don't know why they would set themselves up that much. Like, go on the stand, go up here and say all of that when it was against the advice of counsel. I mean, most lawyers would say against the advice of counsel, he is deciding to do X, Y, and Z so that they're not the ones looking like shit later.
Well, plus it builds in ineffective down the road if need
Right.
be.
Well, it bars against it if they said it the way I said it. They're saying it the way they said it, which Katt's saying is on purpose to help him later.
That's what I'm
But-
saying.
Right.
That's, you know, if he had said, well, I was saying the same thing because I thought it was just George. Like I just remembered the part where George is saying he didn't want the lesser included, and then they add in that shit at the end.
Yeah.
You know, that it was based on advice of counsel, which makes no sense in the you know, when you're considering the fact that they had asked for it, like you said. You know, they asked for it, then they go talk to George, and all of a sudden, you know, now they're advising him that we don't do it.
Right.
It's just it's a miscalculation. It's bad. It's bad.
Yeah. Yeah, I
And
think that
why?
they were wording it for his protection.
Yeah, I agree. Throw at Forge right up. He sent another Venmo or another super. He's saying, did you do also another critical thing sometimes when driving the boat, the wind blows hard in your eyes? Did you do that one?
I think you
Even though glass is making it hard to see. Oh yeah, maybe we did that one already. So what's it looking like? Is there action? Is there movement?
Yeah, if you guys are ready.
Let's
Time
go.
to shut down the chat. I have it queued up. I know.
You're clicking it, right, babe?
Yes. Against
Guys,
my
see you
wall.
again at the end of the day or whatever. If there's a long break, we will, of course, bring you back sooner. If it's before the end of the day, we'll miss you.
We
We'll
love
miss
you guys.
Thank you very much
Bye.
for it's running to the chat when we enable it. I know it's annoying, but it's really awesome to see you guys like eagerly come back to the chat when it's enabled. I love to see it.
Yes. It's wonderful. It's all as it should be when we re-engage chat. It's the world is in its proper place.
Let me switch the banner. Switch the screen. All right, and we are queued up.
Oh, squeaky chair.
She's coming down. So she's coming down.
Okay. We didn't miss much. Oh no, if we shut the chat off just to bloop all this way. Uh-oh. All right, we have action right on time.
Everyone who's gonna see it, thank you. All right. Ladies and gentlemen, we are ready to proceed. Thanks with the case.
Thank you. I heard the prosecutor say to you, period. What I heard the prosecutor say to you is that in the moments leading up to the crash, with about 9 seconds to go, that George Pino was inattentive. He might have been looking over to his wife while she was trying to text a beautiful video of the girls who had a beautiful day over at the sandbar. He might have been looking at his GPS. He might have been looking over to his right or to his left, that he was inattentive. Those are her words. If that is true, if that's the state's theory, George Pino, your job is very simple. George Pino is not guilty of a crime. He may have committed human error. He may well have been inattentive. He may not have looked up in time to see the marker to which the Robalo alighted. But that does not make him.
What's that noise?
I don't know.
We have highlighted for you the law. After all, that's where we are. We're in a criminal court of the United States of America.
That was the
Where
prosecutor.
if your government, my government, wants to brand somebody a criminal, they have to prove he's committed a crime. Not that he was negligent, not that he has civil liability. Footnote, all civil liability has been resolved already, long before you were sworn in as judge. This is not a civil case. This is not about whether, by a preponderance of the evidence, the state or I should say, the injured passengers have established liability, civil liability. That has already been resolved. We are here today because our government wants Mr. Pino to be branded a criminal for having, by their own statement to you, been inattentive. Now let's look at what the law is, because we are, after all, a court of law. And what we've done is we've taken what we understand the judge's instructions of law to be before you on the screen. May not be so easy to read because of the distance.
What is that?
Somebody's moving their
There are two
microphone or
crimes that are
their
being
chair.
charged.
The camera might be
Vessel
spooky
homicide
in a certain
and
angle.
manslaughter. Each of them requires that the state prove beyond a reasonable doubt certain facts. And there they are before you. That George Pino operated a vessel in a reckless manner, likely to cause death or great bodily harm to another person. His reckless operation caused or contributed to the death of Lucy. What does it mean to be reckless? Different than perhaps negligent. Reckless operation of a vessel requires the state to prove more than a failure to use ordinary care. And so even if you were to find that the operator of a motor vessel failed to use ordinary care by not looking up and seeing the marker in the few seconds before it alighted, that would be, even under the state's own theory, negligence, if that's what the state has proven. Because to prove it to be a crime, it has to be so willful or wanton, a willful or wanton disregard for the safety of persons or property, intentional, knowing, and purposeful. Purposeful. A conscious and intentional indifference to consequences, with the knowledge that damage is likely to be done. It's not enough that a human being has failed to do everything he could or she could at a moment in time. This crime requires a purposeful act of indifference, a purposeful and reckless indifference to his passengers. If we looked at the manslaughter charge, it specifically tells you it has to be an act that's not merely negligent. It's right there in the law. An intent to commit an act that is not merely negligent. We turn to the next page. Culpable negligence. So you've got recklessness as one principle of law that the state is trying to apply against George Pino. They've also tried to apply this principle of culpable negligence. Sounds like negligence, but it's negligence plus a whole lot more. It's more than a failure to use ordinary care towards others. It must be gross and flagrant. Think of those words in your daily life, gross and flagrant. Like in the NBA, just came to me. People commit fouls, NBA, National Basketball Association. There are fouls, and then there are flagrant fouls. You know a flagrant foul when you see it. Flagrant. It's not that when the basketball player is going to the hoop and his arm gets hit by another player, even if by accident. That may be a foul. But it's only flagrant when it gets to the point that it's so intentional, so diabolical. And even then, referees have to go back to the screen to see just how flagrant it was. If we're going to put a man, if we're going to label a man a criminal, it's got to be flagrant and gross, with an utter disregard for the safety of others. And that when George Pino, think of it, that when George Pino that morning woke up, when he decided he was going to host a group of friends of his daughter, that somewhere along the line that day, his brain somehow shifted into this gross and flagrant world, that he made conscious decisions, because that's what the law required before we called him a criminal. And I'm sorry I'm getting a bit agitated. It's an emotional day, because we recognize that there was a lot of hurt that came of this event, a whole lot of hurt, a whole lot of pain. pain that endures till today and will endure beyond today. So we have to acknowledge that, because we all feel it. And I'm sure you felt it as the prosecutor over and again played videos of the injuries and drama and chaos that ensued from the crash. Heartbreaking. Seeing a young girl that we now know wouldn't survive that event. Having to see CPR and medical examiner photos. But the law says that we don't judge these events based on sympathy, because we all have sympathy for those that were injured, those that passed away, those whose injuries will continue on beyond today. But we don't judge someone in a criminal courtroom under these statutes based upon the injuries and the fatality to turn what would ordinarily be just an accident into a criminal homicide. I heard the prosecutor try to give you an example, and I thought it was telling. She said, oh, if someone ran a stop sign and they had a fender bender, that would be just negligence. I think that's what she said. But if that same car, same driver, ran the stop sign, but instead of a fender bender, a mother with a stroller was walking in the crosswalk and got hit and severely injured or worse, would that change the character of the manner in which the person who was driving the car operated that vehicle? The level of injury, the death that might ensue under those circumstances, does not then define the level of recklessness, the level of culpable negligence that we all are here to evaluate. And so with that framework, and with a further instruction that the burden of proof is on the state, if the government, your government, my government, intends to seek a criminal conviction, the government, the state, must prove its case. Not guess someone guilty, not speculate someone guilty, but prove that someone has committed a crime. And that's why the judge told you that we begin, each of us, as a citizen of this great country, citizen of the great state of Florida, we all start with the presumption of innocence. And that presumption carries with all of us whenever we are accused of something in a criminal courtroom until proven guilty. And the burden is proof beyond a reasonable doubt. It's the highest burden we impose upon our courts and our juries. You weigh all the evidence, but if there's not an abiding conviction of guilt, or if it's one which is not stable, but one which wavers and vacillates, then the charge is not proven beyond a reasonable doubt. And the law requires, as part of your oath, to return a not guilty verdict. That is the law. That's why we are here. And so, in evaluating the evidence, I'd like to first begin with just a few fact points that the prosecution has talked about. The prosecutor said to you she hasn't charged Mr. Pino with voting under the influence, so she doesn't understand why, I think she said, we have made such a big deal about Mr. Pino not being impaired. I asked you to recall the opening statement of the prosecutor when you first heard from her. And she said to you that Mr. Pino had 2 beers, and she did this little signal with her fingers as if it really wasn't 2 beers. And she said it to you again today, that maybe he had more. Maybe he had more. That is not evidence. A lawyer's assertion is not evidence. A prosecutor's assertion is not evidence. Just because she wants to argue it doesn't make it evidence. We had to bring out the evidence because the state was suggesting to you that it was more than 2 beers. That's why we are talking about it now, because the state is talking about it. And what was the evidence about beer consumption on that day by Mr. Pino? And we'll talk in a moment about the consumption of alcohol by the passengers and other people at the sandbar that day. Is there any evidence before you, even one witness, that has said to you that George Pino appeared impaired, buzzed, in some way compromised? Is there even one witness of all the people that were at the sandbar that day, of all the people that testified at this trial, Not a single person has said that George Pino was in any way impaired by alcohol. That should end it. We shouldn't have to talk about alcohol. But we have to because the prosecutor keeps insinuating that maybe there was more than 2 beers. Of course, the number of beers isn't the issue, since there's no evidence of it. It's the fact that Mr. Pino's consumption of 2 beers did not result in impairment. And you heard it from Lieutenant Thompson. He told Mr. Pino that it's perfectly acceptable over the course of the hours that Mr. Pino was there to have consumed 2 beers over several hours that afternoon. It's on tape. Lieutenant Thompson told that to Mr. Pino. Mr. Shapiro questioned Mr. Thompson, Lieutenant Thompson, who confirmed it's true. You do not break the law by consuming a couple of beers over the course of several hours and then operate a motor vessel. And you know that other adults that afternoon also consumed alcohol and operated a motor vessel, to include Lucy's dad. And no one other than the prosecutor is suggesting anything about the consumption of alcohol having affected the ability of any of the adults that afternoon to operate their motor vessel. That should end it. But it doesn't with this prosecutor. She continues to insinuate that you should find what's not proven. And certainly you can't find that beyond a reasonable doubt.
What a call out.
Later I'll go witness by witness to show you that this is not coming from me. I took notes of every witness's testimony on this and other subjects, and we'll talk about them. So that's the issue of impairment of alcohol. Let's talk about safety and speed. The prosecutor is emphasizing that Mr. Pino's motor vessel was traveling that day as fast as 47 miles per hour. Every single witness who testified that was on the boat, and I'm going to go through it one by one, felt the speed was safe. They'd been on his boat before. It felt no different. Nothing unusual about the way Mr. Pino was operating his vessel. He wasn't drag racing. He wasn't doing donuts in the water. He isn't like one of those jet skiers that's trying to jump weights and do all sorts of thrill-seeking activities. He was not, contrary to what the prosecutor said to you today, he was not trying to be the cool dad. I don't know where that came from. The cool dad. That Mr. Pino, according to the prosecutor, was in some great rush to get back to Ocean Reef because the party that he had planned for his daughter was going to start at 9 o'clock. It was then 6:37 when the accident happened, 2.5 hours to go until party time. As if to suggest Mr. Pino, in his mind, was worried that the girls wouldn't be ready on time and that he was then going to throw caution to the wind and drive the boat in a way that he had never driven before, because you've heard nothing. No evidence that Mr. Pino has ever had an issue with driving his motor vessel. And many of the passengers have been on Mr. Pino's boat before. That motor vessel, Robalo, is built to handle that speed. Actually, it's built to handle more speed. You may recall that boat had 2 300 horsepower engines. That boat is rated to have 2 350 horsepower engines. That boat is built to handle an additional 100 horsepower of speed. He equipped it with motors that would provide less speed than the motorboat is equipped to handle. The passengers were seated exactly where the manufacturer of that boat designates passengers to sit. Every passenger's butt was on a cushion. None of the passengers were standing. None of the passengers were sitting on the gunnel. You by now know what the gunnel is. That's the surface at the front. And to suggest that Mr. Pino, could we put the reckless homicide vessel? To suggest that he was being flagrant. Next page, I think it's better for me. No, sorry. There you go. Perfect. That he was being gross and flagrant and disregarding their safety by having the passengers sit exactly where a company that's been in business for decades. I think this Lieutenant Albert said they've been bought out by some huge conglomerate. You didn't hear 1 ounce of evidence that Robalo had notified the operators that there should be no passengers seated in the designated seating. You did not see a label on the boat saying, "Do not sit here." I mean, we live in a society where every package has a warning on it. You buy a pack of cigarettes, it says, "Warning, if you continue to smoke these, it may cause cancer." You go to McDonald's and it has to caution you that they have hot coffee in a hot coffee cup. We give warnings to people for any possible liability. You come home from the dry cleaners with your shirt on a hanger, you take the plastic bag off, and if you read the bag, it says, "Careful, don't put it over your head. You could suffocate if you wrap a plastic bag around your head." We are a society that is so litigious that we warn everybody of any possible misuse of a product. And yet, you did not hear 1 ounce of evidence, not a witness, not even Lieutenant Albert tell you that Robalo has suggested to any of its operators over the last 40 or 50 years that the boat is not equipped to have passengers seated in the designated passenger seats. And yet the prosecutor is suggesting to you he's driving the boat in a reckless manner or in a gross and flagrant manner by having passengers sit where they are designated to sit. I mean, that's just not fair. That's not fair to the operator of the motor vessel. Just not fair. Let's talk about the speed. How many witnesses testified that the speed at which those witnesses were traveling, some of them law enforcement officers, others just ordinary boaters like David Rodriguez, whose boat can achieve 80 miles per hour, that he was doing 50 to 55 miles an hour that day? There was nothing about the speed at which the Robalo was traveling that was at all excessive, gross, or flagrant. And let's say what we all know to be the absolute truth here. If George had not hit the piling, nothing bad would have happened. The conditions were ideal. The waters were calm. It was not a windy day. It was not raining. It was no lightning. There was no oncoming boat traffic. It was wide open bay. The speed had nothing to do with the injuries. What caused the injuries was the crash. Of course, the faster you go, the more likely someone's going to get hurt. Of course, if he bumps it at 1 mile an hour, nobody gets hurt. But the speed in and of itself did not create the danger. Hitting the marker was the problem. So we all understand that, I hope. No one on the boat asked George Pino to slow down. No one said, "Hey, I'm scared, we're going too fast." Not Mr. Pino's wife, not his daughter, and not any of the other passengers. And with the speed at which Mr. Pino was traveling, even at 47 miles per hour, the state's theory is that with 9 seconds to go, Mr. Pino was on a course that would take it into the marker. And as you may recall, when I examined some of the witnesses, with 9 seconds to go, there's plenty of time to simply turn the wheel slightly and avoid the marker, if George Pino had seen it as he was approaching the marker. Of course, if the state's theory was, he was, for those 6 or 7 seconds, inattentive, that would explain why he hit the marker. He had plenty of time to do it, that is, to change course. But because of inattentiveness, according to the prosecutors, he didn't change course in time. Not reckless, conscious, flagrant disregard. This Robalo boat is yacht certified. That means that it's built to take that many passengers. There is no weight limitation. This idea that 1,000 pounds of passengers is going to create a dangerous situation. No one has said that Robalo warned George Pino or any of its other operators of the state's theory that they're advancing to you in this courtroom. So we dealt for the moment with the alcohol used by Mr. Pino. I'm talking to you now about the speed at which he was traveling and the way he was driving. And so I want to ask you to imagine on that day, if there was a drone watching Mr. Pino's operation of the vessel post from Ocean Reef to Billy's Point to the sandbar and back. If any of us was watching, would someone have said, that boat traveling, that way it's traveling, that guy's driving like a lunatic? Because that's what this crime is basically suggesting. Because you know a reckless driver when you see it. It's the lunatic on I-95 cutting through cars, going 30, 40 miles over the speed limit. You know the reckless driver when you see that person. George Pino his boat was traveling on straight lines at speeds that Robalo is designed it to travel at, in a zone where there is no speed limit. No posted speed limit, not then, in 2020, 2022, and not today. If it was so inherently dangerous to travel at speeds in the 40s, you have to ask why there is no speed limit posted there. You heard Lieutenant Albert when I questioned him. There are speed limits all through Biscayne Bay. On Miami Beach, on the Lloyd Channel, I spoke to him about that. Posted speed limits like you see on a street. And yet, this channel, Cutter Bay, had no speed limit in 2022 and none today. It's not fair, it's not right to tell George Pino after the fact that there should be a speed limit there. I'd like to talk to you now about the government's emphasis about George's imperfect, inaccurate, unreliable memory of the crash. After the crash, and we'll talk more about George's efforts to help people after he regained consciousness, but for now, it's undisputed that as a result of the crash, the collision, George Pino lost consciousness. He was laying on the floor of the boat, unconscious. Witnesses thought he was dead, bleeding from his head. 4 of his front teeth. Maybe you'll help me find it. What do you got, Jeff? Thanks. The prosecutor said no big deal because the impact only shaved off part of his teeth. That we might have a better argument, I think the prosecutor was suggesting, if you'd lost the teeth completely. So George Pino, by all accounts, unconscious on the floor of the boat. He hit his face on the floor of the boat and then the back of his head hit the boat. He had 2 places of impact. He was knocked unconscious. We asked a doctor to come testify because the state did not produce a medical witness on the issue of George's injury. We brought you the only medical testimony about that, Dr. Barrett. And before we get into the substance of her testimony, let's talk about the cross-examination of Dr. Barrett to attack her because she charges for her time This is someone who's been a professor at medical school. She's been a doctor for decades. Her credentials are unimpeachable. And yet the prosecutor is focusing on how much money she charges for her time, that she charges for all her patients. The prosecutor was making something of her preference not to have to process insurance for her patients. They're able to seek reimbursement from the insurance company, but she doesn't do that. She accepts direct payment, and then if they want to be reimbursed from their insurance company, that's okay. As if to suggest you shouldn't consider her testimony because she doesn't accept insurance and because she doesn't work for free. Now, I never asked Lieutenant Albert how much he was charging the state for his time. He's also a paid witness. Because I wasn't going to go there as if to suggest to you that a man who for decades has been a law enforcement officer would lie to you for money. And I think that's what the prosecutor is suggesting that Dr. Barrett did. That's frightening. Because that's what she's suggesting to you. That because she doesn't accept insurance, and because she charges for her time, after all, someone had to pay so she could go to undergrad and medical school and residency. Those of you who have family members that have become doctors and specialists, it takes a decade to get to the point where you can be someone of her level. And rather than bring you a rebuttal witness, they brought you no one. They attacked the doctor for telling you what is black and white law of medicine, the principles of medicine. Medicine, she explained to all of us, makes a diagnosis of a traumatic brain injury focus on what happened at the time of impact and in the 72 hours after, not 3 years later. And Dr. Barrett explained to you that because George was seen unconscious by multiple witnesses, and because it was obvious that he had amnesia because he was recalling inaccurately so many of the details of the crash, the diagnosis was beyond dispute. The man was unconscious. He suffered a traumatic brain injury. Now, the word traumatic, I think, is a word that is giving the prosecutor some concern because it sounds traumatic. It should be like he needed to go to a hospital and stay there for a month. But that's not how concussions work, and the doctor explained it to you. And so the questions of a lawyer who worked for the state, not for free, by the way, who is attacking a doctor, a professor, the questions of the lawyer are not evidence. The suppositions of a lawyer are not evidence. The evidence comes from the witness stand. And the only evidence to you about the issue of George's memory came from an accomplished doctor, one who's a professor, one who has published, albeit she doesn't accept insurance. And she explained to you that George Pino, having suffered a concussion, diagnosed with a traumatic brain injury, unable to accurately recall events related to the crash, including, for example, which boat he was on. He thought he was on the boat that had the 225 horsepower engines that he had previously. He thought he had hit the left side of the boat, he thought the left side of his boat had hit the marker when it was the right side. He recalled to Lieutenant Thompson that it was Nazi he had pulled out from under the boat when we know it was someone else, it was Lucy. All of those mistakes made it clear that George Pino was suffering from a TBI, a concussion, and that his memory would not be reliable. It doesn't mean he had total amnesia. The prosecutor was suggesting to you that he should remember nothing to convince you that he's had amnesia and what they call in the medical world confabulation, filling in details about the event from past memories or other memories. And so when George Pino was recounting what he remembered from the crash, and he thought he remembered that there was a wave that came from another boat, that was his memory of it. It may not be reliable, but there are two things that hold true. First, the science establishes that those are the kinds of failed memories and inaccurate memories and false memories that happen after a concussion. And second, it doesn't tell us, and we don't rely upon it, and you don't have to rely upon it in deciding what actually did cause the accident. Was there another boat with a wave? You can disregard it altogether. And you may recall Mr. Shapiro, when he was questioning Lieutenant Thompson, confirmed that no one else saw a boat out there that day coming back from that marker area immediately after the crash. And so we assumed there was no other boat for purposes of deciding, and for you to decide, whether George Pino acted recklessly or conscious disregard for safety. And because there was no other boat, and because the conditions were ideal, the state really has no theory of why George should be labeled a criminal. Because it's not like George was going and racing through incoming traffic, going zigzagging out of boats, and then hit the marker. It was a perfectly, as everyone said, it was like the ideal day to go boating. And it comes back to what I told you earlier when we started. That what the state is telling you is that George made a mistake. He didn't see the marker. And now we're going to talk about what's left of the case, in a criminal case, where the state has no theory other than to bring to your attention things that they try to influence your decision based on facts that have nothing to do with the operation of the motor vessel. Let's start with underage drinking. And it was a subject of our jury selection when we talked about this early on. Whether the girls, the passengers, were 17 or 27, the age makes no difference. We're not here to judge these parents based on their decision to allow 17-year-old high school seniors to drink. None of them were operating the boat. All of them were seated where they're there was a life preserver, but the law doesn't require it. Well, George complied with the law by having a life preserver available for every single passenger on that boat. Nothing more was required. And what the state is saying is to you is that every time someone comes on your boat and has drinks, and I don't know if it's limited by age, but now the operator of the motor vessel needs to put a life preserver on every drinking passenger. Now, I assume that doesn't apply on big cruise ships, which are famous for people going drinking, or big yachts, maybe. I don't know where the line is going to be drawn in the future. But beware if you're a boater. Beware. Because you take a group of people out on your boat, and they have a few drinks. Some prosecutor will say that because you didn't put a life preserver on that passenger, you are now a reckless boating operator. Because that's what she's saying. But she focuses on the age again, I think, to just sort of to do two things. It's really, of course, much more painful to know that a young person passed. And let me point out that I think the medical examiner told us that there was no evidence that Lucy had any blood alcohol in her system when they tested her. So I don't think there was any evidence that Lucy was drinking. I don't think there was any evidence about that at all. Some of the other girls were for sure. And nothing about Lucy. But it sounds to me like what the prosecutor wants you to do is say he's a bad parent because he, and by the way, the other parents at the sandbar, to include Lucy's parents, are bad parents. And so let's convict them of being irresponsible parents and call them reckless and callous. The underage or any age drinking of the passengers had nothing to do with why the boat hit the marker. I hope that's clear by now. Nor did the absence of a kill switch. Those of you that may not have been on a boat before, we try to explain it. It's this like string that you attach to a button on the console so that if the pilot, the operator, is dislodged or falls into the water, it automatically stops the engines. And the prosecutor wanted you to know that there's no evidence that George had a kill switch. Not required by law, would not have changed the outcome here. But the prosecutor wanted you to know that, and that the flares that were on the boat were expired. Even though I brought out through Lieutenant Alder, even expired flares can serve the function, although it doesn't comply literally with the regulations. And of course, flares had nothing to do with this. And having unexpired flares. All right. So now I'd like to spend some time talking about the witnesses. That's the evidence, the people you heard from. So that you have no doubt that when I share something with you, I am doing my very best to rely on the evidence and not on my theory or my argument. I want to rely, and I want you to please rely, as is your oath, on the evidence. And I sequence them differently than when, in the order that you heard them, to try to do it in a more organized fashion. I'm not particularly famous for being organized, but I've tried my best so that we can cover the subject together in a meaningful way. Everything starts at Ocean Reef. That's the place where the Pinos were celebrating their daughter's 18th birthday. And in addition to the virtual mass and the pickleball tournament that George organized and the boat ride that he had organized, there was going to be an event that night at 9 o'clock dinner, the end of the night. After, I guess, the Florida State game, there was a Florida State game that was being played that evening. And George Pino organized the dinner to start at 9, and it was going to go until 11, but you heard from a witness named Araceli Alvarez, she was the event planner at Ocean Reef, that they could show up late and stay late because there was no other event afterward. And I thought that that's important because the prosecutor's theory is that George became reckless, he became indifferent to people's safety because he wanted to make sure the girls were Instagram ready in time for this party. That's their theory. He was worried about them being Instagram ready. And that he'd be willing to risk the lives of these girls so that they could shower on time. Then we have the testimony of the people that attended the sandbar and the events of the day. It included Lucy's dad, Andres. And here's what he testified to as part of the state's presentation, including the answers to the questions that were asked on cross-examination. He was not concerned that George Pino had consumed too much alcohol. He himself had consumed alcohol. He felt he was able to operate his motor vessel. He did operate his motor vessel. He drove his motor vessel the exact same place that George Pino would drive his motor vessel. He allowed his daughter to drink. It was part of the so-called culture. He knew Ceci Pino almost his entire life. There was a loving relationship between these families. He was at the sandbar until at least 5:41 p.m., and you know it's 5:41 p.m. because there's the photograph of the Fernandez, I think it's going to say, I don't remember the mark of the boat, but it's a 20-footer more or less. And you recall Mr. Fernandez is floating in the boat, in the water behind the boat, and that was timestamped 5:41 p.m. And you know that George Pino left at 6:18 p.m. from the sandbar. So up until 5:41 p.m., at least, sometime after the Fernandez boat leaves the area, Mr. Fernandez had not remembered until we examined him the other day that actually he was planning to attend the sandbar, had changed his mind. We know that because we produced the text message where he told George, for sure I'll be at the sandbar. But then he changed his mind. That's fine. And he did come out. And you heard nothing to suggest that any of the adults at the sandbar thought that there were too many passengers on George Pino's boat. This is really important in my view, because the state's theory is too many people sitting on that boat to be safe. The same passengers that landed at the sandbar from Ocean Reef, the 14 people on board, were the same 14 people that went back. So if it was not reckless and not flagrant and not consciously indifferent to have 14 people in that boat coming to the sandbar, the same should hold true going back to Ocean Reef. And if any of the adults or the parents at the sandbar thought there was something unsafe about these underage girls who've been drinking going back on Pino's boat where they came from, they could say so. Not 1 ounce of evidence that George Pino was told by any of the adults there that day that, hey, George, too many people on your boat, or anything of the sort. Four passengers testified. Tammy Alvarez, Carolina Monterrey, Claudia Portocarrero, and Natalia Reed. Tammy Alvarez testified that after the collision, she thought Pino was dead. On the way to Billy's Point, she felt safe and comfortable. There was no unsafe driving by Mr. Pino. She had no reason to believe he was impaired. No sense of danger, excessive speed, or risk on the return trip before the crash. Here's the quote I wrote down. When Mr. Pino was driving his boat back from Billy's Point, did you feel that he was driving in a dangerous way? Answer, no. She did not notice any perceptible change in speed, and she remembered that George made sure that everybody was seated, what you would expect a prudent operator to do. The prosecutor will use that against George by saying, George, because you told everybody to sit down, you knew you were going to do something dangerous. So imagine that argument from our government. By doing something prudent, by having everyone sit down as is proper, it's, in the state's view,
The camera's doing that. It's the feed, because the feed is still going. That's annoying. It always seems to happen when the defense is speaking. And we're all the way forward, so I like his calm approach so far. I think you're muted, Ali.
She's definitely muted. She's super muted. Yeah, this is ridiculous. Like, why has it been all glitchy during the defense's closing?
Yeah.
It's
I don't know.
outrageous.
I
Like,
mean,
you're
Sitting there
pointing
pointing
to
I'm
at
the
just going to
screen.
say I'm doing all this research and we have identified a real gap in Florida law. Like, as I've said many times, there aren't. Stand by.
Oh, just when she was about to tell us about the gap that we've identified in Florida law. Wow. Well, I'll just have to wait for that. Just keep in mind, like Howard's saying, keep in your brain.
Now
the
they're
gap.
going to that live view.
Oh, oh, oh yeah. Oh yeah. We've lost it. It's all gone.
Oh,
She testified that for a split second, she saw Pino lying between the console with his eyes closed, blood on his head, and thought he was dead. She also said that she and Holly Reed, Nazi, had never been confused for any of the other girls like Lucy. And that was important because George inaccurately thought initially that he had pulled Nazi from under the boat. So those 4 passengers testified. Of course, the state will emphasize that some of the girls themselves were intoxicated. And can we put on the screen exhibit T like Tango? Thank you. If the state had another witness to contradict the 4 passengers on the boat, they could call any one of the witnesses on the list that was provided as exhibit T. We had Mrs. Pino do a count of individuals in the sandbar. By her count, 13 girls, 8 boys, 15 adults, for 36 total. The full page. The state did not call the evidence that I just discussed with Now, Cecilia Pino, the mom, no one is suggesting that she is suicidal or homicidal. She was concerned about her own safety and that of her daughter, little Ceci, and the girls who she's known since most of them were born. There's no suggestion that she would get on a boat with someone who was intoxicated, driving at lunatic speeds, and subject herself and daughter and these girls who she loved to danger. Because if you find that George was doing this, you're basically saying so too was Ceci Pino. That the mother of little Ceci, the camp mom, for lack of a better word, that she too was, quote, reckless in allowing her husband to operate the vessel. It's the only inference you can draw. What else would you say? And not at one moment in time did Cecilia Pino, the mom, say, hey, George, slow down. She didn't feel there was any danger. None of the passengers said, hey, George, slow down. That's the unrebutted testimony. If you need a break, I can take a break. 36 people at the sandbar, 15 of them adults, sharing an afternoon and sharing alcohol. The state put before you the picture of all the empties, the empty bottles. So the Pinos serve as basically the garbage can for that afternoon. That boat becomes one huge garbage can. And everybody puts all the garbage on their boat. And no good deed goes unpunished, because now the state parades before you all of the bottles. And so, being responsible citizens is now evidence against them. Brought it up right at the beginning. She felt totally comfortable motoring along. Can we put up A28? Oh, sorry, V Victor. This is a picture timestamped at about 6:31 p.m. Full screen first. everyone can see, this is a picture from the stern, that's the word we use in boating, the rear of the boat. That's George Pino with the hat, white hat, and Ceci, his wife, sitting next to him. You can actually see the sun catching the right side of his face,
Here we go with the sun
and he's
glare.
staring into the sunset, so to speak, although it's about an hour and a half before sunset. And of course, the state is critical of questions that are asked by the defense about the sun and the tides and all of the circumstances. But of course, the reason why all of these questions are asked is to get the evidence out to you so you can evaluate the facts. And so, for example, if it was 8 in the morning, the sun would be to the east on his left. And so it might be very important in understanding how the sun creates glare off of the water surface in deciding what visibility someone might have late in the afternoon. The state brought you no evidence, no discussion, no analysis of that. Okay. But what you have is George Pino on this boat, and all of you had an opportunity to see the boat in person. George Pino is not 6 foot 8 inches tall like Paul Alvarez, whose head would be a foot above George Pino's. And you can get a sense, because some of you stood on the boat, and you can see that the boat, when it's on plane, and I'm doing a profile, the boat's bow comes up. On plane means the boat is already accelerated, got over the hump, so to speak, and is now riding on a plane. That's what they call it. And so this is the windshield. So the 47 mile per hour that the prosecutor was talking about, the wind, there's a windshield. For that reason exactly. It's not like a motorcycle, which has, some of them have no windshield. This one has a windshield. And on this boat, if we can put a sea Charlie. There's the bow seating that we talked about. This one doesn't have cushions on it right now, because this is after the fact. But this is where the passengers were seated. And you already heard the testimony that their torsos and their heads would protrude above this gunnel, the freeboard of the boat. And those of you that saw it probably took note that that boat, when it's floating in the water, that bow of the boat, you can decide for yourself. You all saw it. You can decide for yourself.
Thumbs down. Thumbs down. Is Cat frozen? You're muted. Cat's frozen. I feel like I'm in
It's
a...
got to be on Cat's end. Let's see if we can do this. Let's see.
Cat is frozen. She
I'm going to
looks
try
delightful.
this. I'm going to try this.
She's giving some side eye to Laura Adams right there.
She sure is.
She's like, oh, this
sure
this
is.
bish. Oh, she's refreshing.
Okay, I was just going to say, I can put up the... Oh, but I don't know where we were. I have the feed up. But just wait, shouldn't that end the thing if she's gone?
No,
You think we're still going? Yeah. Looks
I
like
think
we're
she
still
just
going.
refreshed. I don't think she ended the live.
Were we live or we
I
paused?
mean, I'm no tech wizard, but
No, but how much time do you think we had from the... Let me see where we were. Hold on.
man, no chat, no cat,
Hold on.
no trial.
Shh.
Oh, Sorry, hon.
Sorry. You can decide for yourself. All right, hold on.
I mean, if you find the picture with the glare, like that he
I'm
was
looking at the
showing.
glare. So is that where we got through all these glare pictures?
Give me a hug. All right.
Okay, this is it. I got it. This is exactly where we were. Let's see if I can do this. Oh, he's saying hi to Cameron. She just got back. Okay. All right, this is precisely where we were. Oh, I thought I shared it. Well, it's not sharing. Well, I can't. Kat is the only one that can share. Put it up there. He's talking to Kat. Let me call Kat. Oy, oy, oy. I can't even. We're working it out. Stand by, people.
We're working it out. Stand by, people.
I mean, yeah, they can hear me, but I can't share my screen. But you might need, because I'm pretty sure that I'm
Are
probably.
you sure you can't? Why can't you share a screen?
I can remove the screen and you can share the screen. Can you queue up to where we were?
I have it exactly queued up. I just can't I can't put my own screen up. It's
Why?
shared. I'm talking to Kat, babe.
I know, but it seems like we can. What happens when you hit it?
It's just down at the bottom, like waiting for her to approve it. She's working on it.
Oh, she's got to approve it. I see. I see. Hmm. What's going on with Kathmandu?
Stormy weather, but I'm about to have this fixed. All right, I should be able to. I might have to refresh myself, babe. Stand by. You've got a Venmo you can talk about.
I do. I have a Venmo I can talk about. Oh, Kat's internet went down. Dang. All right. Allie's correct. I do have a Venmo. So Priscilla sent a sweet $5 Venmo. And it said Tech Wizardry at its finest. We've lost everybody. Everybody's gone. It's just me. Woo. Well.
All right.
Yeah, no.
It's all fixed. It's all fixed. It's all ready to go. Come back, people. I could loop back if you need me to, babe, but I should be like 10 seconds before where he was when we went out.
All right. Fire it up.
Okay.
That bow of the boat, you can decide for yourself. You all saw it. You can decide for yourself. How high is it above the water line when it's floating? And the operator, who's a foot shorter than Lieutenant Albert, what is he looking at as he looks to the front? Certainly he's going to see the passengers that are sitting there who are facing him. We'll talk about that more in a moment. Ceci Pino, in the picture I just asked Mr. Armolino to show you, she's actually in the process of sending a text using her phone. Now, let's understand the rules of the road, because the navigation rules have been presented to you. There's no requirement that a boat operator have a separate person serve as a lookout. You're about the lookout rule. I can drive my boat all by myself, provided that I'm looking where I'm going and I'm serving as the lookout for my boat. Just want to be sure there's no confusion here. I asked the witness very clear. The operator can be the lookout. You can have more than one lookout if you like, for sure. And then you'll hear in a moment, or you'll see it when we talk about it, the operator's head is on a swivel. Because when one's operating a boat on the open bay, there are no traffic signals. There are no yellow lines and white lines. There are these markers from time to time. But for the most part, it's just open bay and potentially boat traffic. And so, no different than driving a car, you need to look where you're going. I remember that from when I was a kid. My dad would say, hey, son, look where you're going. And if you don't look where you're going because you're inattentive, you might fall. If you don't look where you're going because you're distracted, you might trip. Or, as might be the case according to the state, if you don't look where you're going at some point in time, you might hit something. That's what we call a crash, an accident. And if that's what happened here, it's not a crime. The judge will instruct you about those navigation rules. All good. Thank you. In the state of Florida, the law requires operators of vessels upon its waters to follow the navigation rules. However, a violation of these rules, individually or cumulatively, is not sufficient by itself to constitute culpable negligence or recklessness. Even if an operator violates one rule, or even multiple rules, individually or cumulatively, that is not enough in and of itself to establish recklessness or negligence. It's back to whether you're driving a car or driving a boat. If you fail to see the stop sign, it could even be a stop sign that you've passed 100 times. You're not paying attention that day. You're going to work and you're thinking about something else. You fail to stop at the stop sign and something awful happens. And that's what we call an accident. Thank you. And like when you're driving to work every day, when you get into a routine, just drawing your own life experience, each of you has life experience to bring to the courthouse. You've driven this path 100 times. Sometimes you leave your house, you get to work, and you don't remember passing half the places that you know are on the way. You just never notice them. You were just daydreaming. Who knows what you're thinking about? Or, my wife will forgive me for saying this, she runs over that same pothole every time. That she should know by now, there's a pothole down the street, don't run over the pothole. It doesn't make people criminals for being human and overlooking those things, particularly when your brain is on autopilot, not real autopilot like a boat, but you're just coming along doing your routine. And if all the state proves to you is that George Pino was on his way back to Ocean Reef, as he always was, and he overlooked marker 15 and he hit it, he'll be held accountable in civil court as he was, but that doesn't make him a criminal. Mrs. Pino, to finish her testimony, corroborated what every other witness testified. Her husband suffered a head injury, fractured teeth, stitched elbow, a leg gash. It's beyond dispute. But what the state does to try to, again, avoid dealing with the lack of a theory of criminality, instead it's focusing on that the Pinos, several months after the accident, with George suffering from the post-traumatic stress, you heard he's on psychiatric medications. They go on a family trip to the Panhandle, and for maybe the first time in 4 months, he breaks out a smile with his daughters. I think what they're saying to you is that should convince you that George's lacked sympathy because he was smiling and one of his daughters posted the picture. That you should find him guilty because he had the nerve to smile for a photograph with his daughters. The first smile he might have mustered in many months and maybe very few since. And perhaps in the most awkward moment of the trial, knowing that Mrs. Pino had spent much of her motherhood with her daughter and her daughter's friends, including Lucy, she's confronted with a photograph of Lucy by the prosecutor, saying, "That's not your daughter, is it?" Why would somebody do that? Why would that question be asked?
Yeah, why would it?
Mrs. Pino explained to you she didn't see the accident, and that's why when she was in that civil case having to explain what she knew, she had to rely on her husband's memory, which we know from the science may not be reliable, but that's all she knew about the cause of the accident. You heard from several good Samaritans: Hillary Candela, Hamlet Rodriguez, and David Rodriguez. These were boaters who came upon the scene. Hillary Candela, a gentleman, he did know George Pino by coincidence. He remembers seeing George looking dazed and in shock. That when Hillary Candela screamed out to George to look under the boat, the first time George didn't seem to register the instruction. Second time he did, and George Pino went under the boat and brought Lucy back from underneath. Hamlet Rodriguez was the person to whom George Pino handed off Lucy so she could get to a boat. Hamlet Rodriguez, a former water polo player, did everything he could to help her. He said he was swallowing water against a strong current until someone pulled him out. He left the scene around 7:05, Hamlet Rodriguez, which happens to coincide with David Rodriguez, unrelated to Hamlet, who had been cruising at 50 to 55 miles per hour, sped up to 70 miles per hour to get to the scene. Yes, of course, he sped up because it was an emergency situation, but he said it felt perfectly safe to travel at those speeds. He saw a mature woman bleeding who said a girl was missing. Likely Ceci Pino, since that was the only adult passenger on the boat that he saw bleeding. And I think she told me she was hospitalized after that night. Mr. Pino, by then, was apparently hanging on to the capsized boat after he had passed Lucy off to Hamlet Rodriguez. David Rodriguez described Pino very in shock, crying, but did comprehend instructions. Pino kept asking David, "Are all the girls okay?" Pino would not get out of the water until he was assured that every girl was out of the water. That was 7:04 p.m., I believe was the timestamp on that. He was asked to look at his camera, what time did you photograph George Pino still in the water? 7:04. The accident occurred, according to the GPS, at 6:37 p.m. 25 minutes, if my math is not wrong, that George Pino stayed with that boat until everybody was out of the water. And to get out of the water, George Pino had to negotiate a swim platform with a tie bar that David Rodriguez explained was no easy task. And David Rodriguez took the unusual step to put his face in George Pino's face. To see if George Pino smelled like alcohol, had bloodshot eyes, slurred his speech, David Rodriguez, who was curious, maybe even suspicious, I think he said, was satisfied that George Pino was not under the influence of alcohol, that alcohol was not impairing George Pino. And we're talking now 20 minutes after the incident, maybe 25 to be more precise. Then the first responders came to the scene. You heard about Officer Bruto, now retired. He was the first officer on the scene. He saw George Pino get out under his own power. No stumbling. Even Bruto was concerned about a concussion. He said safety first. George had a head injury. But still, George Pino was able to keep his balance on a narrow 6-inch gunwale. No signs of impairment, said Bruto. Speech not slurred, no balance problems. I mean, you talk about taking a sobriety test. That is probably the most difficult sobriety test anyone could take. Bruno himself traveled at near top speed at 52 to 54 miles per hour in emergency mode. Quote, here was the question: the conditions allowed you to travel safely at nearly 54 or 52 to 54 miles per hour. In other words, the top speed that your vessel was capable of, correct? Answer, correct. So you have an opinion from a law enforcement officer that the speed is safe to travel. First responder Peter Delgado, a sergeant with the Miami-Dade Sheriff's Office. He triaged Mr. Pino, meaning he rendered first aid. He confirmed, of course, that no life-saving devices, personal flotation devices are required to be worn. The Pino vessel had the required PFDs, none are required to be worn. He's the officer who began talking to us about those markers, the staggered markers in Cutter Bank, and how staggering the markers, as I think you'll see in a few minutes, is less simple, let's say it that way, when the markers are staggered versus red, green, or depending on the side you're looking for. He could see that Pino was an injured passenger, bleeding from his head, and he told Pino to not go to sleep because he was concerned that Pino had a concussion, and going to sleep could be dangerous for someone with a concussion. He too observed no signs of impairment. And no other officer on the scene reported to Delgado or to any other person who's testified in the trial any signs of impairment. John Dalton with the Miami-Dade Sheriff's Office, he transported the girls from the accident scene to Elliott Key. He testified, and this is the best quote I have, about speed. Quote, no more than 40, 45, maybe at max, because they were panic-stricken and begged him not to drive fast, and it was getting dark. As an officer, saying 40 to 45 is not fast. The opposite of not fast, maybe not slow, but it's certainly, it's safe. Let's call it that. That's what the officer called it. The girls on Dalton's boat were sitting, I believe they were sitting, yes, seated on the floor and console at the bow, the front of the boat. By then it was nighttime, doing in the 40s at night. Question, and you felt in those conditions that was a safe speed for you to travel? Answer, yes, sir. He's the one who talked about keeping your head on a swivel, that the operator of the boat has to keep his head on a swivel. And what that means is as someone's operating a boat, since there's no traffic lights, no stop signs, no yield signs, no turn signals, which means that if a boat is coming behind you faster, right, that boat could come up behind you, and so while you're operating a boat, you got to take a look from time to time. You got to swivel, look at your instruments, look at your passengers, and if it takes you more than 6 or 7 seconds to do all of that in one swivel, you might just hit the marker. Lieutenant Thompson testified. He's the witness to whom George Pino candidly said, hey, I had 2 beers. And it was Thompson who explained to them that's okay. It's not illegal to drink and operate a boat. Those are the words of Thompson. Quote, it's not illegal to drink a beer or a couple of beers and drive. And that's a true statement, isn't it? Answer, yes, sir. Now, Lieutenant Thompson was the responder who took the recorded statement from Mr. Pino that you all have seen. Of course, you can judge for yourself in terms of Mr. Pino's speech, whether he appeared to be impaired. A concussed brain, and let's be sure we distinguish between concussion and intoxicated. A concussed brain can fail to record memories. So you can have a concussion, according to Dr. Barrett, your brain is not recording memories, but then when you finally come out of the concussion, you can achieve this score of 15 in the Glasgow scale. So you've got your wits about you, but your memory's not restored. But when George Pino was recounting what his memory was to Lieutenant Thompson, which is recorded, George Pino did not accurately recall the details of the crash. I went through those with you already. And you'll see, if you decide to look at the videos, that the first responders had to wrap George's head in a gauze. And I heard the prosecutor said only 7 staples. Is there a number of staples after which you're convinced that someone's had a concussion? 7 staples on a man's head with the teeth getting bashed in with chipping teeth? That's not enough, according to our prosecutor. And so Lieutenant Thompson, together with the help of some other CSI, crime scene type people, did a recreation. But the boat used for the recreation was Thompson's boat, which doesn't have bow seating, which doesn't have the higher gun. And according to Lieutenant Albert, only tracked the last 9 seconds of Mr. Pino's voyage. That was what they were trying to replicate, of course, with the exception of hitting the marker. And that within the last second or so, there's that buoy, and then Lieutenant Thompson avoids hitting the marker. What it proves to you is that if someone is attentive, someone's paying attention, even at that speed, with that lighting, in those conditions, the marker can be avoided. If the operator is inattentive for some reason, is looking at his instrument, swiveling his head, in the time I've just said that, 8 seconds have gone by, they'll hit the marker. Now, we had a little back and forth. It's not going to be a huge point, but I thought it was important again to bring the facts to you. It was high tide when this accident happened. High tide. Thompson thought high tide was at 4:44 in the afternoon. He was wrong by 2 hours. Lieutenant Albert thought, according to his report, it was at 10:30 at night. So the two of them were completely at odds with each other in terms of what they thought high tide was. And I asked, and Lieutenant Albert complied. Let's get the right answer for this jury. Let's go look at the right answer. Let's not have the wrong answer, even if it only means a foot or a foot and a half of difference in terms of the tide. One witness says the tide shifted 3 feet. They presented evidence. Mr. Albert said it was about 1.75 feet above the normal mean of the water. All evidence is clear. It was high tide when this crash occurred. Ed, can we put on the screen D Delta? And you may recall I used the tape measure to establish that at high tide, 6 feet plus 3 feet is 9 feet at the top of the marker. I believe this is what the state says is the size of the marker. And if on the piling, this is the marker, green of course. Okay? And so you have your experience of having gone to see the boat, where the gunnel of that boat would be relative to the pilot that I represent right now. And whether someone sitting on that gunnel might obscure the operator's view. Of course, should the operator, under normal circumstances, if he recognizes that his view is obscured, request that the passengers make room? Of course. But that's not reckless and conscious and flagrant and gross to overlook that problem. Now, marker 13A, not 13, prosecutor said 13, let's be clear, there's a 13 and a 13A. Let's put 13A. The testimony is that 13A is 5 feet taller. Lieutenant Albert said it was 5 feet tall. So I brought a tape measure. Three and a half inches. So 13A, the bottom of 13A, the bottom would be 5 feet above my head. Okay? The top would be 3 feet tall. Okay? So 13A, that would be 8. 5 plus 3, 8 feet. That's the top of 13A. Okay? And you can see that quite clearly in Exhibit I, which is a photograph that we showed you through Lieutenant Albert. Hold that right there. Hold it. Southbound, going back to Ocean Reef. There's 13A. There's 13. So it's 12, 13, 13A, 14. They're staggered over there. And if we can zoom in, you can see at this angle, there's 15 obscured behind 13A. And I asked Lieutenant Albert, and again, I didn't ask him how much he gets paid. I trusted that he'd be honest. Wouldn't matter how much he's getting paid. He's a law enforcement officer. I believe he would do the job, and he did. Please tell the jury if there was a point in time where those two markers, if the operator was looking through the channel where the GPS track showed, was there a point in time where marker 13A would obscure marker 15? And he said yes. And I think we have that in the Lieutenant Albert. Next one. No, you wouldn't go too far down. Up, up. There you go. Keep. Eye. Obscure right there. Is that it? I'll find it in a second. We'll find it in a second for you. But the testimony was that at 34 seconds to go, that's the number that he testified, Lieutenant Albert. 34 seconds to go, those pilings line up with the operator's view. Now let me be clear. George Pino has no memory of this, no reliable memory of the crash. And I'm not saying to you that in fact, that at that precise moment in time, the 34 seconds to go, George Pino looked up, looking down the channel, and they were obscured. Although the prosecutor brought out from Albert that at 34 seconds to go, it might be that green marker 15 is not even visible because it's still too far away for the human eye to see it. Don't have a reliable memory of what happened, but nor does the state. Nor does the state. But one thing we know for certain, the tape measure doesn't lie. The GPS doesn't lie, the tape measure doesn't lie. And we know for certain that marker 15, for reasons that the Coast Guard will have to explain at some other time, why would they make a marker 5 feet lower than all the other ones in the channel? I'm not blaming the Coast Guard, because I'm waiting for the prosecutor to stand up and say the defense is blaming the Coast Guard. I'm just bringing you the facts. And that's a fact. And so when we saw the recreation of Lieutenant Thompson mimicking what the Robalo might have done, it did not give you a visual of what the operator of the boat of the Robalo was seeing in the last 9 seconds. Because the camera that Lieutenant Thompson was using was in front of the windshield, not at the position where the operator stands. This exercise of crime scene investigation, you heard from Manuel Palmares. He confirmed that marker 15 is the shortest marker in the Cutter Band channel. He talked about the green paint, that the green transfer onto the Robalo. Yep, that's it. Right there. No problem. Just to finish out the loop. The accident happens at 6:37 19. Someone will tell me if I got that. Excuse me, 6:37:28. 6:37:28. At 6:36:54, so let's do our math together. That's 6 seconds before 7 p.m. I'm sorry, 6 seconds before 6:37, plus another 28 seconds. 28 plus 6 is 34. 34 seconds from this point until elision. 34 seconds. And that's where 13A obscures 15. If the boat is here, the operator is looking down the channel, the operator's view would be obscured. And I'm going to repeat myself one more time. Don't know if that's what happened, but it's not our burden to prove to you what happened. Our burden is nothing. Our burden is to appear here in court and answer or hear. But we don't have to present any evidence. But we take the step to bring you all of the evidence for you to consider. If the operator is looking down the channel, could the operator have counted 2 green on the left, 2 red on the right, continues for 10, 15, 20 seconds, and when the operator passes marker 13A, having counted 2 green on the left, 2 red on the right, thought I just passed the last marker, the last green marker in Cutter Bank Channel, veers towards the left to go to Angelfish Creek, and says, "Hi honey, what are you doing?" I'm sending a text message. 8 seconds later, there's a collision. Don't know, but the state has to explain to you why what happened there was more than just, as they've said so far, mere inattention. That was Palmares. Bengal Dahl, Detective Miami-Dade Sheriff's Office. He was the one, I think he was photographing, he was the drone guy. He said that the operation by Lieutenant Thompson in recreating what the Robalo did was, quote, safe so long as you don't hit the channel marker. Well, we all agree. What George Pino was doing was safe, provided he sees the marker in time to avoid it. And let me make one other thing clear. Green marker 15 is visible. To use the word as we understand it, it's visible. It's 3 by 3. If you're looking straight at it, you're going to see it. If it's like the pothole down the street, it doesn't, you can see it, but it's just not registering, you could miss it, even though you could see it. When I say miss it, I mean you could not recognize or not register that it's there. And if you do that, it means you're human. It happens to us as humans. It doesn't turn us into criminals. And Bengal Dahl, he testified that the exercise of having Lieutenant Thompson copy the path that the Robalo took, showed a steady course. No beeping, no hot dogging, no thrill seeking. A slight turn at any of the last several seconds would have avoided the marker. He was asked, question, as the vessel, talking now about Lieutenant Thompson, recreation of the Robalo. As the vessel was traveling in the path at that speed in these conditions, did it appear to be operating unsafely? Answer, no. The only thing that would create a problem is hitting the marker. Answer, correct. This is, as I tried to explain earlier, this is the car that's not driving on I-95 like a lunatic, but gets into an accident because, for example, the car forgot to hit its blinker, took a pass, changed lanes, gets hit, and people get hurt. Did they violate a rule of the road? Yeah, they didn't turn on their blinker. Did somebody get really badly hurt or worse? Yeah, but no one's going to jail for that. And Now we come to the 6'8" Lieutenant Albert. And I think he gave you the answer he thought was the cause of this accident. His opinion. He, the police, testified that the passengers seated in the bow area could have obscured the operator's view. Meaning that George Pino was driving along with a swivel, looking, and that the girl sitting in the front obscured his view or perhaps distracted him, and he didn't take note of what would otherwise be a visible marker, and he struck the marker. And you may recall I counted down with him, 9, 8, 7, 6, 5, 4. During any of those 5 seconds, if George Pino had taken note of the marker, he could have avoided by a quick turn of the wheel, not even that quick, just turn. But if he didn't notice it until 3, 2, 1, it would be too late. And if it's because the seating arrangement made his view of the marker less than ideal, it wasn't because George Pino was trying to be in reckless disregard for people's safety, gross, flagrant, or anything of the sort. A few additional witnesses, the civil attorneys who testified.
I just want to note right here that what the defense should be focusing on is the part of the instruction for, for even under manslaughter act, okay, that the act cannot be mere negligence. So you cannot be guilty of manslaughter by committing a merely negligent act, or if it's either justified or excusable. And the excusable ones she holds up that says it has to be done with the usual ordinary ordinary caution. Sorry. So, but the right before that, it says cannot merely be a negligent act. He has to keep arguing that under the intentional act theory the state has presented, all of the things that they are saying the intentional acts were done negligently. So he did an intentional act negligently. That is not, by definition, intentional act homicide. It specifically says manslaughter. He cannot be guilty of manslaughter by committing a merely negligent act. And he can just strike through the rest of it. And I haven't heard him drilling that point home, and I sure as shit hope that he does. Unless I missed something because I had to take a call, babe. No, he doesn't know. All right, let's keep going.
Prosecutor.
I was paying attention. I just don't know if we showed a pause in it.
Prosecutor, the civil attorneys who testified.
What were you saying? What were you asking? I've been paying rapt attention.
I'm just saying that he hasn't drilled home that in order for it to be intentional act manslaughter, the law specifically says it can't be a negligent act. And I think he needs to be drilling home that before you can just ignore excusable homicide and justifiable homicide. The instruction itself says a defendant cannot be guilty of manslaughter by committing a merely negligent act. So he should be drilling home that all the intentional acts that she keeps talking about were intentional acts done negligently. And it says it cannot be a negligent act.
Which acts? Like you and I just are in disagreement that him, having it full throttle at 47 miles an hour was negligent.
No, but my point is that's what she's saying was the act is. So
I disagree that that's the act too. Like I know what she's saying. I understand that. I think she's misapplying the law. I think he's done, in terms of specifically attacking each statute. I don't know that he's done that, and he hasn't touched the homicide definition at all
That's
yet.
what that's what I'm talking about right now. That
Oh,
under
yeah.
the homicide definition, it says the defendant cannot be guilty of manslaughter by committing a merely negligent act. So he needs to be drilling home that
Yeah.
they're trying to have their cake and eat it too but still all of their so-called intentional acts are merely acts done negligent.
Yeah.
An intentional act done negligently, like operating it negligently, is not manslaughter by intentional act by mere definition. And
Yeah.
then that you can just don't even look at justifiable or excusable homicide. They play no part here. It's using that language differently because the words before it says it cannot be a negligent act. So what she's highlighting and underlying for you is completely different. She's misleading you. Like I think he needs to like really say, why is she showing you this when the rule says it cannot be merely negligent?
I mean,
I don't know.
he's basically said that. He's a little bit I love what he's doing. He's done everything that I've asked that he's needs to do, I think, but that portion there, I agree. He's got to address that specifically.
Right.
You know,
All
he's
right.
a little bit all over the place. Like he bounces around a little bit, but he admitted he's like, I'm not known for being the most organized lawyer. So, and we've all given closings and, he's got a lot of shit he wants to get out there. So, he'll hit an area and then it'll probably make something pop into his mind because he's not reading. Like this isn't an Alan Jackson closing where he's got a full script that he's practiced over and over and over again. He's hitting all the high notes with all the witnesses in terms of what they testified to. It's a strong argument. I mean, he's making a very strong argument.
Right. All right, let's go. Whoops. No. I'll do that 10.
A few additional witnesses, the civil attorneys who testified, prosecutor emphasizes that the insurance company's appointed lawyer for the Pinos, Mr. Mescalado, following insurance company protocol, files a petition for limitation of liability to consolidate all the cases into federal court. A lawyer doing his job, with a client urging him, I want to make sure everybody gets compensated. And the insurance company's lawyer saying, this is how we do business with the insurance company. And George Pino deferring to his lawyer.
And remember, it has nothing
And
to do with
still-
the accident.
Everything gets resolved civilly.
And still,
He holds himself accountable. He resolves the issue of compensating people that are terribly injured and worse for their injuries and their pain and their suffering. And yes, George Pino maintained the same memory of the event a year later that he had the day of the event. That's the nature of a confabulated memory. It's the only memory George Pino has of the event. And he shares it with his lawyer. And his lawyer shares it with opposing counsel. And the case gets resolved regardless. Has nothing to do with the decision you have to make about whether George Pino was acting grossly and flagrantly and recklessly. If I could just have a second.
might be about to be done, right?
Close to wrapping.
Man, Cat's really having a storm or something over there.
Man, oh man. Catman
Early
dude.
on, we talked about the two crimes that George Pino is accused of and which you'll render a verdict on. One of those crimes is manslaughter. And manslaughter,
Here we go. I hope.
while the elements, they sound alike, manslaughter has two different ways to to have the state allege it and prove it. One is, can we put up the manslaughter?
Finally.
Thank you. Manslaughter. A, intentionally committed an act that caused the death. I submit to you that intentionally committing an act, the state hasn't proved by any stretch that he intentionally went into that marker which caused the death. It's not George's intent. Then there's the question of culpable negligence that we talked about throughout this presentation. I just want to make sure that we don't miss that there are two different theories that the state is
What is he
presenting.
pointing at? Am I blind?
That George intentionally committed an act
Yes,
that was not merely negligent
there it is.
that caused the death. Well, the prosecutor told you if he intended to hit the marker,
A murder.
we all agree. Going 47 miles an hour, George Pino intended to crash into the marker, guilty. But that's not what he intended. We all know that. And so the state resorts to this culpable negligence theory. Or maybe the state will say to you his intentional act was turning the steering wheel. And that's the act you should look at. That he intentionally turned the steering wheel, which put him on, as they'll say, a collision course. But you certainly know he did not do that with the intent of crashing into the marker.
Or to cause harm, which is what it says. Go back to the instruction.
Or they'll say he was culpably negligent, that he should have known. But as we've addressed with you already, can't be the product of mere negligence. If that's what happened, if George Pino was negligent, he is not guilty of manslaughter. Because turning the wheel, unless you hit the marker, nothing bad happens to anyone. The speed is safe. It's steady driving. The conditions are excellent. We all know what caused the tragedy here is striking the marker. And speaking of the marker, can we show the jury Exhibit J? J and K. You may recall some discussion about the GPS and how George's SIMRAD device, the GPS device, when magnified, the red line purporting to be the path of George's boat, and when it's magnified, for whatever reason, I think Lieutenant Alba tried to explain that the markers are on a different map than the track. It actually shows that George's boat never actually alighted with the marker when you magnify. Now again, I am not telling you that George Pino was driving, staring at his GPS, and thought that he was going to avoid the marker. But what you know from the track is that as George was going in the channel, which is basically southwest, at some point in time, he starts turning to the left port because he's headed to Angelfish Creek. And we know that marker 15 is to his left, to his port side, until he actually strikes it, and he strikes it with his starboard side. So he actually shifts left.
Too early.
Now, he could leave the channel at any time. There's no rule that he has to stay in the channel. There are no other boats in the channel. He can, typically you stay to the right, but if there's no other boats, you can take the middle of the channel. If you want to go in the shallow water, you can just make a right turn or left turn and go to the shallow water. But I think what this tells you is that George Pino, it did not register that he had one more green marker to go. Because he's doing the veer to the left that he would have ordinarily done when he gets to marker 15. And it may just be, for the reasons we've discussed before, that the state thinks he was inattentive, he should have known he had one more marker to clear before he was out of the channel. Whatever it is, it was not an intentional act to hit the marker. He did not intend to come close to the marker. He intended to take these girls back to Ocean Reef.
And any intentional act is only
And
negligence.
so now I'm going to ask you to try to get into George Pino's mind. Because ultimately, our criminal laws are here to punish people who act with a level of depravity, of gross and flagrant behavior, that there's some malice. And when I say malice, I don't mean like malice.
Judge, Your Honor, that's not a proper statement of the law.
I'll just call it
I'm sorry, Counsel.
How come-
Instructional in the law, ladies and gentlemen.
Wow.
some level of, I think maybe the better word is depravity, a degree of recklessness that leads you as jurors to believe that George Pino was acting consciously, intentionally against the interests of the passengers on board. And you know that when you see it, the pickup truck that puts people in the back of the pickup in a place where no one is supposed to be seated. I suppose you could use the example of putting a bunch of kids on the hood of a car in front of the windshield, and a car was not made to have people travel on the hood or in the back of the pickup truck. And if you saw someone doing 47 miles an hour with a bunch of young kids in a pickup truck on the interstate, you'd say, whoa, that guy's out of his mind. You'd know it when you see it. But when George Pino left the sandbar that day, it's for you to decide, was he taking extraordinary risk in traveling back to Ocean Reef, back to where he came from? Because failing to exercise ordinary care, if he made a mistake as the operator, that doesn't result in a criminal conviction. There may be civil liability, but not a criminal conviction. And so, what was in George Pino's mind? What was in his heart? And I think it's clear because you know what the occasion was. He was there that day to celebrate a wonderful time, a beautiful time in his life, surrounded by the people he loved. Was he really trying to be a show-off, to be the cool dad, really? By driving his boat back to Ocean Reef while the girls, they probably didn't even notice George Pino. As they told you, they're in their own world. It's not like he had a bunch of race car drivers who wanted to see just how fast a boat could go through an obstacle course. This was a dad with his wife by his side, his daughter seated in the bow area. Perhaps daydreaming, perhaps appreciating a beautiful moment in his life, perhaps thinking about how lucky he is. Does he really think that in his heart and in his mind, he was saying, F it, I'll just floor it and I'll throw caution to the wind? Does anyone really believe that? George Pino? And of course, a bad thing happened. A tragedy happened. And a lot of pain has come from this. And I know that there are a lot of people watching, people that have been affected by this.
Objection, it's not relevant.
You heard the testimony of people who came to this court and told you the families that were affected by this. and they're watching. And they deserve sympathy. They deserve an open heart from all of us. Their lives have been changed forever.
They don't deserve.
And it's a hard thing to do, to be a juror in a case where those kinds of feelings have been part of this trial every single day. At the same time, the reason why we have jury trials is because we count on people who have no connection to the injuries, no connection to the feelings, who can try to apply the law dispassionately, even if you have sympathy. It's okay, the two things can coexist. We can all be sympathetic. We can all feel the pain that this event has caused so many people. You can feel it. We all felt it when we had to look at some of these photographs, watch some of these videos, and how they've been played over and over again. None of which has anything to do with the cause of the crash, only the injuries that followed from the crash. And the prosecutor has spent an enormous amount of time showing you just how painful this crash was. It doesn't answer the question of what was in George Pino's mind and in his heart, which bleeds for the families that have been affected by him operating that boat. No matter what your verdict is, he will have to live with that for the rest of his life. People he grew to love, people that walked in his wedding, children who spent time in his home. And so in rendering your verdict, yes, we can all be sympathetic, we can all feel the pain. The law says, though, that when you analyze the evidence, you need to do it dispassionately. And I submit to you, if you do it dispassionately, you'll know that there was only love and kindness in that man's heart. And that never once in his mind did it occur to him.
Objection to counsel testifying.
There is no evidence,
He's such a
none, that ever once in his mind he thought that he was putting anybody's life in jeopardy. Not his own, not his wife's, not his daughter, not Lucy, not Katy, not any of the other girls on that boat. And if anybody at that sandbar had thought that George Pino was going to put the lives of those girls in danger, they would have said something, but they knew who George Pino was and is. He may not be the coolest act, but he's also not a crook. You should find him not guilty.
wow.
It's good closing.
All right, thank you, counsel. Ladies and gentlemen, we're taking a little stretch break. Please put your notebooks inside your envelopes. You can leave them on your chair. And please do not discuss the case. All right, thank you.
All rise.
All right, you all can sit. We'll take about 2 minutes now, start break, and we'll be back.
Where'd Cat go?
I don't know.
All right, we got a couple more Venmos we should talk
I'm
about.
here, but I'm scared it'll freeze. Am I
Is
like
your
confusing to you guys?
your interweb still not
No,
great?
I'm on a mobile hotspot.
Woo, she on a hot spot. All right. Did you see most of it though? Could you hear it?
Yeah. Yep.
Okay.
Watch the whole thing. I
Um,
love the measuring tape.
yeah, it was good. It was effective. Joni sent us 5 and she said, Ali to the rescue with her tech wizardry. Go Pack Go.
Go Pack Go.
Loved
Thank
it.
you.
Loved it up until the Packers stuff. Then you lost me. But thank you, Joni. I
Oh, I
appreciate
thought
it.
she was like, we're a pack. We're working
Oh, yeah, the
together.
Pack.
I
Yeah,
get it now.
that's what she meant.
Little Bears dig. Okay.
Misty came back and with $5 and said, maybe this was said, but how did this get brought to trial when the Coast Guard or Marine officers brought no charges? Wait,
It hasn't been said because we don't know.
wait, on. Hold on. Wait, that was a little longer of a message.
Oh.
This is a ham sandwich. Ham sandwich. Ham sandwich. Thank you, Misty. And then GA Catmom said, I think this is a great closing, but is it enough to overcome the state's emotional prejudice? It's the $1 million question. It's the $1 million question. I mean, if like my Twitter is any indication, I mean, there's definitely folks out there that are having a hard time separating
Thank you.
you know, here,
Oh my
oh,
god, it sounds crazy in the court. What are they
it's
doing?
crazy. So there's people in my Twitter that are having a hard time separating pre-crash behaviors and occurrences such as drinking, girls drinking, and post-crash stuff. Like that is not what the jury's analyzing here. They're
I
analyzing
mean,
the
Laura
crash
wants them
itself.
to.
They're
Yeah,
only
Laura
supposed to be
definitely-
analyzing the post-crash statements to determine if that's consciousness of guilt.
Yeah, well, Laura is, she's totality of the circumstances, that it was, all the things, all the like some of the like, and it's resonated with some people on Twitter. Like they're basically aping what Laura said about, oh, well,
I was wondering, the judge looks
why
like
do you
she's
keep doing that?
sorry. The judge looks like she's looking at something serious. I was trying to
All
hear.
right, I'm done. Go.
No, sorry.
No, I'm done.
Babe.
Nope.
Bob
I'm gonna
really
go.
wants to hear Laura's rebuttal.
I do. I'm excited for it. Let's go.
They haven't started yet.
Bloop it.
We're live.
Oh, all right.
So continue your thought, babe.
I can't even remember what it was.
Was the the people on X
People
pre-crash conduct
like
post?
Laura's argument.
Right. It's just the totality of the circumstances argument that,
Sounds
the
a lot
girls,
like-
had they not been drinking, that they would have been able to save
There's
themselves.
no evidence of that.
I understand that, dude. I know.
And did he even touch on that? That she's going to talk about? Oh wait, they are saying something. Hold on. Oh, it was.
Sorry?
Approachal.
Yeah, that was Laura that wanted it. She's gonna be like,
Yeah.
can I have permission to do this now because the defense said the word malice?
I mean, every objection they made, she sustained.
And I just want to remind people, rebuttal closing is exactly that. This isn't, she gets to do a whole nother closing on anything she wants.
She will, though.
She's supposed to be rebutting what the defense says, right? What she'll actually do is whatever the hell she wants to do. And then, if the defense objects, the judge won't do anything about it. But she's supposed to rebut argument that the defense made. That's the concept of, but I think rebuttal closing should go the way of the dodo bird. I hate them. I think the defense should go first and then the state. That's it. No rebuttals. That's how I feel about it. There's states that don't do rebuttal closings, and I'm a big fan. I don't think they need to be able to speak twice. It's bad enough they get a rebuttal case if they want to put that on. As far as the closings, should be
I
one
like the
closing
call
per
out on
side.
the rebuttal. They could have. He didn't spell it out, but where my mind went when Howard Schriebnick was saying they could have rebutted the expert's testimony. They could have called their own expert during rebuttal, but you didn't get that. My mind went to instead. We went back to the family members for the sadness effect.
Oh yeah, emotion.
That was the case.
Yep, 100%.
I still wish he would have been like held up the thing that she held up and told them that they can just X through it because the sentence before it says it can't be negligence. Like this one's meaningless. I just wish he would have done that specifically.
I wonder if he had time to really I'm sure he looked at the sign on a break.
Yeah.
But she
I
was
mean-
kind of like waving it around and it was right in front of the jury. So while it was happening, I don't think anybody except the jury could see.
I mean, he said it once at the end, but I just don't know that it hit home. Not
I
in a
think
way.
he did a pretty good job of
Okay.
delineating what negligence is, and if it's just negligence, straight negligence, it's not enough. It's not what it is.
But
I
he
thought he really
ignored-
hammered home the flagrant.
Sitting on the car roof, the hood of the car engine.
I understand, but he didn't. Well, now I forget what I was going to say. He didn't do.
He didn't say that her emphasis was misguided because the reason it would be important for him to hammer that home is because that's exactly what she's going to hammer when she gets up on rebuttal.
Exactly.
With
And
the
that's
last
what-
word.
Right, and I was going to say because he ignored that she is not saying the intentional act was going. He keeps saying it the way he wants to say it, but she's going to get up there and say the intentional act was speeding, the intentional act was drinking, the intentional act was letting the girls drink, and he needed to say how some of these you have to listen to the intentional act she says and ask yourself, was that intentional act have any cause or bearing on the accident? Because we know that that Lucy was pinned, and there's no evidence that her alcohol consumption had any bearing. They were sitting on the life preservers. There's no she was pinned. That doesn't matter. The thing.
Speed doesn't matter.
Well, speed
Sarah,
does
no,
matter.
it doesn't matter. The only thing that matters.
But the argument is he wouldn't have hit the marker if he wasn't speeding. But
That's
again,
incorrect. He wouldn't have hit the marker if you would have seen it. The speed of the boat had nothing to do with it. Like he says, if the marker's not there, there's no issue with the speed at
but if
all.
he's driving slower, he has more time to see it.
Driving slower.
Yes. He has more time to react and see it. My point is, he needs to tell her, and the other intentional acts are just negligence. What intentional act is more than negligence that had some impact on the actual accident? None.
I don't think that the speed was negligent at all. The hitting the pole was the negligence. That was it. And it wasn't gross and it wasn't flagrant. Like for whatever happened that he didn't see the thing.
You're not realizing the gross and flagrant come into play for culpable negligence, but not not intentional act manslaughter. It's just not negligent. He committed an act, it caused the death, and the act was not mere negligence. So that's why I'm saying he needs to tell them that when they're back there, they need to go through every act. Is that act just negligence? Move on to the next. Did that act have anything to do with the accident? Move on to the next. I don't know.
Yeah, I just don't agree with you. We would get very
I'm going to try to confine my remarks simply to responding to some of the things that the defense team has put forward. First and foremost, I want to say this. It is not the mission of prosecutors like Mr. Borst and myself to label anyone as a criminal. My job, as I told you at the beginning of this trial and jury selection, is to present evidence. And I am organized, and so is Mr. Borst. And that's why we were able to introduce into evidence more than 100 items for your consideration. Videos, photographs, body-worn camera recordings, written documents, court pleadings, copies of receipts from the point at Ocean Reef Club. We're organized because we have a mission, which is to present the evidence for you, the jury, to consider. It is not our job to ask you to make your consideration out of sympathy. And I will tell you in no uncertain terms, if Mr. Borst and I did not prove the charges of vessel homicide and/or manslaughter, and you decide.
Wait, she says we're not trying to ask you to do anything for sympathy. Well, and then she picks up the picture, and then she's holding up the picture of poor
Lucy.
innocent Lucy.
And this is her evidence, her 100 pieces of evidence. 90% of them is this.
Right.
To find him guilty because you feel bad for this girl, you will tarnish her memory. Because your verdict would be a miscarriage of justice were you to convict this defendant if the evidence does not support the conviction. But likewise, I'm not coming to you asking you, oh, poor Lucy, he's a monster. No, I'm not doing that because that's not my job. That's not professional. But at the end of defense counsel's summation to you all, he was basically asking you to have sympathy for this defendant. Look, we're all human, but your verdict cannot be based on sympathy for anyone in this case. It has to be based on the facts. Counsel saying, oh, maybe he was thinking about how lucky he is or how much he loved his wife or whatever. You know what that's called? That's called speculation. The judge is going to give you an instruction about what reasonable doubt is. It's not an imaginary, forced, or speculative doubt. What was in the defendant's heart and mind when he smashed into that channel marker is irrelevant.
Objection.
What's relevant for your consideration is what is the evidence. So let's talk about that evidence. The defense takes one word, inattentive, and says that's what I base my whole case on. And that's just not true. And I'll tell you why.
Oh boy.
This case is based on so many failures on this defendant to operate in a safe, prudent, and reasonable way that any one thing by
Did she
itself.
write new papers?
Well, you make a mistake. But when you heap mistake after mistake after mistake on him, when he was the one at the helm, when he was the one calling the shots, where to go, how fast to go, then we know. First off, we got him with 12 teenagers, 10 of whom are on the bow of that vessel, leading to at least 1,000 extra pounds, which if you remember Mr. Albert's testimony, remember he had that bright green boat, and he showed you how the extra weight on the bow of the vessel is going to make it harder for it to operate on a plane, so you're going to be going faster, and the faster you go and the more weight you have on the boat, guess what? The harder it is to navigate it. So that's another problem that we have. This vessel becomes less responsive because of the weight and the speed. Let's take another factor into account. The fact that
She was
he had a bunch
definitely
of
writing notes over
teenagers
there during.
who've been drinking the alcohol that he provided. How does that factor into recklessness? It factors in because you now are responsible for the lives of minors, but not minors that are operating at the peak of clarity, minors that have consumed alcohol, and some of them are not of alcohol. You're responsible for the people on your boat. So you darn well be driving carefully to get them safely back to the party you're waiting for. But what else? The fact that he'd been drinking too. That's a factor. I'm not here to prove that he was DUI. I'm here to tell you that this is yet another knock against the safe operation of a vessel. The fact that none of these girls were wearing life jackets, the fact that he wasn't wearing a kill switch, did those cause him to crash into that channel marker? No. But if you're being a safe and prudent operator of a vessel, if you are taking your responsibilities seriously, then if you know that they've been out drinking, if you know you've been drinking, it's reasonably foreseeable that maybe everybody's not at their top of their game. Maybe it's likely that people could maybe not have their best judgment. So you know what you do when you're a safe and prudent operator of a vessel? You tell the kids, put on life jackets. And you wear a kill switch. Because if something were to happen, and those engines keep spinning, which we know they did from that last track mark that Mr. Albert showed us. Remember the little curve? You see all those little track marks. Those engines were still going, thank God. Thank God nobody got chopped, okay? But that's another factor for you to consider.
It's not
Which is
relevant.
exactly why it is not a factor to consider. I don't know why he's not objecting, because this is propensity evidence. She is trying to say he wasn't safe in all these other ways that are completely irrelevant, so he wasn't safe in whatever else she's saying. And I don't know why they're not objecting, and I don't know why the judge is letting it in. And I mean, like, he did not address this enough, and it's going to be, you know, why they decide he's guilty. None of it had anything to do with the accident, except maybe the speed and the weight, but that's still just negligence.
Here's another one. We know from the specifications of that boat, he was going full throttle. Just because that Robalo is rated that it could go as fast as 55 miles an hour, doesn't mean that it's safe. I think I've seen a lot of cars that have speedometers that go past 100 miles per hour. Just because you can do something doesn't mean that it's safe and prudent to do it. Imagine operating a car. A driver puts the pedal to the metal and makes that car go as fast as it can. That's what this defendant did with a boat full of kids. What else makes this reckless? What else makes this criminally negligent? He knows exactly what channel marker 15 is. First off, he'd gone past it earlier that very day to get up to the sandbar. But beyond that, you saw the track marks that were left from his boat time and time again of him going from Ocean Reef to that sandbar. He knows that that channel marker is there. But he pays no attention. What else takes us into the recklessness? There's no reason for him to have crashed into that channel marker. There was no wind. The seas were calm, and it's daylight.
Blackwater.
What else makes him reckless? What else makes him criminally negligent? He's on the wrong side of the channel. Did that in and of itself cause the crash? No, but when you think about the rules of the road say you operate on the right-hand side of the channel. If he's operating on the wrong side of the channel, especially during a Labor Day weekend when you have more vessel traffic, if there is another boat, had there actually been a family boat, right? Where's that boat gonna go?
There you go. Objection, Your Honor. Improper argument, because it's not the facts at issue in this case. Objection. Facts not at issue in this case.
It can't go outside the channel if it's big, because it's going to run aground on the shallow waters of Biscayne Bay. That's a hazard. So all of these things,
That's not evidence.
not just the 9 seconds, But I want to really emphasize, the defense talks to you about the fact that, oh, maybe it was just a couple of seconds. No, it's not just a couple of seconds. I can't stress this enough. This is how long he was headlong toward that channel marker that he knew was there when he'd been drinking with a boat full of kids, with a vessel that's overloaded. Wait for that speed. When he's going full throttle and on the wrong side of the channel. This is how long he is checked out. Ready, set, go.
What was that last one? Why is he not a
That's a long time. Nine seconds.
No, lady, that's not a long time.
That's more than enough time to check your GPS screen. That's more than enough time to see if any other boats are coming around. That's more than enough time to even, if you want to glance at your wife's cell phone. That's a long time to be heading straight into a steel pole with a gigantic Day-Glo green sign on the top of it that you know is there. So it's not just, a few seconds of inattention. It's everything together. You have to consider all the factors that were at play, all the things that had to happen for him to wind up hitting that channel marker. And, as to the defense attorney's point that, but if he only would have just gone a little more in this direction or this direction, he wouldn't have hit the channel marker. Okay, let's think about this. Let's think about somebody that goes skydiving, maybe has a parachute on. Splat, right on the ground. Oh gosh, if only he would have pulled the ripcord, he'd be okay. But that's the kind of argument that you're giving. That doesn't make sense, and the law makes sense. The law can't be such that a person can be that inattentive, can be that checked out, zoned out, spaced out, whatever you want to call it, that you are utterly unaware of your circumstances. You are not taking into account the safety of your own passengers. The law can't abide by that. It's not about labeling anybody a criminal or a bad guy or a good guy. It's about evaluating the conduct and applying the law. And along those lines, I just want to say that to give you an idea of just how much all of these different factors really count in a case like this, I have this rope. And if you look at rope, which ironically for a novel case, I guess, but if you look at rope, there are many little individual strands, none of which by itself would be strong enough to hold on to an anchor or that one boat can tie up to another, okay? But what happens when you take all the little strands of the rope and you start intertwining them and you weave them together, those little strands, when you put them all together, become very strong. And that's why the evidence in this case is very strong for the fact that he was operating his vessel recklessly, and that because of all those other factors, which I already covered when I spoke with you initially, not just reckless. Reckless is the baseline for this conduct. More than reckless. Culpable negligence, manslaughter. To the extent that defense counsel says he never wanted his daughter or his wife or those kids to get hurt, of course. Who would say otherwise? If I had the proof that he deliberately tried to kill somebody, the charges would be different. But just because you don't have an evil heart or you don't have an evil intention, it doesn't mean that you are immune from the laws of this state. If you, even without an evil heart, engage in a course of conduct that is clearly this dangerous and that clearly could have such devastating consequences, then you're properly charged with vessel homicide and manslaughter. Now, I had a feeling that we were going to hear from the defense things like, there's no requirement to wear life jackets. There's no speed limit. There's no requirement for a kill switch. There's no proof beyond a reasonable doubt that the defendant was impaired by alcohol. There's no proof that expired flares don't work. Of course,
He's going to do the
none of those
reasons
things
argument.
individually caused this crash. But again, with the rope scenario, these are just more factors to take into account. Not wearing the kill switch, not having the kids in a life jacket, that you had been consuming alcohol, that you are going as fast as you can. And to say that there's no speed limit on the water, that's not true. There is. The speed limit is set by navigational rule number 5, which Mr. Albert told you about. Pardon me, 6. You have to go at a safe speed for the conditions. It's not the same as being on the land, obviously. We have 55-mile-an-hour speed limits, sometimes 60 miles an hour speed limits. Through school zones, we have 15-mile-per-hour speed limits. But on the water, the rules can't be rigid the way they are on land because the water is a whole different environment. This was a flagrant foul, if we're talking NBA. The defense attorney says, oh, the prosecutor, she tells you all this about Lucy's injuries. And I do. But not really so much to tug at your heartstrings, because I'm telling you,
Oh, yeah.
it would not be a lawful verdict for you to find the defendant guilty just because you feel sad about Lucy or the injuries she had, or you feel sad for her family. That's not what we're here for you to do. But you understanding those injuries was a necessary component of this case. Because you know what? You don't go so fast. Your boat doesn't smash into the channel marker so hard. Your boat doesn't wind up being basically severed from stem to stern. Your boat doesn't start taking on water to the point where it flips upside down and traps a young woman who had her head bashed. You heard from Dr. Garrigan, our Irish medical examiner. He talked to you about the fact that the injuries that she had are consistent with her hitting her head and then her head jerking back, which is why she had that deep bruising in the back part of her neck. And that could cause her to become unconscious. And her now being trapped under that boat, like I said earlier, basically became her gravesite. Her being trapped is what caused her to die. So that's why you needed to understand those injuries, because you know what? You slow down, your boat doesn't hit so hard. Your passengers don't get conked in the head to the point where they are rendered unconscious. You don't wind up unconscious. If you just slow down, operate your vessel safely. He didn't want to do that day. He clearly knew how to. People trusted him. People trusted that he would take their children out to that sandbar and be safe. So he knew how to operate safely. He simply chose not to. The defense attorney talked about alcohol. Oh, everybody was drinking. Okay, well, first off, just because everybody's doing it, A, doesn't make it right. And B, the only people who testified from the boat about whether or not the defendant looked impaired were themselves drinking alcohol. We had...
Notice how she had to constrain that to cut out the first responders?
The defendant's wife takes the stand, and, she acknowledged, yeah, she was drinking. Chambord and Prosecco from one of those Yeti tumblers. She says, yes, I was drinking. But you know what was kind of funny is that in court, she said 1 or 2 drinks. But in her interrogatory, if you remember when I read that to you, and you'll be able to look at it for yourself, in her interrogatory, she said she had 2 drinks. How come she all of a sudden now, oh, I only had 1 or 2? But on her interrogatory, she had 2. Maybe 1 drink here or there, but come on. Prosecco and Chambord. She remembered, but she wanted to undercut how much alcohol she had consumed. So we think that this woman is in a state to really make a good judgment about whether or not her husband should be piloting that boat. Do we think that Cammie, with the 10, alcoholic drinks in her system, is a good judge of that? Caro had been drinking. All these girls have been drinking. They are not the ones to be in a position to make an assessment if he's capable of operating a boat. They're there as kids to have fun at a birthday party. Don't divest your own responsibility onto underage kids that you gave alcohol to. That's what the defense has tried to do regarding that alcohol. It's not a DUI case, but the alcohol can't be ignored. Here's the hatch. You all saw this boat. Here's what it looked like when the police opened it up. And then the police lined up a lot of those alcohol containers that they found from inside. Am I saying that this defendant drank all of them? No. Can I say that the girls drank all of this alcohol? No. But this photograph, States 109 in evidence, tells a story about how prevalent alcohol use was on that afternoon. And because it was so prevalent, he had a duty to be careful. Not just be beyond negligence, but he was so far beyond the pale. It does cross into recklessness, and it does cross into criminal negligence. At least if the defendant was maybe buzzed or impaired by alcohol, at least there would be some explanation for why he crashed into that channel marker that's so clearly visible. No, had too much to drink. At least there's an explanation. You could understand why. Not that you're thinking that it's a good thing, but it's understandable. But let's suppose he did not feel any effects of alcohol whatsoever. Does that then not make him even more reckless and more culpably negligent? Because then what the heck are you doing, buddy? Why do you not see that which is right in front of you? I could almost understand it with alcohol. Again, still not good, not appropriate. But to crash into it if you really were stone cold sober, that's almost worse.
Objection, burden shifting.
Ah. Wow.
Did that shake her off her rhythm?
The navigational rules are the warning to all voters. Violating navigational rules all by themselves will not land you in a case like this. But when you violate so many navigational rules, you're on the wrong side of the channel, you're going too fast. Nobody says that you have to have somebody serving as a lookout, but man, if you don't have anybody serving as a lookout, you'd better be looking out yourself. And he didn't do that. That's like so fundamental. The navigational rules of taking steps to avoid the risk of a collision. Him traveling on that wrong side of the channel marker 15, clearly visible to him. He didn't even abide by that rule. And then, of course, the rule number 8, avoid a collision. He had plenty of time to avoid that collision, he didn't. The defense attorney said to you that it's not fair to his client to say, oh, you shouldn't have had all those girls seated in those seats on the bow of the boat. You know what wasn't fair? It wasn't fair to Lucy and those other girls to operate that boat that fast with that many girls there. Sure, they could sit there, but if you've got that many kids sitting up at the front of your boat, slow down. Don't tell me that it's not fair to him. It wasn't fair to any of those girls, all of whose lives he endangered. This is footage from a drone that did in fact follow a vessel.
A vessel.
It was following the same path that this defendant operated. Here you can see channel marker 14. Let's rewind a little bit. Channel marker 14, channel marker 15. This is the boat that Detective Doral and his partner, Sergeant Kopp, were on operating the drone. The drone is following the FWC vessel that's trying to recreate as close as possible the path that this defendant took on that day. Closer and closer to number 15. Closer and closer. And it's only because Lieutenant Thompson is a damn good pilot of a vessel that he did not collide with that channel marker. And so to the point where the defense attorney said, oh, if somebody was on a drone and watching Mr. Pino operating his vessel, would they want to stop him and say, what are you doing? Yes. Of course they would, because they'd say, what are you doing? Why are you heading right to that channel marker? The drone tells you. Here we are, right by channel marker 15. Here comes the FWC vessel. Look at that course. anyone who saw that vessel coming from that distance would say, what are you doing? Are you crazy? Why are you risking your life and the lives of these kids? How can you do that? So let's talk a little bit about these injuries that the defendant had. It's funny how he's just fine to crawl up onto David Rodriguez's boat when he's so damaged that FWC, oh wait, no, FWC didn't lifeline him away. They didn't take him in a helicopter away. They had fast boats that could get him to the mainland. They had the means to take him if he was seriously injured, like they did for other passengers. Not him. He was treated, you have body-worn camera footage from Lieutenant Thompson on the Elliott Key Harbor. You'll see that he's got his head bandaged, yeah, his head's glued. And yeah, you gotta seal the wound. Stitches don't make a lot of sense for heads, so leave staples. But he needed staples, whether it's 3, 7, but the only medical care that he told Dr. Barrett that he had was therapy and some psych meds. And I don't take anything away from somebody seeking mental health care if they've been through a difficult scenario. But that is not the same as somebody that has a head injury so bad that somehow it causes them to create false memories without the intent to deceive. And then when we think about that evidence, false memories without the intent to deceive, let's go back again one more time. And the defense says, oh, like I'm some kind of horrible person because I have the audacity to challenge what a medical doctor says in this courtroom. I challenged her because the testimony that she gave is not credible, but you're the judges of who's credible. But she literally took the stand and she said she based her finding that he had amnesia just on these 4 things. That he didn't remember who sat behind him, that he said his engines were 225 horsepower, that he couldn't remember exactly what happened post-impact, and that at first he said it was Nazi, then he said it was Lucy. That's it? You get paid 30 grand for that? She didn't even say that he did confabulate, right? She just said it could have happened. But again, reasonable doubt is not a speculative doubt. What evidence do you have that this is really signs of amnesia? First off, we already talked about the fact, and even she testified, oh, whether or not he could remember exactly who was behind him, she's like, well, that makes sense that he would not remember who was behind him. She said, yeah, after a traumatic event, maybe you don't remember exactly what happened. We already talked about the fact that it would make sense if maybe he was confused about which girl he saved initially, because he wasn't the one that brought that child to the rescue boat. He just ducked under his boat after being told to do so and recovered the body, but then passed it off to someone else. And I don't need to refer to Lucy as an A, but that's what he did. So the one thing that we're left with, the reason why we believe that this defendant gave that whole story about a phantom boat is because he thought that he might have engines of only, 225 horsepower? That's not reasonable. I'm not here to bully anybody, but I'm also not here to allow you to not think about whether or not the expert witness that's called is giving you testimony that you should feel comfortable relying on. The witnesses that I got to, trust me, I'm not going over all of them, but I think it's worth kind of looking at in totality. Look at the officers who were called. Bobby Bruto, Sergeant Delgado, Ben Dow, the drone operator, Detective John Dalton, who's both been a Marine Patrol officer and a vehicular homicide or traffic homicide investigator. You heard from Lieutenant Morris and Lieutenant Thompson. Did any single one of them get caught up in some kind of sense that what they were saying to you, they didn't know what they were talking about? That they had some ulterior motive behind doing this? How about the passengers? Cami, Caro, Claudia, Natalia. They don't come here and say, we were there for a good time. We've known the Pinos for a long time. We felt like we were safe, but geez, most of these girls are sitting facing backwards. They have no position to know whether or not George Pino is operating his boat safely. What about the Good Samaritans that you heard from? Hillary Candela, who knows everybody involved, called Katy Puig's dad to say, hey, I'm out here on the water. I think there's been an accident. Hamlet Rodriguez, who takes Lucy's body and gets it to the Good Samaritan vessel. David Rodriguez, maybe a little bit of a character, because, I don't know a lot of people who come across a man that's stranded with his boat and take time to photograph it, but he did, okay. I thought it was interesting that the defense showed you that 6-second video that he had of the defendant, and I was like, oh, you got a picture of him too? Well, come on down here. Let's show that picture to the jurors, and I think that when we zoomed in, you could see the defendant not saving anybody, just hanging onto his boat.
Not saving any.
You heard from a couple of doctors. Dr. Garvin, the medical examiner, and you heard from Dr. Garrett. I'll let you judge who's credible. We heard from some lawyers, Brent Reitman, who was one of the attorneys that represented the Puig family in their lawsuit. Didn't ask him a whole lot, just wanted to make sure you understood what interrogatories were. The defense, I called Mr. Mescalado just to confirm, yes, this is a normal part of the discovery process in a civil case. That was it. I just had him read the interrogatories.
No.
But, when the defense called him back, he starts talking about how Mr. Pino wanted to make everybody whole and all this other stuff. Who cares, right? But it did become relevant that he did try to limit his liability once he makes a statement like that. It did become relevant that he tried to get counts of the lawsuit dismissed.
Objection.
You made it relevant, not me. All I wanted was the interrogatories to come in. But at least he did admit that in answering an interrogatory, it's perfectly fine to say, I don't know. I didn't see the crash. Did Cecilia Pino do that? No. Talk about Mr. Albert. Knows his stuff down cold. Not impeached with a single thing. His expertise in GPS data extraction, interpretation, unchallenged. That GPS data that you got is irrefuted. You talk about Andy Fernandez. Did he stand at the beginning of this trial and as the very last witness, who, despite having lost his firstborn child, kept it together and answered questions. Can you imagine cross-examining that man and trying to get a oops, gotcha? Because, you weren't planning on going there? Well, don't you remember that client sent a text to you about meeting up at the sandbar a week before? Yeah, and at that time I thought maybe I would. But on that day, I was tired from playing golf and I didn't really need to go all the way out to the sandbar and then come all the way back because I had my plans to go football game with my dad. That's the gotcha of the father who lost his 17-year-old child because of the actions of a man that had been his friend?
Wrap it up, counselor.
Rudy Puig took the stand. The injuries to his daughter are not really the issue here, but to the extent that something was made by Mr. Mescalado, the defendant's former lawyer, about, the Puigs didn't settle, you deserve to know at least that she's not the same now as she was before this crash.
All right, Councilman.
Thank you, Judge.
Yeah, finish it. I was gonna wrap up, but let's see if you actually hold it to it.
last 2 points I want to make. The defense in this case had no burden of proof. The burden of proof fell solely on Mr. Borst and me. Throughout this trial, we've presented you with what I would submit are very compelling witnesses. We've presented you scientific facts, data that would substantiate a guilty verdict for both vessel homicide for being reckless, as well as for manslaughter. And so when you go back to the jury room, I'm going to suggest, but it's totally up to you, that you may wish to first look at count 2 of the information, vessel homicide, and that you can make a finding that because the defendant was reckless, even if nobody else was on his boat but his wife, just the direction of travel put him on a collision course, that the verdict would certainly be guilty. But then I would suggest, that it's your call to make, that you then consider all these other factors that were at play on that day. These factors didn't have to be there for a vessel homicide conviction, but because they are there, I'm also asking you to return a verdict of guilty as to the manslaughter charge. Because he did do an intentional act by deciding how fast to go and what direction to travel, and that caused Lucy's death. And because the way that he operated that vessel was culpably negligent. And the very last thing I want to say to you is not me speaking to you, it's you watching what happened in this case. Second to last track one. Channel number 15. With 12 kids on board, if that's not reckless, if that's not culpably negligent, what is? Thank you for your time and attention to this trial, ladies and gentlemen.
I still can't remember if the judge said she was going to instruct them that you start with the highest offense before you go to the lowest. And I think the answer was the state saying, well, because I charged both, they get to do both separately, even though in any other world they're instructed. I don't know if you're muted or
Yeah, I was actually.
no.
Yeah, instead of being a lesser underneath, you mean, like, since it's 2 separate standing charges.
Right. That because typically the instruction would be you have to, start with the highest and only go to the vessel if you find not guilty on the highest, on the manslaughter.
Is anyone please stay quiet? Counsel,
I didn't know that jury because and Katt.
That's not reckless. If that's not culpably negligent.
may see counsel and court clerk.
Okay. Sidebar.
Please, everyone, please stay quiet.
She still doesn't know what she wants to instruct on. Why else would they be having a sidebar? Unless she's gonna ask them, like, do you not want them to start deliberating today?
I mean, that would be the whole reason she did it this way. So was that they could deliberate.
I remember, did you hear her say, like, they could probably stay until 8:30 until they got kicked out of the courthouse if they wanted to stay and deliberate?
I missed it if it was said. I don't remember. No, Bob's back there. I still haven't heard any mention about the enhancement from 15 to 30 as a weapon. Just nothing. I don't get it at all.
Yeah, and I mean, we're going into jury instructions. I still feel like we have this cloud of mystery over how the jury instructions will actually be read. Like that word merely in front of negligent. The last thing I heard was that they were striking the word merely.
Yeah, I guess we'll see.
And I think that's a big deal if so. So,
and I think they should be renewing their request for certain special non-standard instructions based on the arguments
being...
right, especially that whole underlining ordinary and usual.
Maybe that's maybe the judge realized that it would be an issue if he doesn't reprint instructions right now and fix something.
Aye.
And that's kind of how she's been this whole trial. Everything seems to be, oh, we'll take that up later. We'll deal with it later. And then we have these last minute changes. Camera guy is like having a time over there. Just closed whatever it was. Everybody's walking away. Is the court muted or is it?
Yeah, it is. Are they talking? Oh, sorry.
All right, ladies and gentlemen, I'm going to be instructing the jury at this time I would ask if you do not want to sit in the court 20 minutes to do so.
How long?
I would ask if the time is probably taking about 20 minutes to do so. I would ask if you do not want to sit in the courtroom to listen to me instructing the jury. Certainly don't have to, but I would ask you please to avoid going in and out of the courtroom so that there's no distractions for the jury. Members of the jury, you have now heard all the evidence in this case, as well as the final arguments of the lawyers for each side. It is now my duty to instruct you on the rules of law that you must follow and apply to arrive at a verdict. You as jurors are the judges of the facts, but determining what actually happened in this case. That is, in reaching your decision as to the facts. It is your sworn duty to follow the law I am now going to define for you. You must follow all of my instructions as a whole. You have no right or authority to disregard or give special attention to any one instruction, or to question the wisdom or correctness of any rule of law I state to you. Accordingly, you must not substitute your own notion or opinion as to what the law is or should be. It is your duty to apply the law as I give it to you. Ladies and gentlemen, you will have a written copy of the instructions to take and to use in the jury room with you during your deliberations. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. George I. Pino, the defendant in this case, has been accused of the crimes of manslaughter and vessel homicide. Manslaughter and vessel homicide are unlawful. However, a killing that was excusable homicide or that was committed by the justifiable use of deadly force is lawful. If you find Luciana Cristina Fernandez was killed by George I. Pino, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or vessel homicide, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. The use of deadly force, homicide or vessel homicide, or whether the killing was excusable manslaughter, circumstances surrounding the killing in deciding if the killing was manslaughter or vessel homicide, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. The use of deadly force to kill a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon George I. Pino, or to commit a felony in or upon any dwelling house in which George I. Pino was at the time of the killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. The killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances. One, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or three, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. One, Luciana Cristina Fernandez is dead. Two, George I. Pino, A, intentionally committed an act or acts that caused the death of Luciana Cristina Fernandez, and or B, the death of Luciana Cristina Fernandez was caused by the culpable negligence of George I. Pino. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. George I. Pino cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I had previously instructed. To convict of manslaughter, it is not necessary for the state to prove that George I. Pino had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or a grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of another. Culpable negligence is consciously doing an act or following a course of conduct that George I. Pino knew or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of vessel homicide, the state must prove the following two elements beyond a reasonable doubt. One, George I. Pino operated a vessel in a reckless manner likely to cause the death of or great bodily harm to another person. Two, his reckless operation of a vessel caused the death of Lucy Fernandez. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. The state does not have to prove George I. Pino intended to harm or injure anyone. However, the reckless operation of a vessel requires the state to prove more than a failure to use ordinary care. A reckless manner means in willful or wanton disregard for the safety of persons or property. Willful means intentional, knowing, and purposeful. Wanton means with a conscious and intentional indifference to consequences and with the knowledge that damage is likely to be done to persons or property. Vessel is synonymous with boat and includes every description of watercraft, barge, and airboat, other than a seaplane on the water, used or capable of being used as a means of transportation on water. Operate means to be in charge of, in command of, or in actual physical control of a vessel upon the waters of this state, to exercise control over or to have responsibility for a vessel's navigation or safety while a vessel is underway upon the waters of this state, or to control or steer a vessel being towed by another vessel upon the waters of this state. In the state of Florida, the law requires operators of vessels upon its waters to follow navigational rules. However, a violation of these rules, individually or cumulatively, is not sufficient by itself to constitute culpable negligence or recklessness. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything to the crimes charged, as I have previously explained to you. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. During the trial, you viewed and listened to certain audio and video recordings. Some of these audio and video recordings have been edited to eliminate irrelevant portions that would not aid to your understanding of the case. The fact that the recordings were edited should not concern you in any way and must not impact the way you view and or listen to and consider this evidence. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. The Constitution requires the state to prove its accusations against the defendant, George Pino. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement or statements claimed to have been made by the defendant outside of court have been introduced into evidence. Such a statement or statements should be considered with caution and be weighed with great care to make certain it or they were freely and voluntarily made. If you conclude the defendant made the statement or statements, you must also determine from the evidence whether the defendant's statement or statements were freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to: 1, whether when the defendant made the statement or statements, he had been threatened to get him to make the statement or statements, and 2, whether anyone had promised him anything to get him to make the statement or statements. If you conclude the defendant made the out-of-court statement or statements, but it was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find George I. Pino guilty as charged or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. We will also have the verdict forms with you in the jury room to use to document your verdict. First, verdict form in the Circuit Court of the 11th Judicial Circuit in for Miami-Dade County, Florida, State of Florida versus George I. Pino verdict. We, the jury, find, you can't probably see it from there, but we, the jury, find as follows as to count 1 of the information, manslaughter of Luciana Cristina Fernandez. The defendant is, and the first line, guilty as charged in the information. The second line, not guilty. You check only one. So say we all on this blank day of blank 2026. The foreperson is to sign and date and also print their name and date on the verdict form. Second verdict form. Again, in the Circuit Court of the Judicial Circuit in for Miami-Dade County, Florida, State of Florida versus George I. Pino verdict. We, the jury, find as follows as to count 2 of the information, vessel homicide of Luciana Cristina Fernandez. The defendant is, the first line, guilty as charged in the information. The second line, not guilty. You check only one. So say we all on this blank day of blank 2026, the foreperson is to sign and date, and also then on the next line, print the name and date. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. In just a few moments, you're going to be led into the jury room by the court specialist. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. Any notes you have taken during the trial may be taken to the jury room for use during your discussions. Your notes are simply an aid to your own memory, and neither your notes nor those of any other jurors are binding or conclusive. Your notes are not a substitute for your own memory or that of other jurors. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court specialist. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of devices into the jury room. Kindly leave those devices on your seats. Actually, Renee is going to collect those from you, and he will keep those and guard those for you while you deliberate. If you need to communicate with me, send a note through the ballot, court specialist. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. You will have a laptop to use to view digital evidence. You will also have a device to use with the computer to be able to view the other digital evidence introduced during the trial. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, actually coming to 250 years, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Are there any objections to the manner in which the instructions are read to the jury?
Yes, we approach.
Sure.
Yeah, it's a big problem. I don't know what it is, man. Anyway, they did it pretty nearly. They did say merely when they read it, by the way.
They did.
Yeah, merely negligent.
Thank you. I missed that. My mobile data decided to wonk out right in the beginning of jury instructions.
Oh, they muted it for us, so I got the sound back on.
Yeah, these instructions I think are rough. But who knows if, I mean,
So
I like to see it on paper.
Since she's charged manslaughter under the 2 different theories, the jury technically doesn't have to be unanimous on which theory. They just have to be unanimous on manslaughter.
One or the
But
other.
the way that I can't grasp this is because under one theory, it's a
There's
lesser
intent of
included
an act.
offense, and under the other theory, it's not a lesser included offense. So it just there's so this case has shown a severe gap in Florida law that I don't know that they're going to want to take up or whatever. But Florida does this thing where you file an appeal and the appellate court just says affirmed on their non-reported, which any case that mentions vehicle or vessel operation and manslaughter with an intentional in the same, document is all unreported. So you don't see anything about what the courts were arguing. I can only see like what the lawyers were arguing. And in some of them, although it's not the same factual scenario, they're pointing out you've got this huge issue with the law here. You've got culpable negligence, you've got intentional act, and then you've got this definition of excusable homicide that basically says it can't be negligent. And the funniest thing is when they were first talking about changing the law, because you got to think of this as voluntary manslaughter and involuntary manslaughter. That's how you look at the intentional act versus culpable negligence. It's as though it's manslaughter and involuntary manslaughter, voluntary
Which
manslaughter.
would require unanimous because it'd be separate guilty, not guilty lines.
Right. So this is the state's brief in like 2009, and they're trying to get them to take out the intent to kill, which used to be if you did the act, it has to be an act that was intended to kill. So this is the argument they made. Rejecting intent to kill in favor of requiring a deliberate act resulting in death should also end the occasional confusion arising from the notion of voluntary versus involuntary manslaughter, that a deliberate act causing a clearly unintended death is somehow manslaughter by culpable negligence. And they cite a case and they say, compare Brinkley, where they upheld the denial of a dismissal on appeal for conviction of manslaughter by culpable negligence, where the defendant shot and killed his live-in partner's adult daughter, thinking it was a burglar. And Light versus State, which was they entered judgment for manslaughter by culpable negligence when the defendant and the victim scuffled in a mosh pit. The defendant picked up the victim, slammed him to the floor, and the victim was later died as a result of a head injury. So, and I'll give you the next comparison, but before I do that, the state here went on to argue those two should really be manslaughter by act, not culpable negligence. Then they give this third example. Upholding a conviction for manslaughter by culpable negligence when the driver crashed into a tree and killed the passenger. The driver had been consuming alcohol, was driving at an excessive speed, was in a total darkness on a two-lane canopy road, etc. And again, the state suggests that Brinkley and Light, although reaching the right result, actually involved manslaughter by act when death was plainly not intended, while Davidson, the one where he's driving, correctly treated as manslaughter by culpable negligence. The useful distinction is not the defendant's intended result, but whether the defendant acted deliberately toward the victim. And this was the state's motion or petition to the Supreme Court of Florida saying, hey, the courts are confused about when it's culpable negligence and when it's an intentional act. And we have to get rid of this intent to kill and just require an intentional act that caused an unintended death, that caused the death. And they go on to make it clear that basically what we're looking at here would stay culpable negligence. And when you intend an act directed at somebody, it should be intentional act, manslaughter. So, I mean, it's really a huge issue that the court just has not taken up under any of the cases where it gets brought up, as far as once
Whether
they
it
got
should be
rid of
different offenses versus
and what the state would need to prove and what constitutes an intentional act, because the law used to be very clear that an intentional act has to be directed at a person, and now technically the way they've changed everything around, intending to speed and intending to drive dangerously close to whatever could constitute an intentional act, but it can't be considered what the law intended, because why in the hell do you have the whole vessel vehicle homicide?
Yeah,
and
I was
why
just
is
thinking
it
that, like,
and why is it a specific carve out that is a lesser included of culpable negligence manslaughter? If it doesn't matter, if you can just say your choice to intentionally operate in this manner constitutes the intentional act, then what the hell is all this other law for?
Ladies and gentlemen, I am going to ask please
Scheduling?
Gotta give them their-
if Miss juror number
Oh, will be the appointing judge.
29,
Do the-
initials MD, please stay in the courtroom.
Oh, no.
Juror number 35, initials
Oh,
They're gonna be the
AM,
alternates.
please stay in the courtroom. Juror number 448, initials CL, please stay in the courtroom. And juror number 63, initials NL, please stay in the courtroom. The rest of you, please take your notepads and please enter into the jury room to begin your deliberations.
All right.
Everyone be seated, thank you.
It's very coffee today.
Well, ladies and gentlemen, you might feel extremely disappointed at this time that I would advise you that you have selected as alternate jurors in this case. The disappointment may come from the fact that 4 of you have sacrificed over 3 weeks, how many days, but various number of days, to serve as jurors in this case. The sacrifices really were extraordinary. This was not a 1 or 2 day trial. We engaged in an extensively long jury selection process. And then the trial proceedings, again, over the last few weeks. It took so much for each and every one of you to place this, your service on a jury in this community, as your priority. It was forced upon you, really. You didn't volunteer for this work. It says so much about each and every one of you as citizens in our community and in our country as to how you value your responsibilities and this branch of government. If we don't have citizens like yourselves to make these sacrifices, it'd be chaos. This branch of government must remain strong and does remain strong because of citizens like yourselves. And again, this was just not an ordinary sacrifice because of the length of time that was involved. And not only did it impose on your time and disrupt your lives, but I'm certain it disrupted the lives of those closest to you who had to pick up the slack and to take on responsibilities that you normally undertook. But you were here to do this work. And the disappointment may come because you are not engaging in the last part of the work, which is the deliberative process. It's really just a token of appreciation, what I have from each one of you. I'm going to step down and give to each one of you this certificate of appreciation, again, which might feel a little insulting because of the sacrifices that you've made to do the work. But please understand that you are no less important to us and for what has been done and the work that we all have done than any of the other jurors. We don't tell people that they're selected as alternate jurors because there is the risk that they may not give the case the same attention and consideration as they would normally do. So let me tell you, keep it secret. So
Someone has to
with
find
this,
a
let me also tell you, once I discharge you from your service, you have no further obligations to this court. You can keep your privacy as you will. You are not required to speak with anyone at all. You become like every other citizen. We are a public courtroom. You're welcome to stay. You're welcome to go home. But you no longer have any obligations or commitments to court or to this case. And again, you can maintain your privacy, even as an alternate juror.
Aye.
Unless this court orders you, which I will not, to speak with anyone. It is your prerogative to do so. Okay. So let me come down and give you each a certificate, and then I will give you
order
each
juror to speak with
discharge and farewell.
In order them not to do. So they gave the jurors their oath during jury election, but they didn't do it.
Miss M.D.
I'm surprised releasing them now in case something would happen.
Miss
Like what if
A.M.
someone refuses to deliberate?
Right, or
That apparently happened in the Michelle Jones trial in the same courtroom. I don't know if they released the jurors, but they didn't sub out the juror that apparently didn't want to deliberate and wasn't going to change their mind.
So you can gather your personal belongings if you would, and you can leave your notepads. If you want to take them out, and they will collect them, and they will be destroyed. And again, prerogative to speak to whoever you wish to speak to or no one at all. And again, I want to thank you on behalf of myself, on behalf of all the parties, for the extraordinary work that you have done. We are proud of you. We are proud of you as citizens in this community for the sacrifices you have made. And thank you for doing that work that you have done. We are proud of you. We are proud of you as citizens in this community for the sacrifices you have made. And thank you for doing now discharge.
girls or boys.
Stay still, please.
Woman.
It's the alternates that were pre-selected, I think, because it was 3 women, 1 man on the alternates.
Oh, okay.
Oh, there's 4 people? 5? What?
Oh.
Okay, that's just that's a judge. Why did she come down? She shook their hands or something?
He handed them all their.
All right, you can all be seated. Let me give you some further instruction with regard to jury deliberation. This courtroom is clear and locked. No one is cleared in this courtroom other than, if necessary, court staff, but certainly just the court specialists, my bad. So, this includes the attorneys as well. But before the attorneys leave, we need to look at and go through all of the evidence to make sure that what is to go back to the jury is separated from what is not to go back to the jury. So I'm going to let all lawyers start to gather to do that work. As for everyone else again, if there is a question, we will notify the attorney. If there is a verdict, we will notify the attorneys. In addition, we don't disrupt the jury in their deliberations, and we will work to a reasonable time. We're not going to work until wee hours of the night. Just to let you all know that. It's not my intention to do that. The jurors don't know, we don't tell them. So we're just going to let them work. And again, everyone, the courtroom is cleared completely. We don't allow anyone in the courtroom during the deliberations. Renee may wind up locking the door even. So you should take your personal items and belongings with you. And I think we'll probably work until somewhere close to 8 o'clock and see where we are at that point. If the jury has not reached a verdict at that point, I'll explain the process to you all now. We will reconvene. I will instruct the jury that they're going home, they're not sequestered, and they return the next day. We don't meet. They are brought right into the jury room to continue with the deliberations. The parties do not gather at all. So this courtroom will remain locked. If you do have to come back tomorrow, we will remain locked, will not be open for anyone other than Renee and the jurors to continue in their work. Okay, so just to give you a preview, and we don't know, but that's kind of our plan for today. Thank you very much, ladies and gentlemen.
Chat time. Chat time. All right, so I mean, to round it off, deliberations started kind of at the hour. Started like 3 or 4 minutes before the hour.
Yep.
So I'm gonna ballpark 5 p.m. Eastern is when they started deliberating. To me, it looks like the alternates were the pre-selected alternates. It was reported before trial that 3 women and 1 man were selected as the alternates, which makes me think that avid voter guy is still there because he was reportedly as part of the seated 6 jurors.
Right.
So, chat, come back in.
Chat.
Did you re-enable yours?
I did.
Run, Ali.
No, I did.
Thank you so much also for taking over and getting the stream going after my
I
internet
wonder,
went out.
are you like not in control anymore? Did I have to let you in?
No, so when I first tried to join after coming in with mobile data, it was going so slowly, I didn't even want to risk like pressing add to stage in case something like lagged and pressed weird. But now it seems to be smooth, so I can operate things.
Okay.
Kind of. And while we were watching arguments, sometimes the video would freeze, but I could still hear what was going on. So Spectrum said 5 p.m. Restoration estimated time, and we're 7 minutes past that, so we'll see. We'll see if the verdict comes back faster than my internet comes back.
Why don't we have any comments? See, it's showing me now if I try to send a message, I'm you. I sent that test.
Oh, that's crazy.
It's, I
Yeah,
guess,
it says
because of
Ken
the
Williams.
whatever you. Oh, I'm gonna start saying a bunch of stuff.
Ooh.
Speak for Cat.
Does it give you a toggle where you could change your chat at the bottom? Like where you were, if you were to type through StreamYard, can you click my picture and
No,
switch
like I
to
clicked the picture, there's nothing there.
weird?
Yeah.
One time, Nick Starro gave me admin permissions on his StreamYard when he was traveling in case like he had an internet kerfuffle with a hotel and needed someone to go in and turn the stream off. And when I was leaving a panel stream he was doing, instead of clicking leave studio, I clicked the end stream button and ended the whole stream for everybody.
Oh no.
It was bad. It was bad.
Oh Lord.
They were ending soon anyway, thank goodness, but that was a whole time. So
Let's see. I'm gonna put Court TV back on in the background here, I guess. Why are we not getting anything? All right.
maybe if we put them on the screen, they'll start coming in.
Well, they are on the.
Yeah.
Wait, what do you mean? Oh, what's going on?
I can see Lady Di gifted 5 memberships. That's so nice. I want to be able to pull them up. Thank you, Lady Di.
Oh,
you're
that's
doing
right. I
well.
could go in that other way and look at it. Okay, let me do that.
It just doesn't let us like pull them up.
How do I do it?
Until they populate.
I go into my. Like I go. I don't know.
You mean on YouTube?
Yeah, into studio.
Oh, if you go to your studio and then look for the little like it's like a little radio live button, and it'll show you like a live stream panel. I think this is the longest it's ever taken to pull comments back in.
I'm just gonna double check that mine is set. But I wonder if it's could be because I'm you right now, but I'm logged in to YouTube as Bob, so that's different. Okay. I
It's
don't
like
get it.
Freaky Friday. Oh yeah, they're here.
Oh, good, because I
They just
couldn't
came
figure
through.
out the other thing. Hey,
Took
there
me
you
like
guys
9
are.
seconds to realize it.
And it's so now I see the click, I mean the paperclip, but I'm assuming it's telling me like I'm you that that's from Defense Diaries, right?
Wait, give me an example and I'll let you
Like
know.
Matthew, I see the little paperclip thing.
Okay, can you give me like a recent comment? Sharon just said
That's
ha
the
ha ha ha
first one.
ha in from KNW. I still see paper clips for
Yeah, like
let's see.
this one, Kai.
That's a paper clip, that's you. Do you see a paper clip?
Yeah. So that
So that's
means
for Defense
it's
Diaries then.
Defense Diaries.
Yeah, so it must be
Okay.
showing you everything as me. That's weird how they do that.
Well, hi guys. Welcome back.
All right, guys, put a let's do a 1 or 2 in the chat poll. How should we do that?
Boy, I
Put
think
a 1 in
we
the
should.
chat if you think jury instructions were confusing. 2 if you think it's gravy, like the jury will get it.
Well, this America for Justice. No, not America for Justice. Who said it? Somebody
Right as we
said.
flood with 1s in the chat.
Oh,
I
Kat,
don't
I'm
see
not
a
sure if you
single.
know
Oh, I
that
see 1 too.
this judge most often leans defense and her sentences on the light side.
So I haven't
Shocking.
watched trials with her like through the end of verdict, but I've watched a lot of plea colloquies and also like how she's handled some pretrial matters, and I can see that. I just haven't watched it something with her to the sentencing stage.
All right, most people are 1s. We had a 2.
Yeah, I saw 2 up there. I see another 2. See right there. We gotta leave the 2 on here for 9 seconds.
Hello says, gang, I had questions, but I done forgot them.
That's
Go
the
ahead,
hard
you
part about not
take
having a
over
chat right away.
You could take over the pressing of the
All right,
chat.
sweet. I can pull Lady Di up. So again, that's super, super nice. So thank you so much for gifting those 5. Definitely wanting to pull this up and make sure we properly thank you here. So thank
Very
you so
nice,
much
Lady
again.
Di. Yes.
So nice. We also
Bob,
have,
what are you doing back there?
Yeah, Bob. We have Lori here with the 5. Thank you so much, Lori. No
Very
comment,
generous.
just pure love.
Yeah.
Sometimes it's like what some of this makes me feel like, just like no thoughts, like certain things that were being said. You know, and again, I'm a bit shocked that we are leaning so far into the intentional act, the 2A versus the 2C.
Yeah. Yeah. And I mean, like, I don't know if people care as much as I do about this whole, like, just issue with the law in Florida. It's like, I mean, the case is consistently fined for manslaughter intentional act. They involve direct physical acts against a person. The defendant intentionally punching a victim in the face. Like in a 2011 case, the court gave an example of firing a gun at another person. And even in 2017, the defendant hit the victim with a bat. And then, like this is just
Where it seems like the idea is you intended to do something to cause harm. Maybe you didn't intend the death. It kind of reminds me a little bit of like a felony murder.
Which is what the instruction still says. 7.7 still says, I'm going to pull it up now. Let's see. No. Wait, I got to go to part 2. I'm looking at the table of contents. So, okay. Homicide 7.7. And I'll just share the screen so you guys can see what I'm seeing. So first you've got this part. Every person has a duty to act reasonably towards others. If there's a violation of that act, of that duty, without any conscious intention to harm, that violation is negligence. I mean, it says that without any conscious intention to harm. Now, if I was the defense, this is one of the things that I would have been putting up there, saying you need to have she says it's what's in his heart and his mind doesn't matter, a conscious intention to harm. But then they also have here, wait, no. Right. So to convict on manslaughter, it's not necessary for the state to prove the defendant had an intent to cause death. So harm is not there. It just says death. So again, I guess they still have to show an intent to harm, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. So, and then I also would have highlighted the thing here again that for culpable negligence, you have to know or have reason to know it's likely to cause death or great bodily injury. Not like it has the potential, it is likely. So,
Yeah, it's going back to and honestly, I think Howard might have missed like the idea that he's had to deal with these arguments for the last few weeks, last few months. And maybe he's taking for granted that the jury will pick up to his speed. And maybe he didn't jump into explaining it quite enough. But this idea that during outside the jury presence arguments, when the jury wasn't there, this idea that having an accident plus fatality is not enough to get you to manslaughter by culpable negligence. And I think that was such a simplistic way to say it. And I don't know, like harping on that in closing, one of those stupid handwritten signs could have been effective.
and if you look at culpable negligence, it is harder for the state to prove than intentional act, because if they can show the intentional act, they don't have to show all this other stuff. But that's why it has to have an intent to harm or directed at a person, because when they define culpable negligence, we got that one. Okay. But culpable negligence is more than the failure to use ordinary care towards others. For negligence to be culpable, it must be gross and flagrant. That's where all that extra language was coming from. Culpable negligence is a course of conduct showing reckless disregard for human life or a grossly careless disregard for the safety or welfare of the public. And then again, where they say that it's consciously doing an act or a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. That's not the same under the intentional act. So that's not a thing for that. You don't even read it if you're going under intentional act. And then again, the problem here is vehicular or vessel homicide is a lesser included offense of manslaughter, but only under the theory of culpable negligence, not under the theory of intentional act. And here, when you don't have to have the jury distinguish either, she's like, well, we said them both. So you're telling me they can just plead it as both, even though there's not a different intentional act that you are relying on. And that can circumvent the entire lesser included offense, law, the entire vessel and vehicular homicide law, and the entire instruction that the jury is supposed to start with the more severe and only get to the lesser. Like the way she's saying it, it's like she thinks that these will be not merged at the end. Like if they
I was
found
going
them
to say,
guilty
it
of
seems
both.
like a way to get around a like matter of law and or a argument about an inconsistent verdict.
For sure. But it's just shows like a really big kind of gaping hole in Florida's law, It's like, is it, person directed acts only, that the intentional act must be directed at a victim, like punching, shooting, or hitting, or is it just general conduct? The intentional act can be can be a violation that causes death. So then your choice, if you chose to drive at that speed, knowing the conditions were too dangerous for that speed, then your what would traditionally be culpable negligence is now intentional act homicide.
There's also,
Choosing
it came on the docket now after they entered the jury notes at the end of the day here, but it was filed yesterday. It just didn't hit the docket till now. Pino's objections to the June 12th amendments to the manslaughter statute.
which I guess are less
So
important now that she read the original ones anyway. But let us know what was the change. They made it
here, I'll put
less
it in.
severe, I guess.
I put it in the private chat just because I'm wary about sharing windows right now since I'm using my hotspot. Maybe I should
Okay.
check and see if the internet's. But yes, my spectrum's still not restored. What a day to lose internet. And it was right in the middle of like the defense's arguments too. Like it could have been any other time, but no. Also, I took issue with the we know. We had a we know in the state's opening and then also in rebuttal that he was going full throttle. We know that he was going 47 miles per hour, but my understanding is that was an extrapolation from GPS data. We don't have black box data that's saying this is what was recorded as his speed at this moment. But she was phrasing it as we know when it's a fact in dispute, and I thought that was improper, but there were no objections either time.
So he went back to the misdemeanor culpable negligence 8.9, which the judge said that instruction doesn't come into play when you're dealing with culpable negligence under the homicide charges. And I'm just looking to see what's different. I mean, I don't know. I'm assuming the red is the change, but I don't know if it's okay. So prior to June 12th, the standard included this reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to the consequences, which shows wantonness or recklessness. Or a gross careless disregard for the safety and welfare of the public, or shows an indifference to the rights of others, as is equivalent to an intentional violation of such rights. They really wanted that language in there. And then post June, so the new one, so it's okay. It says the negligent act or omission must have been committed with an utter disregard for the safety of another. I mean, they weren't reading either of them, but I think they just wanted this to stay as part of the record that they were asking for this, and they were asking for the one that was in place
The
at the
special
time.
instructions
Right.
too. Like they wanted the pattern language before the change plus a special instruction to clarify any confusing elements pertinent to this case.
Right. And I think the court would have probably said, well, considering that they changed the law, you have an even weaker argument defense, and that would have been accurate. The reason the difference was with burden of proof. Let's see. So they said for this one that the court denied both requests and included only the 7.7 culpable negligence, which is now almost exactly the same as the definition set forth in the newly amended misdemeanor culpable negligence. So what is the point of that? What is the point of saying that? So he's just continuing to decline his, continuing to assert that an objection to them not reading it. I don't know how that argument actually supported them. Like, well, now it's exactly the way it is in the other one that you're already giving. So I don't know how that like actually strengthened the defense's position that she needs to read the old one too, even though this is a homicide case. So when an unforeseeable court construction of a criminal statute is applied retroactively, the defendant has to. Yeah, I don't think that this would have mattered. They're talking about when the law changes and then they apply it retroactively. That's not fair, but it's not really what happened here. As a general proposition, a newer jury instruction under which it is easier to convict cannot be applied to a crime which pre-existed because it's an ex post facto violation. Oh, there's a but C. I was like, that seems odd. They cite this but C, although we question the continued viability based on the holdings of another thing. We do not reach the question. Okay. I don't know that that's a real strong argument, but when you get to the amendment to the culpable negligence definition, I see they're talking about a culpable negligence definition that's not in play here. They're still talking about 8.9. Now tracks the definition of culpable negligence in manslaughter. I don't know why it keeps doing that every time I move the mouse. According to the standard instruction, culpable negligence 8.9 is a permissive lesser included of vehicular homicide, which you didn't ask for. With a lesser standard of proof, lowered mens rea, this creates an anomaly. Under the standard instruction, the lesser offense of misdemeanor culpable negligence has a higher mens rea, gross and flagrant, than the mens rea required for willful and wanton disregard. The greater offense of vessel homicide. Meanwhile, vessel homicide is a lesser included offense of culpable negligent manslaughter. I know, but that's because technically in the reverse of just the misdemeanor culpable negligence, this would be it's the lesser included to vessel homicide. So again, I just don't think their arguments there matter. I'm probably not really explaining this as well as I could because some of it just doesn't really matter. Plus, I don't know why they didn't ask for that lesser included too. Since it's a separate offense that she's charging separately, they should have asked for the lesser included as to the vessel homicide. They should have asked for the misdemeanor. It's exactly what they asked for manslaughter. And the judge was like, you can't have it for manslaughter because for manslaughter, it's a homicide. So you can't have a non-homicide. Well, then you should have asked for reckless homicide because that's an exception to the whole non-homicide lesser included. If it's vessel or vehicular homicide, you can have this non-homicide misdemeanor. It's the exception to that rule that you can't have a non-homicide lesser for a homicide case. The defense didn't ask for it. They asked for it as a lesser to manslaughter. They didn't ask for it as a lesser to vessel homicide. I don't know if they know something I don't know. They've got something in their minds that I don't know, which is why they got rid of the whole 60-day lesser included. Like, I don't get any of it,
I think it's a gamble. Maybe it'll pay off. I think the hard part is you still have two choices, right? So if there's jurors that want to go to the top level, jurors that don't, they could compromise and just say, well, let's just go for the vessel homicide because that's
right. And now they don't have the lesser included on the vessel homicide. I think it was stupid. This is what Bob kept saying here. The court should define the intentional act as the elision, so that they must prove under 2A that Pino intentionally committed an act or acts that caused the death of Luciana Cristina Fernandez is the elision itself, because no act short of alighting with channel marker 15 itself caused Lucy's death. And that, they should have The defense should have been bringing this home in their closings, saying, don't forget it says, and caused the death of. So again, and I would go through all the things that we knew she was going to say. The expired flare did not cause the death of. The, the question, all these things did not cause the death of. It was the elision itself, and that wasn't intentional. And then the judge would have had to say it's not the law, but she's not even sure. So,
Yeah.
but he could have
I
avoided
think
all of that by going back to 7.7 that says a conscious decision, a conscious, an act that is, it's right here. What the hell can I, like consciously intended to cause harm or whatever it says.
I
With the
think the judge is
conscious,
fine letting the appeals court reverse her.
yeah, without, it's an act with that there's a violation of that duty without any conscious intention to harm. That violation is negligence. He needed to keep saying that over and over again. If there was no conscious intention to harm, that violation is negligence.
Do you
And then
think it's just a dumb idea playing in my head? I feel like Laura Adams was very calculated in figuring out how to work in the most possible exposure for this defendant, for George Pino, without having to bring in a BUI, because not that I really think she might have actually tried a BUI, even knowing that they might not have the evidence to support it. But what I think she might have been afraid of is possibly bringing in the hospital BAC from 11 p.m. with the 0.00, which
right.
would have looked very good for George Pino, but because there is no BUI, we can keep that part out, but we can still say the 2 beers thing. So by charging it this way, we can have our cake and eat it too.
And I think that they should have argued that her keep relying on the drinking and especially focusing on it in the
2 beers.
closing, right, that they should have been allowed to get that reading in. They weren't, right?
Mm-mm.
Did we put up at for Dread's comment?
We didn't read it.
The way I understand the judge read the instructions, it seems they only need one other element to find guilty because Lucy is dead. And I think Laura's snaky ways is going to confuse the jury. I agree. I absolutely agree. And then hello said, and thanks for your generosity at for Dread. Has anyone, defense or state, ever objected during jury instructions while being read to the jury, or would that be disrespectful to the judge? So, I think we might have seen it in read. I can't remember if it was one of the reads, but usually it would be like, as the judge is reading it, you'd say, Your Honor, can we have a sidebar? And she'd know something was up. But you would want to address it like sooner rather than later. Or I guess you could wait till she got all the way through it, depending on what it is, and then have her fix it. And then sometimes the judges say afterwards, before the jury goes, like they did there, they had a little sidebar before they let the jury leave. So if she had made a mistake, then she would have had the chance to correct it. But it wouldn't be an objection while she's reading it. It would just be more of a, do you interrupt or do you wait to the end? Right. Yeah. And thanks for your generosity. Iceman cometh. What's he got to say, babe? Yeah, he's muted. So
Bob.
I had a big problem with the flagrant foul.
What up,
There he is. Foul analogy, only because the NBA keeps changing the rule. And if any of the jurors watch basketball, that may affect them because it would definitely affect me. What do you got to say on that, babe?
Are
you familiar
foul
with this?
Yeah.
Changes in the NBA's.
Yeah, I thought it was, I didn't hate the analogy as much as Iceman did. It's a little different though. It's a flagrant foul in the NBA. They do keep changing kind of the rules of it and what constitutes flagrant, but it's usually a high level of intentional violence that goes beyond just like, because you can sometimes accidentally foul somebody. They're taking a shot. You're going up to block. You hit their hand before the ball releases. That's just a foul. sometimes you can intentionally foul, where you're meaningly or with meaning trying to hit their arms so that they can't get the shot off. And that's not necessarily flagrant. Is like when you're doing something intentionally with intent to maybe harm them.
And so it requires some sort of malice.
So it's like a
Uh-oh.
low version of malice, like a low form of malice, I would say.
Thanks for your generosity, Iceman. And then Hello came back with a good question because I actually meant to explain this and I think I got distracted by it. My question is, if they don't go by the new instructions they already argued before it went to the jury, can they object to the judge? So she didn't change anything. If something changed like that, they would object at sidebar. It still wouldn't be like objection out loud. It would be like, can we approach? And then they would object. But here, with the reasonable doubt instruction that was changed, when they did jury selection, they would have been introducing the jurors to the concepts. And it actually says in the Florida rules or jury instructions that they should be introducing the jury to the concepts of the certain concepts of reasonable doubt during selection. And that's why the judge said, all right, we're going to read the old one because that was the one that was in place when we selected this jury. And that's what we introduced this jury to. Now, if they didn't go by the new instructions, they already argued before it went to the jury. Yeah, they can ask to approach and then object on the at the bar of the court. It's not like a typical objection that you need to stop a lawyer from asking a question. You just need to get it, on the record. And they probably did on the side over there, just like restate certain objections after she finished reading them. And thanks for your generosity.
So I started.
Hold on, I have a Venmo
poll.
from Tiffany. Thank you, Tiffany.
Oh.
It says, tell Ali to check Bob's Venmo.
Oh yeah. Oh, okay. Let's see.
Let's see who checks it first.
So Tiffin said in rebuttal, Adams comes off as desperate. She is the epitome of the ick. Now,
Yeah.
Ali once really, really had to school me on the use of the term ick because she told me I used it improperly when it wasn't relating to a relationship, right? Like a boy.
I did, but I'll be a lot easier on Tiffany. Tiffany's fine.
I mean, she really read me the riot act about the misusage of the word ick in relation to something. Like I said, oh, it gives me the ick. She's like, no.
It wasn't even a person gave him the ick. It was like, I don't remember what it was.
Gave me the ick.
It was wrong. It was way wrong.
I'm with Tiff. I think it's got a much broader usage pattern than you give it credit for. I think
she's using it way better than you used it. I'll tell you that. But Jody,
as a matter of fact, she's using it exactly.
Nope.
Thank you, Tiff. I feel so validated. And thank you for your generosity too.
Yes, thank you for your generosity. Jody said, I think not guilty. They should have objected more. Love y'all. Well, thank you for your generosity and your.
All right, so I started a poll. Kat, have you started a poll?
I did a verdict today, yes or no.
Okay, what are they saying?
Vote, guys.
What do you at?
I gotta go, babe. I think we need to decide
2/3, yes.
How we're gonna get notice if there's a question or a verdict to restart at some point after whatever we started.
Well, Kat's just gonna have to set another live.
That
and
just
then
goes.
Yeah, and then I'll jump in when she sets it, and I'll set it for us to be able to dual stream it. And then whenever a question or a verdict comes in, at that point, then we just fire it up.
Yeah, you could set it for 8:30 Eastern time, and then change it if something.
Where do you have to go?
I got to go to get Scout's stuff before she's got to go to practice. She have a game or practice?
Practice.
So she's been being very patient.
About what?
What up, Doe? Her phone.
Oh,
All right. I'll see you guys
Oh.
later. Bye, Kat.
See ya. All right, so you got another one. Well, I think you kind of
Another-
just read it because you said what up though, but you didn't.
oh, what up, Doe? What up, Iceman? Thanks, brother. So my poll was, what do you think the jury will do? The jury, not what do you think is going to happen, but what do you think the jury will do? Always a separate question. So we're about 200 votes in, just shy of it, and it's 50-50. Guilty on one of the counts, not guilty on all counts. 50-50. Straight down the middle, split. Straight down the middle.
I think that's actually a bit more optimistic than before closings. I think, did closings rub people the wrong way and think like maybe the jury won't take so well to the argument of the state?
Yeah, I mean, that's why I definitely distinctly went with what will the jury do as opposed to what people might be thinking themselves personally about the case. I mean, it's pretty clear from what I've seen in our chats and our Venmos that we've been sent during the trial. There's not a huge fan base for Laura Adams. So, I mean, my whole problem is that I just think that she's trying to push this case that I just don't think should have been a case. To me, it really is just a civil case. It's as simple as that. I mean, that's how we've kind of landed on trying to make people whole in situations like this. Because if you subtract everything out of it, like if you take Lucy's death out of it and you take the debilitating injuries to the other passenger out, and you're just looking at the conduct on its own, there's nothing culpable about it. There's no culpable negligence. There's no recklessness. I mean, like, that's what I kept trying to say. The same thing that Howard's saying, that the hitting of the pole itself is the thing that we're talking about. And was he negligent? Like, him going 47 with 10 girls on the boat, if he doesn't hit the thing, is not an issue. It's not negligent.
Well, at least the state got their polls straight for closings, because to me, it was very frustrating that they didn't know the difference between 13A and 13 and 15 and 14. Like, they just had no care or concern until they heard the defense argue it, that they needed to be able to distinguish between what somebody would be seeing as they moved forward through the channel. And I think that's the type of thing that if you really want to see a conviction, those are the basics that you should be getting right. I also think it's helpful to maybe not the very first witness, but start earlier with give people an idea of the point of view of what the channel looks like. I thought the channel width was going to be so damning for George Pino. And then it's like this tiny narrow channel. Like, well, I wouldn't know which way to be on the left or right if the channel markers are staggered and not even like bink, 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 bink. And it's like they couched that to the end a little bit as if they knew that wasn't going to support the way they were arguing it. And I just don't like, it's a turnoff for me when people don't embrace the good and the bad. I also don't like that we had a bit of burden shifting in the closing. I always hate to hear that. This almost mockingly, the prosecution was discussing, well, the state's giving you, I mean, the defense is giving you these explanations. Those are just speculations, as if you haven't just done the same. And yet you're the one that's supposed to give, granted, you're arguing two theories here, but you're supposed to have some somewhat specific idea of what happened. Your case should not be the one where it could have been this, or it could have been that, or it could have been that, or it could have been that, or it could have been that. Just return a guilty verdict. That's not how the government's supposed to be able to prosecute somebody. And I feel like that's what we're getting here.
Well, I mean, the fact that she hasn't landed, or the state hasn't landed on a theory at all, to me is a reasonable doubt. Like, you don't get to convict on speculation. It's that simple.
Yeah.
I mean,
And maybe it's a little different if there's like 7 shots fired and we don't know exactly which bullet was the one that did the damage, although an ME usually can clear that up. But he intentionally made a turn to steer towards the channel marker versus, well, maybe he just didn't see it and didn't know anything at all. That's 2 different mindsets.
It totally. And there's 10 other ways that we can think about what happened. You know, I mean, like we were talking about days ago. I mean, maybe his wife hands him the phone, her phone, says, look at this cute video, or I sent you this video, see if you can get it out for me. It's like pissing me off, trying to send it to all the moms. It's so adorable. And he takes his eyes off the water. I mean, who knows? I don't know. What do you need?
Do you want me to take over so you can deal with your phone?
Oh, they muted. They muted. But I love this, and I'll wait either till Bob or Ali come back to make sure they see it as well. But I love this. Hello, hello is saying, I would love to see Ali and Laura in court. Fight, 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 fight. Ali would give Laura a run for her money. I would definitely watch that. I would definitely watch that. Like, wholeheartedly. Running to watch it with you guys. Hopefully with a live chat. You see this one, Bob?
Which one?
Look at the super. It's such a good idea.
Oh, yeah. Oh, yeah. That would be good. That'd be fun. I mean, Ali would bury Laura. That's what my opinion is. Like, Laura wasn't some phenomenal prosecutor in there. I found her, like, frankly, grating. Like, she bugged me. Like, it just... I never want a prosecutor to come off as if it's like some kind of personal vendetta. And I just had that feeling the entire trial. Like it just felt like a highly personal case to her, which is improper. That's not what we need from prosecutors in this country, is them taking up, you know, personal vendettas for families, you know, on their behalf, especially in a case like this. Like she was so venomous towards him, the way that she came off. It's like people on Twitter or X are like, "Oh, he reminds me of Murdoch." I'm like, "What? What are you talking about?" I'm like, "This guy
It's
is
just
in
the
like
money
no way, shape,
factor.
or fine." Like it. No, they're talking about the emotion shit, and like people are like, "Oh, he's just fake." I'm like, you don't think that this guy who's had these kids in his life for the past 15 years, in and out of their house, eating dinner, spending the, sleepover, all the shit that comes along with being a parent and having, being a girl dad. I have a lot of daughters. I've had like a lot of kids like in and out of my house for the last 15 years in this neighborhood that we've lived in for 20. And I know all these people. I know their parents. We're tight with a ton of the parents. The kids that Scout plays softball with, I'm tight with the parents. It's like to think that this guy is faking everything that he's feeling at this trial when his life is hanging in the balance. Now, like, it's not a death penalty case, but I'm saying if he's doing serious time, his life is done. Everything that he's ever known is done, and for people to be so skeptical, I guess that's just what our society has become. Like nobody thinks that anybody can genuinely feel bad. If they're a defendant in this country, it's insane. I don't get it. Like people are just, I don't know, very, very skeptical, pessimistic. They just don't think that like this guy who his lawyer put it best. I mean, he was just a dad who was trying to have a nice day. Like I have somebody in the chat who's, for all intents and purposes, a very intelligent person is like talking about how like George turned him into a creep. Like he wanted to look at the girls in the bikinis. I'm like, okay, it's Miami. It's an 18-year-old girl's birthday and they're out on a boat. I don't think that this was some big plan for George to be able
The
to
state didn't even
ogle.
argue that.
George was he couldn't keep his eyes on the water because all the girls in the bikini. I mean, maybe that's true. I don't know, but it's weird to me. I just, and it's probably again because Ali and I are, we've been on the defense side of things forever, and we're used to dealing with these human beings that are charged with these crimes, and some of them have committed them, some of them haven't, but you're seeing the other side of it. There's always a story behind what happened. There's always typically a reason, unless you've got somebody who's just a sociopath. There's typically a greater story behind it, that's worth knowing. That's part of what we do when we're trying to plead somebody out. We're like, hey, they have strong evidence. There's no point in going to trial here. You're not going to win. And
Well, he knew the minimum range that the state would accept and went to trial anyway. Oh, Bob left us. Okay, guys, so there is a widget on the screen. It's a way to do joint polls across both of the channels since we're co-streaming. But you have to either type a 1 or a 2 in the chat, and only a 1 or only a 2. If you put other words in the chat, the poll won't scrape your answer and count it. And it'll only count your vote one time. So do you think this was just an accident or that it rises to culpable negligence? Type 1 and just 1 for accident. Type 2 for culpable negligence. And I should say it's the number, not like spelling out O-N-E or T-W-O. So there we go. That will let us have a hybrid poll across the chat.
Abby, we are in fact on Verdict Watch. They went back. Kat started the clock at 5 Eastern, so we're about 52 minutes in. So
Yep.
Yeah. I don't know. What do you think it's going to be? You think it's going to be quick?
I think they'll have a verdict by tonight, because I think they can stay at least until 8:30, which will give them 3.5 hours, and
Yeah.
I think they could come back.
I think that there could be some issues.
Confusion over the instructions. I think we'll have a question. I definitely think we'll have a question. I'd be surprised if we don't have a question.
Yeah. Yeah, exactly. DB says, and they all saw you hit that dock, Bob, and they accepted it and still appreciate it. Exactly. My boatmanship was phenomenal that day. Could have been so much worse, but for my excellent boatmanship. Oh, good times. Those good times.
Yeah, I
I'll
feel
tell
like
you
a lot
what.
of Florida cases are late. Like, we just stay late. We have the Black Swan. Ashley Benefield was late. Alicia Andrews was late. Sarah Boone. I didn't remember the time, but I trust you that it was 10 to 11 p.m. Like, that's just part of being an East Coaster too, right? Like, we have to start our days early, but then we also stay open for West Coast time. I think we're just used to it. So, deliberate late here. Also, you have Mima, fellow cat, says her attack of witnesses was so gross. What did you catch that where she had I don't know if you're looking at the screen, but Laura Adams had the poster board where she listed all of the witnesses and she had them in categories. And so she went through like, oh, we have all of these law enforcement witnesses, which kind of gets into the defense's prior objection of the cumulative nature of some of the law enforcement officers being called to opine on the same thing, without really introducing anything new. Just, do you think this is a violation? What's reasonable to drive this way? Then went through the witnesses of, well, and at some point she constrained. She was like, and the witnesses who said they didn't notice, that were on the boat during the time, because she didn't want to acknowledge in the immediate aftermath the first responders and FWC, the investigating agency, didn't see signs of impairment that would make them go get a warrant or conclude that alcohol played a factor in this accident. She constrained it down to the witnesses that were present on the boat at the time of the accident. They said they didn't see anything, but are they good judges if they themselves were drinking? Right? And I understand why she's making that argument, but to me, it was very selective about how she had to make that argument. Bob is leaving us again. Thank you, Mima Cat.
Sorry, Allie's bringing back, or she's going to pick up Scarlett's gift, which was a new phone, but trading my old phone in, and I'm like, whatever, I'm dealing with shit with it still. I'm not comfortable wiping it because I have to make sure everything transferred over because, sometimes that's a thing.
I hate changing phones for that
It's
reason.
like it's a total pain. Like, cause it's not like magic. It's like half my apps aren't installed and I don't know, whatever. Um, yeah, I did see that. I just didn't like any of her game. You know what I mean? Like I didn't like her case. I think it was a shitty case to bring. And I'm standing by this. I think she's criminalizing negligence. I think this is a case that is a civil case. And as a matter of
The
fact,
chat
it's
wants you to
been,
talk about the rope.
oh my God. I just thought that the rope analogy was so stupid. I couldn't even she's like, oh, well, one thread might not that be might not be that strong, but when you put all the threads together, it becomes very strong. I'm like, but your threads don't have anything to do with the actual issue that's being decided by
But
the
she
jury.
said all her evidence makes a strong rope because she put in 100 pieces of evidence.
Yeah.
And I thought she'd go the other way with the rope metaphor. I thought we were going to get a Swiss cheese type of, you can make a mistake and it might not cause an accident. It might not rise to the level of criminal culpability, just like a rope with many threads. But as a rope starts to fray, as one thread starts to unravel, the rope could still be strong. But if another thread is coming loose, and another thread is coming loose, and another thread is coming loose, now that rope is like basically disintegrating. It's unraveling. So when you fail to do one thing, you might say, okay, that's an accident. But when you're doing and then lay out all of your bullet points again and say the rope comes undone. I thought that's where she was going to go with this rope thing. I didn't think she was going to bring this out. And she sure enough did, to say, this is how strong our case is.
I knew that's exactly what she was doing. Like, but I didn't think, like, you were the more optimistic of the two. I was all about, like, she's doing this to talk about how strong her evidence is. That one thing individually is not strong enough, but the culminated, it's what I keep saying. She's doing the totality of the circumstances, like evidence in a case wherein, again, what happens after the fact and what happens before the fact doesn't matter. None of that matters. Whether or not he supplied the girls with booze doesn't matter. I mean, but like in terms of building an emotion driven verdict that you're hoping for, it matters to her because it makes him look like a shitbag. It's like, oh, this guy, he's got a bunch of 17-year-olds on his boat, and one of them had like 10 Trulies. She was pounding Trulies. Kids were shit faced. It's like it makes him look like he's a negligent person in general. That he's not being the kind of parent that one would expect in that type of situation. She's like putting in things to force people to become judgmental as to him personally, as opposed to focusing on the issue at hand. And the issue at hand, the problem for the state is they have no idea what happened in that 9 seconds as to why he took his eye off the pylon or the thing, because he either didn't see it. I mean, I have to believe that he didn't see it in the time that it took for him to notice it and then have not enough time to react. Like I don't think it was ever like, oh, like it's what I keep saying. If you strip away everything, including the channel marker, and you just look at the fact that he's got 10 girls on the boat. I disagree with Brooklyn, who keeps saying that 45 miles on it. This was almost placid water. There were no other boats out there. Like 45 is not some crazy speed. I've been on boats. Anybody who's been on boats, I mean, is your hair blowing back? Yes, of course. You're going 45 miles an hour, but 45 miles an hour is 45 miles an hour, whether you're on a boat or in a car. It's the same speed. Always. It's like that old thing. Well, if I drop a a pound of rocks and I drop a pound of feathers, which one's going to hit the ground first? They're going to hit the ground at the
It's a
same
mind
time because
trick.
they're a pound. Yeah. I mean, it's just, it's not an unreasonable speed. It's not an unreasonable speed, period. End of conversation. But as far as if he doesn't hit the marker, what about, and they get to where they were going safely, what was criminal about his activity? And I'm talking about the driving of the boat, not the buying of the alcohol for the kids. That's a different thing. She could have charged him with that. She elected not to for reasons unknown. I don't know why. Certainly could have.
I would have
She could
liked
have
to see
added on.
Borscht. I would like to see Borscht do this case, or any other prosecutor, because I think this could have been prosecuted with like a neutral tone, and sure, you would lose the impact, and that's why we are up here griping. It might seem like it's, oh, we're pro defense, but you are not supposed to consider sympathy when you're on the jury. And people are human, right? We know that people are human. So the idea to make it a strategy of your case to weaponize sympathy for the victim and the tragedy that occurred to secure a verdict is just problematic. It's not supposed to be what happens.
For
And
sure.
I think Laura Adams, whatever witness that Borscht was questioning, that she took over on redirect, it's like she felt like it wasn't, oh, and could you tell us a little bit more about that? And you weren't driving drunk with precious cargo on your ship, were you? Like, she didn't like that Borscht wasn't doing that.
Yeah, I mean, have you ever seen him in action though? Like in any other cases, have you seen him try anything?
Oh,
Yeah, I mean, I'm just curious as to whether or not he would have been more effective. I mean, we'll find out, you know. I mean, if the jury comes back with a guilty verdict, then, you know, she's going to be walking around peacocking, pulling that shit on every case. I mean, I've never seen Laura Adams try another case. Maybe that's her style in general. To me, she just gave up, you know, these vibes that she was personally engaged with this case in a way that's improper for a prosecutor. Yeah, I like that was how I felt about it. It's like I couldn't feel any other way. And it was just strange. It kind of reminded me of when I got super deep into the like my Gacy season. I started doing all the research about this one particular cop that was like obsessed with Gacy, and Gacy was a monster. He was right about Gacy, but the fact of the matter is that he created this relationship, developed it with Peace's mother, not in any kind of sexual way, but just like this like thing where he's going to their house every night and updating her. It was just improper, something that you don't see cops do ever, right? It's like, if anything, families are always complaining the cops aren't telling them enough. And like this guy was just so obsessed with this case, it took on a personal tone, which ultimately ended up in the dude like fabricating the evidence to get Casey. It's like insane. It's like totally insane. You know, it's like I called his wife when I uncovered it, and she was like in Arizona on vacation. Cousin Zach's dad, and I'm like, you know what your husband did? And he's like, I am not trying to besmirch his character, or his integrity, or his honor, or his career, or any of that. But I mean, I'm going to report what I uncovered, you know. And she was like, oh, well, she's like, I typed out that evidence log. I'm like, I know. You wrote about it in your book that you helped him type, you know. And it was just like, that's what she reminds me of. Like somebody who is just improperly engaged with somebody that they're representing in some capacity. No, his daughter didn't testify.
all right. So Tiff has been trying to give you a message here.
I'm with Bob. Adams wants a relationship with the jury, but nope. Ick. Thank you for doubling down on that as well. I appreciate that. I appreciate it. It's like Tiff
Thank
and
you for
I
hanging
are,
on the screen.
yeah, locked arms on the usage of ick. So I feel
And then you've
bad.
got hello asking, have you pissed? Who pissed in the Wheaties? Who pissed in the Wheaties?
George, apparently. George took a big old dump in her Wheaties, and she's super pissed about it. It's like that thing where she kept trying to distance herself from the fact that she was trying an emotional case, like holding up Lucy's photograph when she's like, if you guys do anything in terms of deliberating using your emotions back in that room, this beautiful young lady, we're besmirching her memory, because it was so disingenuous. It was like a cheap carny trick. Like her standing in front of them saying, whatever you do, you're doing a disservice to Lucy by going back there and not finding George guilty only on the law, but having your emotions play a part in it while she's holding up the picture is like the shittiest thing that I can imagine a prosecutor doing. It's like that woman just never stopped with the photograph of Lucy. And I don't know why, to be honest, I don't know why Howard wasn't objecting. Like, how many times does this woman have to hold up the photograph? Like, what was your count? Like on that case, if you had to put
I
an
wasn't
over and
counting.
under, but give me an over under guess. I'd say it was over 40 times.
47.
I like your number. I like your
Yeah.
number. I bet your number's spot on. All right, if somebody's got
secretly
nothing
counting.
to do. Yeah. All right, let me see where my poll's at. So your impromptu poll was a landslide with 1. So we've got
Well, but to be fair,
400
people might, and I don't want anybody to feel this way. I'm just saying I understand it. It might be a reason. People might not want to vote out loud. It's different than a YouTube poll, right? With a YouTube poll,
Totally.
you can press a button and nobody knows what you're voting unless you tell the chat what you were voting. Whereas with this, if maybe a lot of people don't want to vote for the option that's currently sitting at 6% out loud in public. So I don't want people to feel that way. I'm just saying I think like it could be a factor.
I think no one should feel that way. If you're of the 6%, I think you should be loud and proud. I mean, you're allowed your opinion no matter what. That's just the way it is. We're dead even on our poll, 50-50 with 440 votes in. Like literally 50-50. Like on the
head
nose.
walked by on the stream. I don't know if that means anything.
We got to keep an eye
on.
I'll keep an eye on Kathy's Twitter feed. She's usually pretty good if there's something going down.
Okay, no more movement. But it just looked like the way they were walking past the camera, like there's that room behind the jury bench. So that's why I was wondering. And I'm also nervous, like I'm looking at the video, but like if it freezes, I won't know if there's activity. Because I still don't have, I can't believe it. I can. Because Spectrum, their estimates on restoration never seem to be close to the right time. But still no internet restored here. Really sucks.
Oh, is that that's the StreamYard poll, yeah? I forgot we can do that now.
Yeah, it's just the way to bring the polls together across the screens with the shared chat. I don't know. Hello says, serious question. Did Laura lose a child and is taking this personal?
No idea. No idea. I mean, I think what it really boils down to is you just have these prosecutors that on occasion, they take on a cause. And at some point, Laura got it in her mind that he needed to be tried criminally, whether that was after a lot of communication with the Fernandez family, who was insistent, that they felt that he should be held responsible, criminally speaking. And, we saw Katt put up the chats between Laura and her boss, where her boss is like, you know what? I ain't feeling you. And then they had some kind of conversation. It seems like there was maybe a phone call. And then there was this final thing. And she's like, well, I appreciate you fleshing it out for me. But then Laura leaves the office. So there's this gap in time that it's a weird
Well,
case.
I don't think she left. I think she probably put in her resignation, still had her off-ramp time period where, 30 days and then I'm officially leaving, 40 days, 60 days, 90 days, whatever. And she rescinded her resignation before she actually off-ramped.
Yeah, but she checked out
So,
mentally. You know what I mean? She might not have
yeah,
physically
but
left.
I really think it's possible that people can do those types of things as a stunt. They can do that as a way to manipulate somebody into giving them what they want. The idea of like, think of a couple who's arguing and one of the people decides, all right, I'm going to storm out of the house and see if they follow after me. Not because I really want to leave, but because I just want to see if they're going to chase after me. I mean, that type of dynamic it's not just something that happens in an intimate relationship between intimate partners. It's something that can happen with friends. It's something that can happen in professional settings. Like, and I think there's a very good chance that it was a manipulation tactic to try to push her office to get on board with charging this case the way she wanted to charge it.
There's no question. That's exactly what it was. I don't see what else it could have been. It was her trying to flex. I mean, she's the probably the top felony prosecutor in that office, aside from the elected prosecuting attorney, but I don't even know. Like, sometimes you'll get people elected as prosecutors have never tried a case as a prosecutor. Facts. I mean, it happens. So whoever got elected in, whoever that woman was that she was texting with, I don't know what her background is, but I think that based on what you were telling me, Laura was the top felony prosecutor in the office. And, this is a case that she had taken under her wing and for whatever reason was adamant about taking the shot here. Because like I was saying, to me, it's not that far removed from what was going on with the cases with school shootings, where they really are trying to stretch out a statute to fit in a way that it typically doesn't fit.
To make someone like a guardian that's letting a child come to harm through negligence with the warping of what it means to be negligent as a guardian.
Right. And it was.
And I don't know Laura Adams' background. I just know she's been there 30 years. So I don't know like if she has accolades or anything like that. I just know she's tenured. She's been there 30 years, which is quite a long time.
It's long in the tooth to stay in the prosecutor's office. It's I always wonder about lifelong prosecutors or public defenders for that matter. It's like, are they just truly dedicated public servants? And that's what they want to do with it for their whole career. Because it's like neither side makes any kind of real money. Like, you're in there with the grind. It's not to say that she doesn't make a comfortable living, but in comparison to what you can make in the private sector, it's always a little bit strange to me. Like, I've seen, it's not as strange as when I've seen people come in late in their careers, but usually when they do that, they're wanting to effectuate some kind of change. If you have a lawyer that is 20 years in, they're like, you know what, I'm going to go to the public defender's office, or I'm going to go to the prosecutor's office because I want to try to do good. It's like my concept is the only way I'd ever become a prosecutor is to try to get in there and change shit. Like, that would be my entire purpose. Like, I try to teach.
Funny thing about this specific office, the Miami-Dade State Attorney's Office, they hired someone to come in and be in charge of ethics. And then Miami Herald did an expose on him because of some literature that he wrote, fictional. And he was fired from the position before he really got started. And it's been an ongoing saga. A whole ongoing saga with this district attorney's office. So they almost had an ethics person, and then they did not.
Yeah. I mean,
And then Kathy says, did they start with misdemeanor? Yep, they started with misdemeanor charges, and then the family started doing Katy Puig. I think it was her family members started speaking with the media and expressing concerns that they don't think that FWC, the lead investigating agency, did a good job trying to investigate if things like alcohol were involved here. And that media coverage raised the attention of some guy named Matthew Smiley, who we didn't see called at trial, but he came forward over 2 years later to give, well, his deposition was like 2 years, 3 months ish later, I think. He might have like raised his hand and it took a few months to do the deposition. But at some point in 2024 or late 2024, because of this coverage, this guy, Matthew Smiley, who was a firefighter that helped show up at some point during this aftermath, wanted to speak to the prosecution team and would ultimately give a statement that he observed bloodshot eyes and could smell alcohol on George Pino's breath when he was speaking. So we get that. That's the only like new thing that comes forward. And we get this vessel homicide charge. And then at some point it's going to upgrade to the manslaughter by culpable negligence, tack on the extra. And again, I believe the reason for doing that was maybe to increase the exposure and hope that someone will just take a plea deal. But we
Yeah.
took it all the way to trial, which is always a gamble.
and oddly
and
enough,
then Matthew
that person
Smiley's
was
never
not
called.
Right.
Nope,
That's
never called.
pretty weird.
So-
Pretty weird. Good old Matthew Smiley. Why wasn't he called? Can you come up with any reasons why? Probably the impetus for the felony charges wasn't even called. Is it because she didn't go for the BUI? I don't know. Maybe. I don't know. I mean, are you aware of any motion in limine to keep him from testifying?
Yes, but there's no order relating to it, and no hearing was broadcast. So I don't actually know if it was, a defense motion in limine was granted, or if it wasn't granted, but something just didn't play out.
Yeah.
So,
Yeah. It's
and I
interesting.
don't know, not for nothing. I don't think it would be a good look, but prosecutors do it all the time. The things that I don't think are a good look, calling somebody years later to just say like, hey, I never came forward, but I promise this is what I was saying back then. Like, if you're also a firefighter, you should have made sure you got your statement to somebody right away.
Yeah.
And it was a high profile case. So if you consider, if it's not like you only should have seen the coverage of this case if you live in this area 2 years later, when the family was, in my opinion, advocating for higher charges to be brought. And you had a prosecutor that was friendly to it if they could get their boss on board. To me, it seems like that was the impetus for someone coming forward, not, hey, I've never heard about this case before, even though I responded to it and never saw any other coverage, and then just realized 2 years later that nobody ever questioned me.
It's
It
weird.
just seems odd.
It seems super
So
odd.
maybe that was a risk they weighed.
And
calling him.
hello sent another $5. She said, no offense or nothing against you all, but can you ask Ali my question later about Laura? Are you talking about which one that you want to see Ali and Laura in court? That's more of a statement. But you did ask, is your question the one that you wanted us to ask Ali? Is they didn't go by the new instructions they already argued before it went to the jury. Can they object to the judge? Is that the one that you want? Hello? I'm assuming that's the one you want, because the other one's more like you'd like to see Ali and Laura in there with the gloves off, throwing hammers. That's more of a statement as opposed to a question. But I'll ask her. I'll make sure to ask her that question. I'm assuming you're talking about the definition of reasonable doubt, how it's changed. Is that what she's referring to? The fact that they've changed it as of June 12th, how the definition of reasonable doubt is defined. Is that what you think she's talking about, Kat? All right, so Lynn, Lynn, a love shot.
Ask Ali all the questions.
ask her all the questions. In my opinion, they need to hold the parents as well. They knew the girls were drinking. They are just as culpable as to it as he is, which I don't think he is. Yeah, I mean, I'm pretty clear on the whole drinking thing. It didn't have jack shit to do with what happened with him hitting the channel marker. Just didn't. You know, like to me, that's just a character assassination move to try to make him look like a shitbag. You know, like it has nothing to do with what happened. You know, it'd be one thing if the girls were all hammered, standing, falling all over the place. I mean, maybe
Like
then,
hanging on his shoulder while he's holding the steering wheel.
yeah, just doing all kinds of crazy shit, but it didn't appear that that's at all what was going on that boat. So, yeah, I don't know. I don't know.
And then Hello
Let's
Hello
see.
said it was the question about having a family member.
Oh, oh. I mean, Allie's not going to know, but if you want her to opine on it, I'll certainly ask her. Definitely. Slag Daddy said 2 weeks ago, a boat struck a channel marker in the Cutter Bank channel where an 8-year-old was ejected. No charges. Interesting.
No charges yet.
Interesting. Yeah, it depends on how this one goes.
I
Was
thought
the
it was really
8-year-old
enlightening to see those stats on how many like channel marker collisions, whatever happen annually, and half of them happen during the daytime. It's not like, oh, the totality of this are nighttime. You know, it didn't seem like the majority of those accidents could be explained by it was daytime and the only answer was alcohol. Or like some like depravity that someone was pulling a prank and hot dogging. So I thought those stats were really illuminating that we looked at maybe on day 7.
I like the way that you really adopted hot dogging into your lexicon now. Now you didn't
Gotta,
know what it was,
gotta.
and now it's like part of your fiber. Were you out there hot dogging? I
4th of
see you
July
just
is gonna be so
asking
fun.
people. Oh my God. Were you just are you out there hot dogging right now? What are you doing? Why are you hot dogging? They'd be like, what? What do you mean?
But yeah, I
Who
thought those
doesn't love
stats were
a good hot
enlightening, but of
dog?
course they don't come in a trial, right? You just call like 3 law enforcement officers to tell you that they think what George was doing, although they have to distance themselves from making that conclusion and say something like, somebody doing that thing would be unreasonable. It would be negligent. It would be a violation. Well, do you write tickets for those violations? No. Like, just a whole mess to me of, you know, I think we got the picture that they don't seem to try to enforce anything that would promote safety on these waterways. There's all these channel markers that need repair that aren't being repaired. Channel markers that are missing the signage that would make them visible, and they're not fixing it to put signage back up on these channel markers. We're hearing law enforcement testify that we don't write violations when we see somebody going too fast on the waterway. We don't do that here. Like, why not? Why not?
I still stand by this whole like why are they having these things like immovable objects? Like I just don't understand that. You know, like why are the channel markers like these concrete immovable metal poles that like it seems like there's a way that you could do something that can indicate, look, here's where the channel is, and it's not something that if somebody hits it, it can end up like this. It's like you were saying, like a buoy. Like buoys move. It's like you can probably make it with a tight enough chain to where it's going to only have so much of a radius to which way it can float, but it's not immovable. You know what I'm
Yeah, it has
saying?
some
It's like,
slack to make the physics less dangerous.
and beyond that, I think that Howard made a very good point. Like if there are these statistics that exist about the number of channel markers that have been struck, why isn't there a speed limit in there? Like just put it in there, stick it in there. I don't get that. If it's an issue, if they're concerned about people's speed and it's a known hazard, then why aren't you posting some kind of speed limit? It's that's strange to me. that they haven't done that.
Can you
'Cause
talk
it's an
about
ongoing problem.
the importance of voir dire and things that would make somebody, not a candidate for sitting on a jury, things that would get somebody stricken for cause? Well, let's
Well,
use the example of it's a domestic violence case.
oh,
Could
I
somebody
mean,
who lost somebody to a domestic violence incident, would they likely make it on a jury, or could they be stricken for cause?
well, they should be stricken for cause if they're honest. I mean, those are the questions that usually are if we know what kind of case it is when they send out the jury questionnaires. And in Illinois, our jury questionnaires are pretty basic. And we're certainly always going to be allowed to discuss without indoctrinating the jury in terms of what the facts of the specific case is. We can always ask what the charge is, if that's going to be something that they're not going to be able to put aside their bias, because either it's something that they've had affect them personally, or somebody that they care about personally, or a family member, whatever the case may be. um Voir dire, picking your jury, is the most important aspect of the entire trial. It's more important than anything else,
And it's not a
including
strategy, it's part of
it.
the system. It's built in to be that way.
Right. And it's like it's so important that it takes higher precedent to me than jury instructions, which are the second most important thing. It's everything revolves around that jury. Everything. Like we're doing our very best as attorneys trying to figure out who these people are a little bit, the best that we can. It's like it got easier for us in Illinois with the advent of social media, like because we don't get a list ahead of time. It's like there is no, oh, I can go ahead and do research for 3, 4 days leading into voir dire from who the pool is. Like we don't get a list of names to where I'm going on everybody's socials and looking and seeing what makes them tick. Are they parents? Do they have are they gainfully employed? What their education level is? Depending on the type of case it is, do I care if they're conservative or liberal? I mean, all those things, you're trying to get an idea of who these people are and how they think. And our most important question to them is always, at least in my estimation, and I think Ali would probably agree, is if you get back in that room, are you going to be able to stand your ground if it's 11 versus 1 or 5 versus 1 and you're the one? Or are you going to cave, to the will of the others? Because, you want people that are going to be able to stand their ground, that are not going to, which you kind of saw with the Karen Reed shit. Like when they were writing those notes, and those notes, when they came back to the judge, were pretty clear that people had their opinions and they were not budging on them. Period. End of conversation. It didn't matter how long they were going to stay back there. They were never ever going to move on their position, which is what you want. It's if you feel a certain way as a juror, then you feel a certain way. But back to your question, so yeah, voir dire is the most important aspect. And in terms of if you have somebody who admits to their bias, that it's going to affect their ability to be able to sit on that jury and put that bias aside and not have that affect their ability to be able to be a fair and impartial juror, then you're absolutely going for cause. And it's a judge by judge thing as to whether or not, because it's that rehabilitation thing that the judge does, where the judge will call the juror up,
And ask them
and
to say, like, can you
yeah,
hear all the evidence and then weigh the evidence and making your
yeah,
decision?
and can you follow the law? And if they say yes, I can follow the law, then the judge considers them to be rehabilitated. Then you have to use one of your challenges to get rid of them. When it's clear that that person's never going to not be biased. Like it's such a legal fiction, that rehabilitation of jurors. It's such a load of shit. I cannot stand it. And it's so unfair,
Well,
especially, I
and here
mean,
we
it
have a
will,
discharge of the alternates. So if someone's back there right now saying, like, I know my belief has been, and it's always been, that he was guilty, implying like a preconceived notion, which is something that you're not supposed to do. It's not how you're supposed to approach a trial, let alone deliberations. The judge has already discharged the alternates.
Mm. Yeah.
So,
Yeah.
which I think is risky, because you don't know if somebody's going to get back there and refuse to take part in deliberations.
Hello says, oh, and Bob, I'm Western Kentucky, right over the Ohio River. I would never visit Chicago. Sorry, but not sorry. I hate big city life. Yeah, that's kind of judging a book by its cover a little bit. A little bit. I think Chicago is probably the most spectacular big city that there is in the entire country. It's very livable. It's an amazing architectural city. You're kind of missing out a little bit. There's nothing to be afraid of. There's nothing to be afraid of. I mean, all big cities have crime in certain areas. I mean, you're never going to be, able to escape that in total. But in terms of the culture, the food, the architecture, it's a spectacular city. It really is, especially in the summer. It's just beautiful. It's a beautiful city. It's worth it. If you come in, I'll bring you on a guided tour. You just hit me up. I'll keep you safe. I'll keep you safe. You'll change your mind. It's a great, great city. Really is. But, some people just don't like the big city. There's definite charm to small towns. I love
There you
both.
go. Look how
Yeah.
deliberations work.
Thank you. Hello. See, I love that. I love that. Yeah. So did you do that?
Did I do what?
Did you do the Folio? Mavka says the Folio judge went off on how violent Chicago is today.
That's right when my internet died.
Oh, so you didn't get to
So
do
I got to see the allocutions from the defendants. Well, pretty much there were like 3 allocutions, and then one of the defendants just stayed in his chair when they asked him to speak and said, "I just want to say I love everybody," I think is what he said, or something to that effect. So he didn't really do an allocution. And then my internet cut out, like right as the state started making their arguments for like what they wanted to see. And again, the minimum they were facing is life without parole, and the maximum they were facing was life without parole. So as far as sentencing, not really that interesting. And I didn't get to hear her statements, so I have to watch those later.
Yeah,
So
I mean, as far as like most big cities, there's areas that are where most of the violent crime takes place, and Chicago's no exception. It's like you have the Austin neighborhood, which is on the far west side of the city. That's right on the border of the town that I grew up in, like literally the street, Austin Boulevard. I have Oak Park where I grew up, which was a very urban suburb. And then right across the street, you got Austin. So I grew up over there, like going to liquor stores when I was 18, getting booze for parties, for house parties, because they would sell to us, and then you got like parts of the South Side. That's kind of where most of the violence is. Like you're not getting it. And that's not to say that there's not like marauding bands of, criminals sometimes in the areas where, people are out and about enjoying a nice evening, dining or shopping. There's been some crime in those areas recently, but it's a
I can't
very
wait to
safe,
watch
clean
this.
town. What?
So Mafka
Which thing?
added more context, saying a witness said Jacksonville was like little Chicago, and then the judge started citing Chicago gang violence stats, like 100 plus homicides last year. So that's how it came up during the sentencing.
It was a hell of a lot more. It's like a hell of a lot more
Wait,
than 100.
they did kind of get into this when one of the Sean Gathright, one of the defendants' mothers, was speaking, but did she come back to it and go off more? Because it was kind of quick, the first part, before I lost internet, before the allocutions. Interesting. I've also got hello saying, I'll drive through, but with my man by my side, I'm antisocial. You know what I think? Living in a city is a lot more appealing to me now that I wouldn't be a commuter for work. Like,
What?
I'd rather live in a city or live far away. I wouldn't want to be a commuter that has to drive and get stuck in the traffic leaving to and from the city. That's my gripe about like populated areas.
The worst.
Just the-
It's
Getting
the
stuck in
worst.
traffic. I hate it.
Oh my God. It's the worst. It's like we moved whatever 38 miles west of the city. Like we're pretty rural out here. We're like past Naperville, past Aurora, which are western suburbs, like due west as the crow flies. And it's like living out here. There's parts that I hate, because I would have rather my kids grown up in a more kind of urban area, because I just feel like kids that grow up in not necessarily in the city, but especially in the city are just a little more street savvy than kids, like, because there's just nothing to do out here, which is good. It's safe. It's safe, but the traffic, girl, oh my God. It's like whenever I drive back into Oak Park, I'm in hell. Hell, it takes like hours to get from like the expressway to like the north side of the city. Like if we're going to visit my uncle and I'm taking like Harlem, which is kind of the main thoroughfare through Oak Park, and it goes all the way up to the northwest side of the city. And it's like, I just can't. It's so miserable. When I first moved back from Philly, when Ali and I were practicing out there, and I was commuting when we bought out here for the first year and a half. I was commuting to my father's office. We lost Kat, her internet, and it was just it took 2 hours no matter what. If I took the train down, it was an hour train ride with all the stops, and then getting to the train and getting from the train station to wherever I was going, if I was walking to the Daily Center or whatever courthouse I was going to, it was 2 hours. And then it was 2 hours in the car. So it was 4 hours a day, because it's 2 hours each way of just commuting. And it was just miserable. I mean, I did listen to, and this is like before podcasts. So I was like, it was like sports talk radio was like my big friend. That was what kept me occupied for all those hours. Peoria is little Chicago. Peoria doesn't have the highlights that Chicago has. That's the problem with it. Or are you talking about like crime rates? It's Peoria is definitely not Chicago. Let's see. I can't throw the comments up because those are under Kat's control. But Chantel Simmons says if Lucy was sober, she was, quote, stuck under the boat. How was she stuck? Couldn't she swim up, or would you think it's suicidal? I don't know. To me, it appeared when we got the evidence that she had the fiberglass embedded into her head, into her skull, it seemed clear to me that she was knocked out. I don't think that I think she was knocked unconscious at some point. That's a guess, but I mean, to hit your head hard enough to where the little fiberglass shards are stuck in your skull, it seems like she hit her head. Probably not too dissimilar from what happened to George. And I think Kat said that the ME did say that she had some injuries to the skull and to the head, but that they weren't calling blunt force trauma part of the cause of death. And I think there's an argument to be made if she was wearing a flotation device, like a life jacket, and she's kind of trapped under the boat. Doesn't that make it harder to get out from under? Maybe, potentially. I don't know. It's like I was talking about, like, seatbelts are good, but I can definitely think of certain situations wherein, like, if you're about to get T-boned and you're going to want to try, you see it coming and you can't move anywhere. So you're behind another car and somebody's about to T-bone you and you're trying to lean away from where the impact is going to take place, but you're belted in and you're trapped and you don't have enough time. I mean, that's a situation where seatbelt's probably not optimal. What's the question? Yeah, we're close to Elburn. We're very, very close to Elburn. That's the last stop on the metro. That is the last stop on the metro. Oh. Are we even live anymore? Wait, hold on. Tracy's calling me. Hey, what's up? Verdict? Oh my God. There's a verdict. Kat, if you're back there, there's a verdict. I don't know if I could pull it up. I don't know how Ali did that. What was the workaround? Kat, where are you? Oh my God. Oh my God, where's Ali? I don't know how to get this thing up. What was her workaround? Oh my God, I got to call Kat. Her internet's down. It's like always, it's the worst possible timing for. There's a verdict. Yes, there's a verdict. How did Ali get the thing up? What did she do? No. Yes. All right. Wait, she's back. Get up there. Get down there and pull it up. Cat's off. Yes, we need you right now. That was super fast. It's super, super fast. All right, but can Ali, if she's going to be on her computer, she's here. She's running down there now. She just got back. That is all right. Try to get back on. Try to get back on. All right, there she is. All right, bye. Wow. Fast verdict, huh?
He's reading it already.
What?
Yeah. It's obviously guilty.
I think it's not guilty.
No way.
That fast? I mean, it's easy to predict guilty. Guilty. He's guilty.
We're leaving this stream up. It's over. Right in the comments.
Please publish the verdict.
In the Circuit Court of the 11th Judicial Circuit in Miami-Dade County, Florida, State of Florida versus George P. Case number F24-22896. Judge Marisa Tinkerman. Verdict. We, the jury, find unanimously as follows. As to count one of the information, manslaughter of Lucy Fernandez, the defendant is not guilty.
Wow.
So say we all on this 22nd day, June 2026, signed by the foreperson, C.F. In the Circuit Court of the 11th Judicial Circuit in Miami-Dade County, Florida, State of Florida versus George Pino. Case number F24-22896. Judge Marisa Tinkerman. Verdict. We, the jury, find as follows. As to count two of the information, vessel homicide of Luciana Cristina Fernandez, the defendant is not guilty.
Oh my God!
22nd day of June 2026, signed by the foreperson, C.F.
I
Does
cannot.
counsel for either the state or the defense wish for the jury to be polled? Yes, Your Honor. Madam Clerk,
That is
please poll the jury with initials.
Yes. Lady and gentlemen of this jury, you heard me please the verdict. As I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no.
I can't believe it.
Mr. A.L. Initials A.L. Yes, sir.
Yes. More, y'all.
Initials C.F.
Exhausting.
C.S.
Yes.
L.M.
Yes.
J.M.
Yes.
and C.K.
Yes.
C.A.
No, I'm a, yes.
Judge
Oh, forget it.
Ladies and gentlemen, I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. I want to thank you all again for the sacrifices that you have made over the last 3 weeks, for your time and consideration in this case. What I have for each one of you is really just a token of our appreciation, which is a certificate of appreciation, and a small symbol of the great appreciation all of us have for you and for your participation in our system of justice. What I'm going to ask you to do is, as I discharge you, you will go with Renee, and Renee will take you out, and he will provide you with your juror certificate. All right? I'm going to ask everyone, please, in the courtroom to please remain in the courtroom for a few moments and allow the juries to exit. Thank you.
All right.
All right, I gotta go. I'm glad that I was able to be here for this. And every time a jury does something like this, it restores my faith in the system. Well done, jury. Well done.
Everyone, please remain in the courtroom. Be seated, thank you. For purposes of the record, there are no errors or omissions in the verdict form. And filling out the verdict form is legally sufficient. Mr. Pino, the jury was found not guilty as to both counts of the information in this case. Are there any other matters involving Mr. Pino
Not for the state.
for this court to address?
Not for the state.
Anything else? All right, there are no holes in Mr. Pino, is that correct?
Correct.
All right, ladies and gentlemen, if we would give the jury a few moments, please, to exit exiting the courtroom in the courthouse. And I want to thank everyone again for your respect for this court. We'll take a moment now, and I have no further matters for me to address, and at this time, we are in recess. Thank you.
Who's talking over there? All right. Well, that's all we're getting. I think the father's being a lawyer is probably why he's like on the other side, like so comfortable to walk around the courtroom and go, I don't know where they were actually going. Oh. They're like, oh, people want to see what's going on in Maybe that's fun. That was a girl. I was over All right, they shut it back off. All right, let's see what you guys are saying. So I'll start at the bottom. At for Dread says, it wouldn't have been no celebration if Laura Adams didn't make him out to be to be a scumbag narcissist. I mean, it's like, look, when the jury comes back in an hour 45, clearly I was still thinking it was going to be guilty, even on vessel homicide. And, I was certain they were going to be like kicking themselves for not requesting lesser included, any lesser includeds. So that's crazy too. I'm gonna leave this up in case, I don't know, there's some kind of, the state hates to give press conferences after they lose. But no, I hear you at for Dread for sure. And thanks for your generosity. Hello says, oh man, this hits hard. It really did. Ad for Dreaded the first time said, I just cried for George. Nothing he's done is fake, popular to contrary belief. Faith is restored. No, agreed. Agreed. Hello, said jury understood the mission and saw right through the prosecutor. Yeah, an hour 45? I mean, that is like insane. I just, I guess maybe sometimes 6 jurors works for you, you know, because that was really fast. I can't even believe it. Adford Dredd came back again. He said justice was served. Blame Laura Adams' stank ass, rude, condescending ways. Happy for George Pino. He's already punished daily. That's true. Music to my soul said, Allie to the rescue. Thank you, Allie. I mean, like I got off to do something with Scout. Then she was like, all right, let's do it tomorrow. And then I was like, all right, these two are just up there talking. No chance we're getting a verdict anytime soon. I just sit in front of the TV, start watching TV, and then all of a sudden I hear like all this ruckus. And I was like, what is that? And I didn't like, is that my phone? Why'd my phone just start making weird noises? And then I realized the judge is sitting there. So that was like literally, I mean, obviously you guys were there. Like we almost missed it. We almost missed it. And Kat, I think you're still in the chat. Jeannie says, thanks for all the great content, Kat. A member for 1 month. Happy Cat anniversary. Pokemon, member for 29 months, was like verdict. So that was 540. Yeah. So like less than an hour and 40. It was like an hour and 40 minutes. I mean, like, what? Maybe Megan said the same thing. Maybe Megan, maybe not. And I'm just surprised I didn't hear him call down to me. I think he thought I was gone, that I had left. So they were probably like freaking out. I was just staying quiet downstairs. And hello, said, sad thing is I work for Public Works. Sounds bad, but I am a heavy equipment operator and I have to talk to people. I can't ignore people. I mean, but people do suck for a lot of times. So I feel for you. Bab, there's a verdict, Brian says. Member for 25 months. Thanks for your continued support. Sharon, thanks for your continued support. Bob, verdict. And then I don't know if Bob read these or not, but Ritzy once said, and I think I remember Ritzy, I live in Chicago, in the city, not the burbs, would not recommend. I guess visiting is okay, but no longer a good place to live. It used to be. I have a pit bull that keeps me safe, though. Oh, well, sorry you feel that way. I don't know what part of the city you're in. Chantel Simmons says, if Lucy was sober, she was, quote, stuck under the boat. How was she stuck? She couldn't swim up or no, I think she was unconscious. So, I mean, that's what I think. Or I don't know if that was like a comment in response to something somebody said. So, but and then Bob left to take Scout to softball practice. My husband and his family are from Chicago now. They live in Wyoming. Thanks, Darcy. And it looks like that's it. It's such a useful thing that they do this like highlighting now. OG feisty cooter, member for 18 months. Kat definitely appreciates that. I believe in justice today. I mean, it's real. It's kind of crazy. Like, I mean, you guys were here. You know how we felt. We're like, there's just like, in a million years, I didn't think they proved their case, but I still thought a jury was going to come back guilty. Music to my soul says, I haven't followed this closely, but I still saw evidence of reasonable doubt. It seems likely the jury agreed that this was likely a horrible accident. George's reaction is making me emotional. I mean, it's just, it's such a like a shame. It's so horrible, and you know, it's like all these kids really went through it, and I'm sure it was hard for the Pino family, like the tremendous guilt of causing the death, like literally being responsible, not criminally, but still responsible for the death of, I mean, even just anyone you know, but someone whose family you know, who was a huge part of your family for whatever period of time that happened. Like it's so horrible for everybody, and I just don't know what the motivation was for upping the charge, because they probably could have gotten him guilty on just regular, like some sort of misdemeanor. I mean, he would have done 60 days if they charged him with what they charged him with the first time, you know? Um, yeah. Miss Priss, thank you for your continued support. Says it was fast, but they did it. Yeah, and I'm just saying it was fast. Like that's a big slap to the prosecutor's face. She's like, oh, uh-oh. Like I'm the only one that thought that this was, this is what was going on here. Sky Goddess, thanks for your continued support. I don't know if I said that already. Justice was served. Yes. I want outdoors. Thank you for your generosity. Kat, Allie, and Bob, thank you. There she is. Here she comes. Can we hear you, Kat? No. Kat's having let me see something. If you don't
Can you
know,
hear me?
now we can, yeah.
Okay, sorry, I have to have you on speaker because the headphones that would plug into my phone apparently don't want to work. I am so excited that I think the jury got it right.
All right, so let's go back and watch it because Mavhawk, and it was quick, says, Allie, can we rewatch the verdict with you? We were in a panic frenzied state the first time. Yeah, I'd like to see how the judge.
Carm week is officially over. The rest of us are back.
Bob watches.
Taking
whenever he's not doing. Whenever he's got his. All right, let me just pause it. And I can just go back to when the judge first comes in, because I wanted to see her face, like when she read it, if they showed it, like to herself.
Ladies and gentlemen, the jury has reached a verdict. I commend everyone for the way you all have conducted yourselves so appropriately and respectfully in this court. And I've respected that this is a court of law, and I'm going to ask you all to please, while this is going to be very difficult moments, to please dig down deep inside and please continue to maintain your composure to the best of your ability and to continue to honor and respect our justice system and this court. Thank you very much, everyone. I'm going to receive the verdict now. Thank you.
Point to the judge. Cameraman, judge. What else do you want to see right now?
Yeah, I agree. All right.
Got the prosecutor just cut off. Damn it.
Please be seated, thank you. Ladies and gentlemen, I understand the jury has reached a verdict, is that correct?
Yes.
All right, our foreperson, please hand the verdict form to Renee. Thank you.
Doesn't see it first? Come on.
And clerk, please publish the verdict.
In the Circuit Court of the 11th Judicial Circuit in Fort Miami, County, Florida, State of Florida versus George P. Case number F24-22896. Judge Marisa Fernandez. Verdict. We, the jury, find unanimously as follows. As to count one for information, manslaughter of Luciana Cristina Fernandez, the defendant is not guilty. So say we all on this 22nd day, June 2026, signed by the foreperson, C.F.
So I'm just going to say this. Do you see her over there writing? Like
Scribbling. She reminds me of Adrian Love.
She didn't skip a beat. I'm like, did somehow either she was like, oh shit, like she knew herself, or somehow she knew beforehand. To me, this is obviously just assumption.
When Bob called and said there was a verdict, I don't know if you heard me at speaker, but I'm like, it could be an acquittal. I think it was too fast to be a guilty verdict.
And I thought it was too fast to be.
So she probably knew by the speed.
I mean, all right, let's see.
In the Circuit Court of the 11th Judicial Circuit in Fort Miami-Dade County, Florida, State of Florida versus George Pino. Case number F24-22896. Judge Marisa Fernandez. Verdict. We, the jury, find as follows. As to count two of the information, vessel homicide of Luciana Cristina Fernandez, the defendant is not guilty. So carry on this 22nd day of June 2026, signed by the foreperson, C.F.
She folded her hands and sat up straight with her computer.
Or the defense wish the jury to be polled.
Yes.
Madam Clerk, please call the jury with initials.
Yes. Ladies and gentlemen of this jury, if you heard me, please be ready. As I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Mr. A.L. Initials A.L. Yes or no?
Yes.
Initials C.F. Yes. C.S.
Yes.
L.M.
Yes.
J.M.
Yes.
and C.A.
Yep.
C.A.
No, I'm a yes.
Yeah.
Ladies and gentlemen, I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order.
All right. Kat, you gone? Oh, she's muted again. There you go, Mavhawk. And Girl Ryan, new member. I feel like I recognize your name, so welcome. Family hug. Appreciate the support. Yeah, it was weird. She was just like writing the whole time. I don't know. You want me to? Do you guys want to keep watching? Oh. All right. Read the Venmos, Ali. read it. Oh, I opened up YouTube by accident. Let's see. Is Katt back? The last Venmo I see is 5:45. In rebuttal, oh, and I think we read that one already. Maybe. I don't see anything.
I have one from Janice who was asking, and I would love your opinion. We talked about it a bit earlier. Why would the judge discharge the jurors before they even began deliberating?
I mean, I thought it was crazy. We said, I think you and I talked about it when she first released them. Like, what if there was an issue? I'm keeping a lookout, Sarah. I'm just not seeing anything.
And thank you, Janice.
And that must just be the procedure in Florida, I would assume. Now, you said it happened again, another in that same courtroom where they did that. So maybe that's what they do. And then like once deliberations start, I don't know. Maybe it's just all on the Sarah, put it in the regular chat, whatever your question is. I'm watching. Oh, they were during closings. What? I thought that Bob got all those. Let me see. Let's see. Let me see. Oh, I do see. Okay, there might have been more. Objection, fuckface. Is that you? Is that the same Sarah? Yes, that was absolutely how I was feeling internally and externally. Bob did read that one. Because I remember it. And then there's another one from @Carol593. Oh, yeah. Please play the judge's response and bring back the chat. We read that one too. I was trying to tell you guys to do that too. They were deliberating an hour and
45.
an hour 40 max, because it was, when I look back at the chat, I'm trying to see if Sarah said anything else. Oh, and I'm gonna take this live just in case. Oh no, it ended. We know it ended, right?
I mean,
Yeah.
if attorneys speak, sometimes it'll be the local syndicates that do it because it won't be the still camera that's doing the feed for the court. So local 10, NBC 6.
So
I
how
think
do
it's WPLG. If you search George Pino trial, because usually the local syndicates will stay live on their feed and then just switch to an outside camera. So find someone that's live.
Local 10.
Now at noon, the George Pino trial wrapping up with closing arguments underway right now
Go
in
to their
Miami
channel
courtroom. The
and
real
see if
estate
they have a
CEO
live
accused of
video.
causing a boat.
Yeah, they might just be doing a recap.
Weather.
Some Milums. When you want the very best.
And I was going to say Publix, not Publix.
I'll check to see if I see anything else. Wow. So there's.
All right, guys. What do you think? What do you think the prosecution office that handles misdemeanors might be thinking about right now?
I mean, too late now.
We told you.
Yeah. Oh, wait, now this one says, is it live? Oh, wait. Oh, no. But this is the one we're watching, right? Wait, share this tab instead. Yeah, local 10. Huh. So I don't know. I don't see anybody that's actually like got anything outside the courthouse sitting there anyway. Still have closing arguments are underway. George Pino verdict. I'll try that.
How much do you think this case costs? Like with like the reenactments that the state did and
I mean, probably a lot. Probably. I couldn't even guess. I couldn't even guess. All right. Well, they just have like none of this stuff is live.
yeah, they might not be doing any. And it's also late. You know, people might have wanted to run home.
Yeah. I don't think it's still live. Right. Yeah. Yeah. Nope.
I think if I were in George's shoes, it would be very difficult for me to speak without just wanting to. I mean, I guess I would have like this bellowing feeling of like being grateful that the jury came back with an acquittal. But I think it'd be very hard for me not to complain about these charges being brought. And maybe he doesn't want to be that type of person that just goes out there and speaks badly on somebody else after he gets an acquittal.
Right.
They're interviewing everybody but George Pino.
How do you know?
Oh.
What makes you say that? What do you mean?
Oh, because what's on the screen? You still have the screen share up.
Oh. Yeah. Okay. Nothing.
Yeah, they're interviewing a bunch of people that aren't related to this case.
Yeah. Well, oh, I see over here. I was like, I thought you could see what I was doing.
Oh, no.
I'll just leave that there until, because I was looking elsewhere. See what you guys are saying. I Want Outdoor says, I want to see the text messages between Laura and the state's attorney now that the trial is over. Yeah, right? Oops.
Oh.
Ali, now you guys can start covering Rashawn Jones.
Oh, you guys will lose your minds over that trial. If you thought Laura Adams was a headache.
You've already said enough before that made me like, what the hell is going on? What the hell is going on? Well, we watched the oh, I thought I had that up. Just do we keep taking it down? There, not guilty. All counts.
Oh, I think because the comments replace it. Maybe I don't know how to. I could do it if I knew how to use StreamYard on mobile, but the scrolling banner, it should be the top banner all the way at the top of the pre-made banner selections if you want to just update the ticker.
Wait, why did it do that? Edit. Okay.
And think about like all the girls had to come down for this trial, and you know, what if Uptown Girls was a fond memory, but now they associate like a fond memory of a last moment with a loved and cherished friend, but now Uptown Girls reminds you of Laura Adams at the courthouse.
Right. I mean, probably. Yeah. I'm surprised that we don't have like a camera that's outside of the courthouse. That is strange. It's bizarre. There you go. You got that guy. Oh, it's Vinny.
It's Vinny.
How did he already
Graffiti
make
After
it
Dark.
to shocking decision?
No, it's old. I think just to not include lessers, right?
Probably. Yeah. All right. Well, that's all we got.
Yeah, sorry
So-
I'm useless with the research right now, but I appreciate you being like the hands-on solving all the problems today.
No, we're good. Yeah, we're good. Court TV has monopoly. Yeah, I don't know. There's nothing else. Right. So Waller says, I wish these were Rick Allen's jurors. Yeah, I'm with you. For sure. Miami Dottie says, Kat, love you, but no. If Laura's reputation, I'm really surprised at. Wait, Kat, love you, but now Laura's reputation, I'm really surprised at. But no, I don't know what that was actually starting with. So sorry.
Gotta look for the follow-up.
Yeah. Bluebell says, thank you, Allie, Kat, Bob, and Mods. Appreciate all your hard work. All right. So should we let the people go?
Let the people go. We need one more Bob. We who labor here.
We who labor here.
Seek only the truth.
Well, they sought the truth. Oh, she says that Laura has a great reputation. And like, I forget where else we heard that. Like we were watching something where locals were saying she does like all the high profile stuff and she only takes cases she knows she can win, or I don't know, something like that, the really important ones. And then, or maybe Bob and I had seen something and he was like, well, we know that's not true because she was texting her boss like, I need this case. She almost quit over not being given this case. If that's how you're supposed to read those texts. I wasn't sure how to read those texts. But,
Okay, I mean, if she has a great reputation, I mean, I feel like everybody has a moment in their life where they have a lapse of judgment, a moment of inattention. And, they don't see things the way maybe they should see them.
I see what you did there, Kat.
Yeah. But, I don't think being an attorney on either side of the aisle is an easy job. I think it might be a little bit more difficult to be a prosecutor that wants to do things the right way, and the victims, rightfully so, understandably so, might not understand how the process is supposed to play out and why prosecutors, police, investigators might not be able to just tell them everything, or, not something I would be good at.
Yeah. Ooh La La says, thanks, Kat, for putting this on my radar. All right.
Oh, well, thanks for hanging out for it.
Yeah, thanks for hanging out with us through all this. And I hope you guys had fun in Discord. You were desperately missed. Sharon says, thanks for everything, Kat.
Thank you to Sharon and the mods for holding it down across 2 channels.
Yes, thanks to all the mods, like Kat said, holding it down between 2 channels. It was you did the hard work. And then I don't know, what do you have coming tomorrow, Kat?
With my internet still not being up, I think I might just stare at a wall tomorrow and get it together. I can't believe that the internet went out today and we had a verdict when I had no internet.
You can catch up on Love Island.
Oh, maybe. You know what I just watched? I finally watched season 2 of Jury Duty, where they did the company retreat with the one actor. I mean, everyone's an actor except the one guy.
Right.
And I just finished that yesterday. Totally recommend it.
Not as good as the first one, I didn't think. Did you?
I thought it was for its own reasons, because there were so many little emergencies that they had to improv. I thought it was very cool from a production and broadcast standpoint, how to make a resort work. And guys, if you don't know what we're talking about, there's a show by the team that made The Office and another show, I forget, where they put together, the first season was a fake jury trial. But everybody was trained actors. They were all very good. It was over the top, but just enough to slide in the realm of possibility. Maybe because they did it in LA where crazy things can happen. But
And the one guy
juror didn't know that everybody else was acting, that it was a fake case, and that it was all like a reality show setup where he was basically the hero or supposed to be the hero. Incredibly insightful, interesting show. Great production, very funny, lots of entertainment value. And they did a second season with a different theme. And totally recommend checking that out. I think it was on Prime that I watched it.
I can't remember. I watched it when it came out. I don't think Bob was home when I watched it. But I can't remember what it was on. But yeah, that was definitely good. All right, so Kat's gonna have some time off tomorrow to catch up on whatever she wants to. And I don't know what we're doing yet. So I guess you'll have to just keep an eye out. But thank you guys all for being here with us. Kat, is there anything else you want to say?
No, looking forward to hanging out with you guys in the future on whatever you want to collab on with a live chat. The whole time.
Yes, for sure. All right, guys. Thanks again. We'll see you tomorrow. And then if I hit end stream, will it play your music or do your outro or?
It should just end it for both of us.
Okay.
I don't think there's an outro set.
Well, let me make sure I didn't miss a super. Nope, we're good. All right. Bye, guys.
See you guys.